Hello, yeah, it's apologies for the delay, but it says it's live now.
Thank you very much. Well, good afternoon, everybody, and sorry for the little wait. I'm Councillor David Fuller, Chair of the Planning Committee, and I want to welcome everyone to this virtual Planning Committee meeting. We are meeting virtually in response to limitations placed on the governance by the COVID-19 pandemic. This meeting is being broadcast to enable the press, the public to view this meeting. The officer will present the application, read out any written deputations received and confirm the recommendations for debate. To facilitate this meeting, I've exercised my discretion in accordance with the Constitution and suspended Standing Orders number 41A, and I'm allowing debate of items before the formal motion is made to this committee. Members are reminded to keep their videos on and indicate if they need to leave the proceedings at any point. So could you let me know? Members are requested to keep their microphones on mute and only turn them on when you're ready to speak. And obviously this will limit the amount of background noise. Officers are requested to turn their cameras on only when they are presenting their reports or answering any of the questions from members. Members who wish to speak in this debate, I'm sure you already know, could you use the chat facility and simply write RTS request to speak. Please do not use the chat facility for anything else. Officers will also use the chat function to advise me if they need to provide further advice to this committee. If there was technical difficulties or a need to take a confidential advice, we will endeavour to resolve this where necessary and possibly may have to have a brief adjournment. I will now explain the running order of this meeting. Members will declare any interest, receive an update on planning matters, agree the minutes on the previous meeting, and then determine each planning item. For each item, the planning officer will make a presentation of the application. Following on from the presentation, the officer will then read out any written deputations submitted in accordance with amended standing orders for deputations. Members will then be able to ask any questions, they will be able to make any comments and determine the application. So I would now like to invite members to introduce themselves. Can you please reply by stating your name and stating present or whether you are attending here as a full committee member or that they are here or they're present will be recorded of absent from this meeting. So I call upon my vice chair, I call upon Councillor Judith Smythe, please.
Councillor Judith Smythe, Vice Chair of this committee, present. Chair.
Thank you and welcome, Councillor. Call upon Councillor Matthew Atkins, please.
Councillor Matthew Atkins, permanent member of the committee, present, Lord Mayor.
Not Lord Mayor, I'm afraid.
Sorry,
that's all right.
It's
a force of habit. I call upon Councillor Chris Atwell.
Chris Atwell, present, Chair.
I call upon Councillor Lee Hunt, please.
Yeah, I'm here. Thank you, Lord Mayor, and most of the ward councillors. Nelson, which covers Stamshore, Tickner, Buckland and North End. Thank you.
Thank you. Welcome, Councillor. Call upon Councillor Donna Jones, please.
Thank you very much, Chair. Councillor Donna Jones, Conservative Group Leader, Hillsey Ward Councillor, permanent member, present.
Always get it right, I must admit. I call upon Councillor Terry Norton, please.
Thank you, Chair. Yes, Councillor Terry Norton, Conservative Councillor for Drayton and Farlington Ward, and I'm also a full-time member of this committee.
Thank you, Councillor. Councillor Lynn Stagg, please.
Can you hear me? Because my screen has gone blank. Okay, that's fine. Lynn Stagg, full-time member of the committee, present. Thank you.
Thank you very much, Councillor. Councillor Luke Stubbs, please.
Luke Stubbs, I'm a main member of the committee and I am present.
Welcome, Councillor. Councillor Claire Udy, please.
Councillor Claire Udy, present here, full member of the committee.
Thank you very much, councillors. I know there are other councillors here, and I know that I'll welcome them later on, but I know there are a few other councillors here. So now call upon and ask the officers to confirm that they are present as follows. Ezi El Caldo, Head of Development Management. Would you like to introduce yourself, Ezi, please?
Yes, Chair. Thank you very much. Ezi Keledo, present.
Thank you very much. Edward Chatwood Stapleton, and he's the Interim Development Management Team Leader.
Chair, thank you. Good afternoon, councillors. Yes, I'm here present.
Thank you very much. Adam Banting, please, the Development Management Team Leader.
Hi, Alan. Yeah, I'm here.
Thank you very much. Rebecca Altman, Principal Planning Officer.
Hello, yes, I'm present, Chair.
Thank you. Ike DiMano, Planning Officer.
Thank you, Chair. I'm present. Thank you.
Thank you. And for Planning Legal Advisor, we've got Kieran Lavin. Lavin, is that right? Yeah. Kieran. Would you like to introduce yourself, Kieran?
Kieran, you're on mute.
That's it.
Yes, I am. Afternoon, my name's Kieran Laven. I'm one of the council's planning solicitors. Thank you.
Thank you very much, Kieran, and thank you. Anna Martin, who's the Local Democracy Officer.
Yeah, Anna Martin, present, Local Democracy Officer.
Thank you very much. So now we'll swiftly move on to any minutes. Any apologies. Sorry. The first item on the agenda is apologies. So I'll now ask the Local Democracy Officer to confirm whether they've received any apologies for absent at all.
I haven't received any.
Thank you very much, Anna. So now we're moving on to declarations of interest. That completes the attendance records and part of the meeting. I now move on to item number 2, which is declarations of members' interests. Do any members here have any declarations that they would like to make? Please state both the type of interest and the nature of the interest. Any councillors at all? Please, if you could put that in the chat. No? Okay. There are no other declarations of interest. No? Okay then. So minutes of the previous meeting held on the 23rd of February, and I now move to item number 3 to consider the minutes. As I say, on the 23rd of February, the recommendation is that the minutes be approved as a correct record to be signed by me, the chair. Do I have a proposer for the recommendation, please? Can someone recommend that, please? Hands up. Anybody? Councillor Terry Norton proposed it. Councillor Judith Smythe seconded that one. Thank you very much, Councillor. So that's been approved and second. I'll now take a vote of the affirmation. Is there any dissent? Then it's passed. Are there any objections to this recommendation? No? Okay. Everyone happy? Okay, thank you. So the minutes of the meeting on the 23rd of February have therefore been approved. Thank you, members, for that. So now we're going on to minutes of the previous meeting held on the 9th of March. I now have to move to agenda item number 3 to consider the minutes of the meeting held on the 9th of March. The recommendation that the minutes be approved as a correct record and to be signed by the chair. So do I again have a proposal for the meeting held on the 9th of March, please? Anybody want to propose that for me? Councillor Lee Hunt, anybody want to propose that one?
Councillor Jones is waving a hand.
Oh, sorry, Councillor Jones, thank you. Didn't see you on there. Councillor Jones and Councillor Lee Hunt has seconded that, so thank you. So I'll now take a vote, and if there are no dissent, then that's been approved. So any objections to that at all, to the minutes? So the minutes on the 9th of March have therefore been approved. Thank you, members. So they've been fully approved. Okay, so now we're on to, we now move on to the next item, which is updates of planning applications. So, do you have any updates for members, please? Over to you.
Thank you, Chair. I definitely have a couple of updates on previous planning applications the Local Planning Authority has received. As at today, we have received 7 new appeals against decisions of the Local Planning Authority. We've not received any decisions, neither have we received of anyone that's yet to start. So if it's okay with members, I will just quickly go through the appeals that we've received so far. We received an appeal from 52 Coverack Way in Port Solent, and that's for a two-story side extension with extension of balcony, loft conversion, and changes to the carport. The second appeal received was for 168 to 170 Fawcett Road in Southsea, and that's for a change of use of ground floor to purposes falling from A3 to class A3 and /A5. We also received another appeal for 12 Blake Road, Drayton, in Farlington, Portsmouth, and that's for construction of extensions, front extension and part two-story and part single-story rear extensions. The fourth appeal received is for 143 Telephone Road in Southsea, and that's for a change of use from purposes falling within a C4 HMO to a HMO for more than 6, which is too generous. The fifth appeal is for 62 Middle Street in Southsea, and that's for an outline application for the construction of 4-story building comprising 21 number student accommodation units and ground floor commercial units following demolition of existing buildings, looking for principles of scale and access to be considered, and that was a resubmission of a previous application that was refused. The sixth appeal received is for 36 St. David's Road in Southsea, and that was for a proposed red dormer for a dwelling in a conservation area. And the last appeal received is for 36 Paynes Road in Southsea, and that's for change of use from purposes falling within a C4 HMO to a HMO for more than 7 persons and 7 bedrooms. That ends the previous updates. Thank you, Chair.
Thank you, Ezzy. Any members wish to ask any questions or anything just to Ezzy, just on those pure couple of points there? No? Yes, Councillor Judith Smythe, please.
Ezzy, the last application, the one of 36 Paynes Road, what were the grounds for refusal that we had previously agreed on that one?
Don't have it in front of me. I could put that up. If you give me 5 minutes, I should be able to put that up. Okay,
that's fine.
Okay. Councillor Matt Atkins, please.
The Blake Road appeal, was that one we gave permission to? I thought we gave permission to that. Is it the applicant appealing, or is it somebody else?
Is he?
I need to look at, I think probably non-determination, because maybe we've taken some time to get to the decision, and so they've appealed it. But I can look that up and confirm to members.
Okay. If you get
Ezzy, if you're happy for me to jump in, I think that's a neighbour. I think the application was for 14, wasn't it? And the appeal was from 12. Is that right?
Ezzy?
A neighbour couldn't appeal a decision.
Yeah, that's so. The number is the number right? Was 12 the right number?
Is it 12? I have on my records. Yes.
Councillor Luke Stubbs.
Yeah, just flowing on from a comment one of the other committee members has made. Are we getting a significant number of appeals on the grounds of non-determination at this time?
No, Councillor.
Okay. Okay, thank you very much. Okay, members, so Ezzy, if you could look back, and if we don't get time during the meeting, if you could feed back to the members that have asked those questions, that would be great. Thank you very much. So if that's the case then, so the planning officer will now present the first item for decision, and this is agenda item number 6. This is for St James's Hospital, Loxway Road, Southsea, PO4 8HW, and this is number 1800288. For the benefit of members of the public, this item is an unusual item because it relates to a single particular issue that is relevant to the planning application 1800288, namely wherever the 2 buildings, and that's Fair Oak and the Beeches, are Coulterage listed by association with the listed St James's Hospital building. So the committee is not here to considering the whole planning application today. So we will not be granting or refusing planning permission. Today the committee will consider only the Coulterage listing aspects because it has consequences of how the whole application will be assessed and brought to the committee, i.e. with or without the application for listed building consent for the demolition of Fair Oak and the beaches, together with the referred to as the villas. I hope I've said that correct. So Ezzy, you're going to, Head of Development, is going to present this application. I know that we also have some councillors here who will be doing as a deputation. So I want to welcome Councillor Ben Dowling, Councillor Will Purvis, if he's here, Councillor Darren Sanders, Councillor Jeanette Smith, and Councillor Gerald Vernon Jackson. Welcome, councillors. So Ezzy, I'm going to hand over to you, please, to present St James's, please, the villas. Thank you.
Thank you very much, Chair. I'll try to share my screen. Just one moment, I'll just put that up. Can everyone see the slide?
Yes.
Thank you. Thank you, Chair. Good afternoon, members. Presenting today the St James's Hospital, the curtilage listing issue with respect to the Fair Oaks House and the beaches, being the only item before members today for consideration. Just this slide shows the area view of the site in question. That's St James's Hospital Phase 1, which is just north of Loxway Road, and again north of Fair Oaks Road. The two villas in question, the Fair Oaks House and the beaches, are to the north and northwest of the site. The application was originally reported to the Planning Committee on the 20th of February 2019, with a consideration and decision deferred to allow the Council to seek further legal advice in relation to the question whether or not the Fair Oaks and the beaches should be deemed curtilage listed in association with the main St James's Hospital building, pursuant to Section 1, subsection 5 of the Planning, Listed Buildings and Conservation Areas Act 1990, which will be known going forward as the 1990 Act. Following resolution of this issue, the outline application itself will be reported back to the next available Planning Committee for determination. This slide shows the St James's Phase 1 site in a bit more context, setting out the different units within it. To the top left-hand side, which is to the northwest of the site, is the Fair Oaks, the U House, and the beaches. The photograph satellite imagery there shows further setting in terms of the vegetative boundary treatment of the different villas there. The slide shows the villas in question, in terms of the materials finish, standard materials finish, the design, and the scale of these villas. The top, on the northeast is the beaches, and on the northwest is the Fair Oaks House. And these are on the screen there. This slide shows the villas in question, the Fair Oaks and the beaches, looking at it from the south, and the imagery. Members would note the tree belt that surrounds the rear of the Fair Oaks, borders the southern gardens of the Fair Oaks, and also the beaches. This slide shows the beaches and the Fair Oaks House from the north. Looking again, one sees in context the tree line belt that borders the south gardens of the beaches and the Fair Oaks. And again, the access road coming in from the north. The chapel, as in the foreground, is independently listed and has of no bearing to the issue on hand today. This is a more recent photograph taken of the Fairview, which is from the north, seen from Woodlands Walk site. Again, with the break in the tree cover from the north of Woodland Walk. The fair view again from the north elevation behind can be seen from the vegetation bordering it and the Woodlands Walk. This is a photograph of the beaches looking west to the chapel, which again is independently listed in its own right, and grade 2, and that is the beaches again. Front to the Woodland Walk is the tree line cover that borders it and separates it from that access. This photograph shows the beaches looking southwest and the chapel being behind the vegetation out of sight to the right. And that again says the road, the Woodland Walk, as you approach the beaches. The slide here shows the St. James's Main Hospital building, which is shown to the northwest of the site, and it's grade 2 listed. And to the southeast, is the chapel, which again is independently listed in its own right as grade 2. South of the chapel is the villas, and to the southwest of the chapel is the Fair Oaks, and the beaches is to the southeast of the chapel. The slide shows the buildings to be demolished and the extent of the demolition work that is being proposed. That ends the presentation.
Thank you very much.
Yeah.
Are we good to sorry, Chair. That just in presentation, I just need to kind of give a bit of commentary to the presentation done, just to give a bit of background to it, if that's okay. Yeah.
Thank you. There are two legal tests that apply, and notwithstanding the recent Court of Appeal judgment of the 18th of March. Respectfully, we wish to draw members' attention to the Court of Appeal judgment that's contained within the appendix of the report that's been published on the system. I would also wish to draw members' attention to the SMART, which we published, which, if with due respect, if I can read that out for the members of the public who might be listening.
Yes, please.
Thank you, Chair. Committee members' attention is drawn to the QC's latest opinion, and it's attached to the appendix A below of the SMART, which forms part of the SMART for this item, and the report should be read in light of the updated opinion. In terms of any amendment to the report following that judgment and the QC's opinion subsequently received, this will be limited to noting a minor change as below. On page 24, heading 7, first paragraph and first sentence, case law established that to fall within the curtilage of a listed building for the purposes of Section 1, subsection 5 of the 1990 Act, the alleged structure must form part and parcel with the listed building. The recommendation that the villas are not curtilage listed pursuant to Section 1, subsection 5 of the Planning and Listed Building Conservation Areas Act remains unchanged. That's the end of the SMART. I shall then go forward to say that members that the recommendation before members today from the local planning authority is that the villas are not considered to be curtilage listed pursuant to the 1990 Act. The deputation, we received the deputation from Milton Neighborhood Forum, which Edward would read on my behalf. Just to put on record, Chair, members of the Planning Committee, that we have not received any response from Homes England, who are the applicants. An email chaser was sent to them this afternoon, and the ones we received have no response attached to it. Edward, can you please read out the deputation from Milton Neighborhood Forum, please?
Thank you, Eddie. Thank you, Chair. Yes, if I may, I will start shortly.
Yes,
Can you all hear me okay?
Yep.
Thank you.
Thank you.
Right. The deputation begins as follows. The officer's recommendation is an attempt to dissociate two important heritage assets from their connection with a Grade 2 listed hospital building. The applicant's Heritage Impact Assessment, or HIA for short, paints a picture of the villas that are far removed from their true place in the evolving history of St James's Hospital. This deputation unpicks that narrative and replaces it with the real facts to hopefully convince you, the planning committee, of the truth. This is further to submissions already made, which are in today's papers. The law states three key tests for curtilage listing: function, layout and ownership. No parties dispute the ownership of the villas in question, but there are significant misconceptions of the function and layout which has led to the officer's recommendations, which we refute. The villas date to 1907, not 1926 to 1932. The date of the villas is crucial to the function and layout. The council has asserted that the villas date to 1926 to 1932, the same as other villas on the site, but this is not accurate. These earlier villas are much more closely related to the hospital itself than the later villas as demonstrated below. The officer's report bases their assumptions for the dating of these villas on Ordnance Survey mapping. However, producing new editions of the Ordnance Survey was a time-consuming process, and parcels of land would have been surveyed well in advance of their map's publication date. A building not appearing at publication date, 1910, is not evidence of its absence. We would guide you instead to the tender documents in the Norwich Library and the RCHME's archive, Historic England, Swindon, which tells us the villas were sanctioned in 1905 and completed in 1907/1908. Indeed, even before their completion, the Committee of Visitors warned that the four villas would not meet demand and requested the construction of two more. Because all 7 villas appear in the next edition of the OS, the HIA comes to the incorrect conclusion that they all date from 1926 to 1932. The officer's recommendation report highlights the HIA text by way of proving the contested timeline. Unfortunately, this evidence base derives from an abbreviated article lifted from a defunct website, History in Portsmouth, and it is selectively quoted. This is explained in further detail in our original submission to PCC on page 57 of the meeting pack. The suite of 1907 villas are integral to the pre-World War I hospital estate. As built, the hospital was flanked to east and west by the farmlands of the Goldsmiths, to the south by Lily Lane, brackets Loxway Road. To the north, the asylum's home farm ran to Milton Lake. Land had been purchased from the Goldsmiths, who retained their farmland to the east and west. The farmland was well established, and certain pre-existing features would be retained as part of the therapeutic design beloved of psychiatric hospitals. A central field boundary path held to the higher ground and led out onto the summer marsh grazing of the harbour. Today it can be traced by the line of Woodlands Walk. Similarly, field boundaries were retained in the original scheme, notably the north-south alignment that will become Chapel Way and its continuance south to Loxway Road. Portsmouth provided care for its own pauper lunatics and those of Southampton. Consequently, the hospital was oversubscribed from the outset. To meet rising demand, commissioners were forced to sanction 4 extensions before the onset of World War I. For the last of these extensions, the commissioners chose to build freestanding villas and place them symmetrically in the northeast and southeast corners of the available estate. Here they had easy access to the hospital service wing. In keeping with established best practice, all psychiatric buildings of the long Victorian era face south to maximise the beneficial powers of the sun on the spirits of the patients. It is to be noted that the applicant's HIA supplies us conveniently with the rear service view of the villas. Were a similar viewpoint taken for the hospital, we would not be having this conversation. It was not until the death of James Goldsmith in 1911 that the hospital was able to expand further east, where the interwar villas would be built. Any locations closer to the east side of the hospital would have been discounted by the functioning airing courts and the obvious health implications of the 1885 sanatorium. In conclusion, this was the only practical location for the villas. They purposefully faced south, but not away from the hospital. Indeed, as these were for fee payers, there is a certain serendipity in the degree of privacy they provided, something not afforded to the pauper lunatics occupying the contemporary villas to the northeast. For the avoidance of doubt, map regression shows that the trees lining Woodlands Walk existed before the villas were constructed. They were not planted as a screen, as the HIA has suggested. The 1907 hospital, including these villas, had a single function. The 1845 Asylum Act compelled counties to build asylums for county paupers, and Hampshire County Council built Knoll Fareham in 1853. Portsmouth and Southampton were exempted from contributing to the county venture, preferring instead to place their pauper lunatics separately in the workhouse. By 1867, the situation in the rapidly expanding port cities had become such that the lunatic commissioners pressed Southampton that they would require the borough to erect an asylum of its own, or conjointly with Portsmouth. Southampton responded by building a better workhouse. Portsmouth built St James's Hospital. Population growth continued to accelerate in the late 19th century, and the failure of Southampton Borough or the county to build a third asylum meant that St James's housed not only its own but also Southampton's pauper lunatics. As stated, overcrowding was an issue needing to be addressed from the outset. To meet the growing demand, the hospital was extended on 4 occasions. The 4th extension was building the villas in question. They belong to the final stage in the evolution of psychiatric hospital design in this country. Here, the ward pavilions, which were by this date simulating domestic villas, were detached from the main building, reduced in size to accommodate fewer patients, and placed within a designed landscape. They were all built south-facing to mirror the overall south-facing design. Furthermore, it would have been impossible to build them attached to the main building without compromising the symmetry and other design aspects of the wider estate. The villas only ever serviced the expanding population of pauper and fee-paying lunatics. There was no separate function. Significance. St James's Hospital has a civic heritage that we should be justly proud of. It was Portsmouth that answered the call, building St James's at great expense. Again, it was Portsmouth who responded to the growing need when a third asylum failed to materialise. The extensions were handled with great care, were at the cutting edge of hospital design, and always favoured quality over cost. They are significantly linked to the main hospital building, forming a single purpose in a coherent setting, as noted by nationally renowned hospital architect A.E. Cogswell, who was at Rake's side in 1879. Popular throughout Europe and the USA, villas were largely shunned in England as being too costly and unsuitable for the nation's feeble-minded. Even G.T. Hine, an advocate of the villas, only succeeded in placing a handful scattered across the estates of his huge London asylums. Scarce from the outset, the few that now survive are surrounded by a sea of modern development, long detached from their raison d'etre. Here at St James's there is a unique opportunity to preserve the evolving national story of psychiatric hospital design for future generations. The COVID-19 pandemic has made us ask searching questions about the value of life. These villas are at the heart of that equation. Their implementation was stalled because of the rising tide of a pseudoscience called eugenics. To appease that tide, the 1913 Mental Deficiency Act looked to incarcerate the prolific feeble-minded so as not to weaken the nation's gene pool. It is to that history that the now demolished villas belong. As we've shown, the US 33rd Army Hospital used the villas towards the end of World War I, pertinent then to US practitioners who are at the forefront of our newly gained understanding of the neuroses caused from being under fire. This in turn led to a much more enlightened interpretation of the 1913 Act. By way of a postscript, others have commented. Firstly, 2012 RSKA Archaeology for Portsmouth Hospital's Teaching Trust in advance of the Crayfern development stated that Light Villa was directly representative of the mental health care regime at St James's Hospital at the time of its inception and contextually related to the listed buildings. Secondly, the 2016 CBRE Heritage Assessment. The site, The Beeches, falls within the curtilage of St James's Hospital when seeking consent to erect fencing. Thirdly, the 2016 NHS Property Services West Lodge falls within the grounds of the Grade 2 listed St James's Hospital and as such is curtilage listed. Finally, it is hard to escape the view of the Council's own Conservation Officer that the wall demarcates the historic curtilage of the hospital before concluding that it is perfectly reasonable to consider the wall listed. Conclusion. By following guidance and case law around curtilage listing, it would be impossible to conclude Fairwick and the Beeches are separate and distinct from the listed hospital. The Planning Committee must reject the officer's conclusions and require that a demolition of both buildings would require listed building consent in accordance with the Historic England guidance. And the deputation finishes with a web link to the Historic England guidance. Thank you.
Thank you very much. So we've got some deputations on this applications by some councillors. So just to remind councillors, there is no time limit at all. So the first person I'd like to call is Councillor Ben Dowling, who wishes to talk on the on this application. Councillor Ben Dowling, please.
Thank you, Chair, and thank you, members, for your time. Obviously, I come here trying to speak on behalf of local residents as a ward councillor, and I've been actively engaged with the neighbourhood forum since I was 15, so about 13 years, and the neighbourhood planning forum since its inception in 2015, so the past 6 years. But actually, I come to you with another hat as well today, which I don't often get to say, which is that I come to you as a history graduate. And very rarely does my degree come into much use in day-to-day life, but for once I think I can draw on some of those skills for today's discussion. There's been kind of a lot of there's lots we could say about the wider application, but just to reiterate that today is very much about the curtilage listing of these two villas, not the broader application, and those issues will come forward at a later date. And it's important to differentiate today's decision from any opinions anyone might have on the wider application. We've got to today through quite a long process. This has been a topic of disputes between the community, the council and various landowners for a number of years now, and various people have come to different viewpoints. But we are now in the position with yourselves as democratically elected people sitting on the planning committee in your quasi-judicial roles to hopefully come to some sort of conclusion which can move things forward. It's interesting that we continue to debate this despite as early as 2016 the council or our council has previously said that we believe they are listed. And there are a number of occasions where that has happened. One such occasion was when there was an application for a fence going up in St James's. It was part of the ongoing work by the NHS at the time to do upgrades and stuff in preparation for selling off the land, and that was rejected at the time. Part of that was in relation to the curtilage listing of these villas, as well as the impact on the listing of the primary listing of the main hospital building and the chapel. As has been stated in both the QC's report, the advice given by officers, and again in the Neighbourhood Planning Forum's deputation, there are kind of three key tests, those being around ownership, function and layout. No one is disputing ownership, and in terms of it being in NHS hands at the time of listing. So it comes down to this idea of function and layout. I'm quite a visual person myself, so I find it quite helpful thinking about the map of St James's, and I appreciate you might not have it in front of you right now, but earlier on Eze kindly showed the lodges in relation to this applicant's kind of geography, showing them in the top left hand corner or the northwest corner, but actually from a community perspective, and when you zoom out of that map, they're not really in the top left of anything. They're actually in the bottom right-hand corner in relation to the main hospital building. So I always think about them, and the community would think about them, as being southeasterly of the main building rather than northwesterly of the applicant's land, which they now hold. All of this seems to stem from a tabletop assessment done a number of years ago by consultants, and with various reasons behind that. And it comes down to this idea of how does function and layout relate to the significance and the timeline of which these villas were part. And I don't want to reiterate too much of what was in the deputation you just heard, but to kind of bring it, really boil it down, essentially there are 7 villas on the site, of which 4 were built before the First World War, 3 of which were built in the interwar years, and it's the villas in question are 2 of the 4 built before World War One. And I think that's really important because that's to put them in a bit of historical context. So all 4 of these villas, it just so happens that in modern times the land ownership has been split between currently PJ Livesey / the NHS, depending on whether or not they get planning permission, and Homes England with the other half of the site. Perhaps short-sightedness in one way or another without this issue being kind of determined, but that's where we are. So there are 7 villas in total, 4 villas which we believe should be curtilage listing, but we're only talking about 2 of them because they're the ones that fall within the land of the application in front of us today. I hope that makes sense. We believe that they are very intrinsically linked to the hospital because of the way they were used at the time of being built, and they were built in such a way that whilst they are physically separate in the sense that they're not literally attached in the way that a terraced house is attached to the house next door, they are attached in terms of function and layout and use. A lot is being made of the tree line in particular in terms of it being a demarcation, but actually firstly the tree line was there before the villas were there. The villas were very specifically placed in relation to the trees and the wider landscaping of it. But also there's been mention of West Lodge, which some of you might know better as the former Wind in the Willows nursery site, and that sits at kind of the gate entrance to St James off of Loxway Road. If you're driving along Loxway Road from Milton Park area, then it's the first kind of entrance into the hospital site on the left-hand side, and to the left of the site where Forest Lodge has just been approved for the new care home. Now that is quite clearly more separate than these villas, and no one is disputing that that is curtilage listed. The current applicants agree that's curtilage listing, the council agrees that's curtilage listed, it is curtilage listed, and that's become really clear. The primary reason being because it's within the wall line, and yet we're having this ongoing debate about these villas, which are a limited distance away from the main hospital and have actually a clearer link to the main hospital and a clearer function and layout to the main hospital than arguably West Lodge does. Ultimately, this is a significant part of not just local history but actually national history. The way that villas were used in mental health history in the UK is a really interesting one, and St James's probably is one of the very last, if not the last, surviving example of this approach taken in that kind of pre-First World War era. And so I hope we can come to a conclusion which saves that local history, and potentially in the future we can enhance it as well. And you've received extensive legal opinions on this. You've had 3 bits of advice from the council's QC. You will have seen the legal advice the applicants got from their QC. You may well have done your own research, and there's an awful lot of information in front of you. But ultimately, this is for the members of this committee to decide today. I think most planning professionals, including our own, have said that it's possible to come down on either side of this, and it's very justifiable to come down on either side. But we believe it's both in the public interest, the community interest, and the council's interest, and ultimately the interest of preserving history, which is the whole point in listing existing as a concept, for these to be considered curtilage listed. And ultimately that might not save them either. We have to be very open and honest about that in the future we might be in a situation where the committee agrees today that they are indeed curtilage listed, applicant comes back in X number of weeks or months' time and says, okay, we accept the courtesy list and that's what you've decided, but we still want to demolish them, and can we have permission to do that? And then we can have a different discussion about that moving forward. But as far as today is concerned, it's are they courtesy listed or not? I believe they are. Local community groups believe they are, and I hope you will come to the same conclusion. Thank you, members.
Thank you very much, Councillor Ben Downing. Thank you for that. Councillor Will Purvis, I haven't actually seen him on the screen, but is he around here to do deputations? No? Okay then, so my next person on the list is Councillor Darren Sanders, please. Councillor Darren Sanders, please. Would you like to do your deputation to the committee? Thank you.
Thank you very much, David. It won't be my deputation, but it will be the deputation of two of my constituents who articulate this much better than I could. If I may.
Yes, of course.
So I'm giving a deputation today on behalf of Kevin Doyle of 29 Moorings Way and Viola Langley of 9 Revenge Close, both in Milton. The officer's recommendation to disassociate the pair of Edwardian villas, Fair Oak and Beeches, from the Grade 2 listed buildings is misplaced, erroneous and in part mischievous. Planning officers were made aware of the true age of the villas by the Milton Neighbourhood Planning Forum as long ago as 25th of May 2018, when it wrote to the then Head of Development Control Ruth Ormella and Claire Upton Brown. It supplied them with photographic evidence of World War I US soldiers outside one of the northern pairs of villas in 1917, together with a photocopy of a bill of estimate from Messrs. Rake and Cogswell, dated September 1907, for the construction of 4 villas at the St James's Asylum for Lunatics. The photograph is reproduced on page 103 of the reports pack, together with the tender for their construction in 1907 on page 101. The villas were constructed to meet an ongoing shortage of accommodation in the county. Having already expanded the main building 3 times, Cogswell had no option but to construct freestanding villas. Indeed, it would only take a few minutes to see on which date the villas were erected and by whom, with a few clicks on the internet search engine, because there are so many sources, including county asylums, listing every asylum in the UK. Click on St James's therein, search history, and there you have it. With that evidence, the officers cannot make the statements as they do on page 17 under function in the reports pack. The statement being that the villas can be more precisely dated to the period 1926 to 1932, as they were constructed as a result of Dr. Thomas Beaton's innovative approaches to mental health, which occurred after 1926. The source is Freeman, 1962. Evidence suggests that it is likely that they post-date 1928 as documentary evidence details that from about 1928 changes began to be made in the mental hospital. End of quote in reports pack. It was Albert Cogswell, the apprentice to the hospital's principal architect, George Rake, who oversaw the construction of the villas. They had no connection at all to Thomas Beaton. These buildings represent an extension to the Grade 2 listed building and not a departure. Cogswell used the pre-existing tree-lined field boundaries within the landscape because they were already there. He did not arrange a planting scheme to create a screen to separate them from the asylum's layout. He was hardly likely to, because to do so would require the felling of established trees. When the committee considers that the trees added to the tranquil setting of the hospital, as it was then in a semi-rural setting, and that these pair were designed and built for fee-paying patients and not for the paupers who were assigned to the northern pair of villas, it would be insane, excuse the pun, to fell the trees. To do so would interfere with the whole purpose and function of the asylum. When, open quotation, officers note and accept the point made by the Milton Neighbourhood Planning Forum that the planting represents an intrinsic quality or facet of such hospitals, creating sylvan avenues with the express intention of connecting, not separating elements within the hospital estate, unquote. They're commenting on the relevance to the hospital's function and layout within the landscape, as well as the landscape's function in supporting the hospital, which these villas especially are an integral part of. The suggestion that the villas are somehow separate and sitting in their own part of the hospital site is to misread the hospital layout. Both pairs of villas are placed symmetrically northeast and southeast of the main building, whereas those to the south are less than 65 metres distant from Beaton Ward. They continue the adoption of south-facing facades to maximise the capture of daylight. Once again, this information is readily accessible from website searches such as under county asylums. The attritional demolition of psychiatric villas and asylum landscapes since 1961 makes these buildings extremely rare and quite possibly unique survivals. They precede the 1913 Mental Deficiency Act, which adopted the villa system to escape the institutionalised Victorian-built asylums, albeit not until the late 1920s. The now demolished villas Light, Grieve and Divine are indeed a consequence of Thomas Beaton, whereas Fair Oak and Beeches, formerly Dickens and Brunel, named after eminent Portsmouth-born Victorians, belong to the Victorian era of asylum care in the same way as do Falcon and Baytrees, formerly Pink and King, named after Mayor of Portsmouth William Pink and Sir William King. Their association with the main Grade 2 listed building is unequivocal. There is absolutely no substance whatever to the officer's claim that, open quotations, there was nonetheless a distinctly separate function between the main psychiatric focus of the hospital and the more general medical function of the villas, close quotation. The applicant accepts that the boundary wall, approximately 300 metres away, is curtilage listed, because the applicant applied for listed building consent to undertake works as evidence in the committee papers. So for officers to say, open quotations, the mature trees created a barrier between the listed buildings and the villas, which largely survives to this day, and this intervening vegetation means there is little intervisibility between the area of Phase 1 land and the hospital's main building, close quotation, is a simple statement of observation because the wall is invisible to the hospital too. For officers to say, open quotation, they do not appear to have or have ever had a close physical relationship to the main hospital complex, close quotation, defies a trust in their judgment based on an over-reliance on the applicant's flawed heritage statement. The heritage assessment is drafted for the applicant's overall scheme and cannot be understood as impartial. For officers to say, quote, in this context, they do not have a strong aesthetic relationship with the listed hospital, and nor do they share a similar architectural style. They also face south away from the hospital into their own rear gardens, close quote, is another misconception because the echelon extension of the hospital that the villas relate to and conform with all face south. Indeed, an earlier planning committee on 27th of April 2016 considered an application to erect fencing 2 metres high between Fair Oak and Yew House and Beeches. In the officer's report, Section 66 of the Listed Buildings and Conservation Areas Act 1990 was referred to, placing a duty on the local planning authority to have special regard to the desirability of preserving a listed building or its setting or any features of special architectural or historic interest which it possesses. The officers quote, the proposal is located within the curtilage of a listed building. Therefore, it is important to consider whether the proposal would affect the setting of the listed building. Close quote. If PCC officers considered the villas had a relationship with the hospital in 2016, then why in 2021 should they now say they don't? The Council's QC refers PCC to a very recent Hampshire County Council case on page 200 to explain that the curtilage in respect of a non-heritage listed terminal building within an airfield needs to be treated differently to that of curtilage listed heritage cases. That's by virtue of Section 1, paragraph 5 of the Town and Country Planning Act 1990, where it says that the object of the Act is to promote the preservation of listed buildings where the extent of curtilage is wider. In paragraph 23 on page 203 of the committee papers, the Council's QC explains why curtilage listing must be considered as a matter of fact and degree, but ultimately a matter of planning judgment. The QC also acknowledges that the QC is not in a position to resolve the disputed facts, but instead passes the responsibility to the Council's case officer to review the evidence in the competing assertions to form a view as to what to accept. The QC, in paragraph 24 on page 204 of the papers, explains that in his view, if officers were to accept the forum's version of events, it would strongly indicate that the villas are curtilage listed. On balance, a proper interpretation of curtilage in relation to listed buildings does alter officers' site-specific planning judgment because their function and layout is intrinsically related to and consistent with the Grade 2 listed building. Interestingly, the judge in the Hans case also said it is a matter of fact and degree and public law. The finding that these buildings are curtilage listed is not in itself fatal to the applicant's application for residential development. Rather, it means that they must follow due process and seek listed building consent before they can be demolished. That is a matter of public law. The MPPF at paragraph 184 describes heritage assets as an irreplaceable resource. If the wall demarcates the boundary of the estate, and hence the limitation of curtilage, and officers in 2016 considered Fair Oak and Beeches, these villas, to be curtilage listed, then committee members will need to be very clear as to why they're not following due process through the LBC procedure. Interference with a listed building without appropriate consent is a criminal offence, and residents do not believe this council will be following due process if this committee determines that the villas are not curtilage listed. Here ends the deputation from my residents. I also object to this scheme. Thank you, Chair.
Thank you very much, Councillor Darren Sanders, for that. Councillor Jeanette Smith, please. You're next. Councillor Jeanette Smith, please.
Thank you, Chair, and thank you for giving me the opportunity to make this deputation on the St James's development. An important issue, as I'm sure you can appreciate, for both Milton and Baffin's wards, but also for the wider city. Our heritage is under threat from scrupulous developers, but it also seems from this committee. I believe at the heart of this issue is to maximise profit at the expense of affordable housing, as stated in a letter dated 16th of February 2021 from Pinsent Masons LLP, and I quote, "Clearly, if the council did determine that the villas were curtilage listed, this would incur cost and delay to the programme for this project, which will deliver much needed housing to the city." The letter also claims that Milton Neighbourhood Forum have not provided evidence in many of their key claims. You've heard today the evidence from the deputation from Milton Neighbourhood Forum, but from the developer there seems to be one-sided legal advice. Strangely, no response from Homes England today. The officer's report considered that the buildings are not considered to be ancillary to the main hospital, as they are not subordinate to the main hospital, but are complete in their own right. I'm not sure in my short time as a councillor I've heard such nonsense, as it also states historic working relationship with main hospital, and the villas were intended to provide open wards for patients. To be considered curtilage, the buildings must be built pre-1948, which they are, but in ownership of NHS, which they are, and be within related to the physical layout of the hospital. This point is not in doubt. The NHS itself has described the West Lodge as curtilage listed and the surviving elements of the boundary walling as curtilage listed. Historic England's advice and guidance on the curtilage listing, February 2018, would also suggest the villas are curtilage listed also. So why then is this report coming to the conclusion that the villas are not considered to be curtilage listed pursuant to section 1 in brackets 5 of the 1990 Act? Because I'm at a loss to understand why we take the applicant's legal advice rather than listening to local residents, especially Milton Planning Forum or even Hampshire Buildings Trust, who know more about the history of this site than anyone on this committee. The bill for the estimates is dated September 1907, and this photo, which you probably won't be able to see, was taken of World War I servicemen outside one of the pauper villas to underscore the dates the building were erected. The Planning Committee must think very carefully in supporting this report. You have used your discretion before for the 66-bed care home against officers' advice, and I implore you to do the same. Not to make this a political application voted on party lines, but because it is right and it is within the remit of the Planning Committee. To do otherwise would make a mockery of planning in this city, which is already at an all-time low, especially in Milton, and calls into question maladministration of the whole planning process. Thank you, Chair.
Thank you very much, Councillor. Councillor Gerald Vernon Jackson, you're next. Councillor Vernon Jackson, please.
Thank you, Chairman. Sorry, let me get to the top. I hope it'll be fairly quick. Good afternoon, colleagues. I'm here as a local Milton councillor to talk about whether the whole of the St James's site should be considered as part of the listing or whether it just relates to the main building and the chapel. I'm very grateful to Ian Maguire for his advice on this. Over the years we've been looking at this issue, we've had 3 heads of planning. 2 of them have taken the view that the villas are not covered by Kirklees listing, and 1 of them took the view that they were covered. Ian Maguire has been very clear with me that members of this committee are free to make the decision to either accept the argument that the villas are covered by the listing or not. So we are in a very different place than this committee is often in, when we know if we reject an application, the applicant would win on appeal. So on this occasion, the committee has real discretion. I want to be clear, though, that any decision here to grant Kirklees listing does not mean that development of St James's won't happen. If this committee does agree that this land is Kirklees listed, then the developer can come back and ask for permission to demolish the villas. The committee might then decide to agree to that demolition, or it might not. My understanding is that there are 3 tests to decide whether the villas are covered by the main listing. These are the Stevenson's tests. These tests, as I understand them, are to decide whether the buildings are a key part of the complex, whether they were in the same ownership in 1948, and whether they are have the same function as the main building as listed and part of the layout of the complex. The villas were built to be part of the therapeutic offer at the hospital within the walls of the hospital. St James's was built in a semi-rural location to allow for people with mental health issues to recover in a quiet and healing atmosphere. The villas were wards of the hospital and received services from the main building. Having worked in mental health services, it's absolutely clear that these buildings were part of the whole hospital complex and a key part of the hospital. They were not separated from the main building by walls or fences, but part of the same grounds and enclosed within the same wall of the hospital complex, of which they're an integral part. The argument that the trees separate the villas from the main hospital is specious. When I worked for the Department of Health with people suffering from serious mental health problems, it was in a series of houses spread out over a site, as it was far better therapeutic outcome if residents were spread out over a whole site in smaller units, exactly the same way as the villas are in St James's. These buildings are a vital and integral part of the whole hospital complex. So it's really clear that the activity of the villas was a key part of what happened in the whole hospital complex. They're in the same ownership, and that the wards in the villa were part of the whole St James's Hospital, offering mental health support and healing to local residents. So it's clear to me that the villas were covered by the Kirklees listing. I'd like to record my thanks to the Milton Neighbourhood Planning Forum and to Paddy O'Hara in particular for the incredible work they've done on this. Local residents clearly view St James's Hospital as a whole. When people talk about a friend or relative being admitted to the hospital, they talk about them being admitted to St James's, and they always have done. They don't talk about them being admitted to the Orchards or Fair Oak Villa or any other unit on the site. It's being admitted to St James's. So to me and to the public, I think it's very clear that St James's offers mental health services as a whole complex in one ownership enclosed within a wall, and that the villas were a vital part of this, reflecting mental health thinking at the time they were built, and therefore must be covered by the Kirklees listing. Their function was as a vital part of the hospital, their ownership was part of the hospital, and their location is within the wall of the hospital complex and not separated by walls or fences from the main building. Therefore they pass all the 3 Stevenson's tests, and therefore they must be Kirklees listed. Thank you, Chairman.
Thank you very much, Councillor Vernon Jackson. Can I thank all the councillors here for your deputations? So, members, I think you've all heard that, so thank you again. But we're now going to move to questions, please, from members of the Planning Committee. Councillor Luke Stubbs, please. You were first. Questions, please.
Thank you, Chairman. I've got a number of lesser questions, but I think I'll just ask my most important 2 to start us off, and then others in after that. So, and really the first thing I want to ask is about almost why this is here. I mean, it's where we have matters of fact like scoping assessments or permitted development checks on permitted development, or whether buildings have been in a particular use for 10 years, and if so, do they benefit from an acquired usage. Those are all things which cannot come to the planning committee because they are not matters of planning judgment, they are matters of facts and law. And it does feel to me like this is a matter of fact and law. Look, I'm not a planning lawyer. I don't know, what decisions have been made elsewhere, what's happened in the courts about determining what is listed and what isn't, and I feel quite uncomfortable, to be honest, being asked to make a decision on this matter, because I think really feels to me like it's outside of scope. So my first question is, could officers comment on what I've just said? And then the other thing is, we as a council don't have the power to list or delist buildings. That rests with Historic England, and therefore, this feels like almost potentially, because we could, effectively this is amending or not amending a listing. So if we can't make a listing and if we can't delist, how come we've got the power to effectively amend a listing? Thank you.
Thank you very much. Eze, do you want to answer those two very good points from Councillor Luke Stubbs?
Thanks, Chair. If I can call upon Kieran, it's about legal here that he can provide more clarity on.
Kieran, please.
Afternoon, Councillor Stubbs. Thank you for your questions. So the first question you have relates to scope and why this is before the Planning Committee today. The reason is that it is a planning judgment, as has been identified, but it does also turn on points of fact and law. Now, I'm going to give you an explanation of the legal tests that you need to set out this afternoon to reach a decision, because the law only carries you so far. The onus is on you as a planning committee, as the height of the local planning authority at Portsmouth City Council, to apply the facts to the law and to reach a decision. So unless you've got any further questions at this point, I'll just go through the legal tests that you need to apply. Firstly then, today you will need to determine whether the two villas are structures for the purposes of Section 1.5 of the Planning Listed Buildings Conservation Areas Act 1990. There are two limbs to that first test. Firstly, you'd have to be satisfied that if the villas or the alleged curtilage listed villas were to be removed, there would be an adverse impact upon the listed building itself. So that's the St James's Hospital building. The second limb of that first test is that you also then need to be satisfied that the two villas are ancillary to the main hospital building, and that legal test just exists to ensure that much larger or sort of self-sufficient buildings in their own right don't become dragnetted within the protections of the Listed Building Act. The second test for the committee to decide to satisfy itself of is whether or not the structures form part and parcel of the listed building, so St James's Hospital. And it's in answering that part and parcel question that the committee will have regard to the three Stevenson factors that have been repeated many, many times already this afternoon. So I'm grateful to hear that. But that is a two-limb test with different strands within it. So if you have any questions at any point in relation to those tests, please do ask me and I can assist you. So that was your first question regarding the scope of the item before the committee today. It's correct to say it's not an application. We're not considering the grant or refusal of planning permission today. Your second question related to delisting and how that interrelates with the Secretary of State's role in basically putting an entire listed building on the list. They are separate processes. You're quite right to say that Portsmouth City Council does not have the power to list and delist buildings. That sits with Historic England, who take that function on behalf of the Secretary of State. However, the structure of the legislation is such that where you have a listing or a listed building, so I have here the listing and there is a description of St James's Hospital within it, where that listing is silent, the question will arise whether there are any structures within the curtilage of the building, if a building indeed has a curtilage. Not all will. But where you'd come across structures, you run through the tests that I've just detailed to assess whether or not they are curtilage listed, so they attract protection of the Act. So is that clear to you? It's probably best if I ask if you've got any questions on that at this point.
Councillor Luke Stubbs?
Not at this time. I'm going to give that all some thought.
Okay.
Thank you, Councillor Stubbs. I'm sure you can come back again. We won't miss you, I promise you. Councillor Judith Smythe, please. You are next.
Thank you, Chair. I've got 3 related questions. The first is, does the date of the building of the villas make any difference to our considerations? I mean, we can all see the photograph of the soldiers outside the villa. 1907, 1910 sounds more likely than either obviously during the war or 26 to 32. But does it actually make any difference?
Essie, who would you like to answer that?
Because they're all before 1948.
Yes, it will make some difference, yes.
Could you explain why?
I think in the, I just need to just refer back to my report. It does refer to what could be defined as part of the curtilage listing, and that would need to meet a certain period. So just it's on paragraph 3 of the report. One moment. Paragraph 3 and talks about both buildings if they were pre-1948. I think it just says in context when you look at the period the St. James's Hospital was built out, and when these other buildings were. So if they were built after then, then it will give less credence to their being curtilage listed.
But not the fact that don't seem to be arguing at all about whether or not it was built before 1948. Definitely both. They were built before 1948, but there seems to be an argument about whether it was 1907 or 10 or 1926 to 32. And it seems to me that that's not really.
It's material. Not really. No, I agree with you there, Councillor.
Okay, thank you.
You have a point, Councillor.
My second question is, I suppose, more from Kieran, which is, you've very carefully laid out what's also confirmed in the report, that the various questions we have to ask ourselves. Are they structures? Is the first set of questions, and there are 2 points to that: the adverse impact on St James's Hospital and the 2 villas. Are they ancillary to St James's Hospital? Do we have to answer yes or no to both of those to make that stack up? And likewise, the Stevenson test, the test, the 3 questions we're asking about function, ownership and layout, do we have to answer them all with a yes and a no, or a no, depending on which way we're going to make our judgment, or can we look at the balance, or how do we have to do that?
Kieran?
Thank you, Councillor Smythe. So your first question, in terms of the structures, the answer has to find them curtilage listed would have to be that yes, there would be an adverse heritage impact upon the listed St James's Hospital building if they were removed, and yes, they have to be ancillary to the listed St James's Hospital building as well.
So both of those things. Both
of those questions have to be answered as yes to find if they're to be found curtilage listed. Yes. In terms of the second limb, which is the part and parcel test, the question you're directing yourself is to whether or not the 2 villa buildings form part and parcel with the listed building hospital. The Stevenson factors, they're not strict tests, but those are the factors that you use to make that decision on the part and parcel question. So you're right when you ask, is it something for us to weigh? Yes, it is. It's up for you to take the evidence, view it through those prisms, and weigh a decision on the question of whether they're part and parcel of the main hospital building.
Okay. I mean, that's significant because obviously there doesn't seem to be any disagreement about the ownership. question.
No,
So
and
the other two we have to
I mean, there's also judicial comment generally that ownership, it comes up quite a bit in different planning scenarios, but is even specifically in the heritage context. The tricky thing with ownership is that it's very easy to change legal ownership, but nothing actually changes other than on paper. So that is a legitimate thing for you to be weighing in when those sort of three competing factors, or well, not competing, they're all obviously something you consider in tandem. But, does that make sense?
Yes, thank you. That's helpful. The last question then, Chair, if that's all right.
Yes, of course.
There have been attempts to get the villas listed, and I wondered if you could remind us of whether they have been successful, or I gather they've not been successful, and I wonder when the last attempt was.
Kieran or Ezzy, who would like to answer that?
Just, Councillor, if I need to just go through my records and just confirm that to Councillor Smythe, please.
Yes, please.
Thank you.
Chair, I don't mind if you postpone the answer to that question in case it can come back.
Yeah, okay, I'll come back to that one.
As I recall, they were turned down, and I couldn't find it in my report when I was checking this morning.
Yeah. Okay, well, have you found it yet? If not, I'll move on to Councillor Donna Jones and then come back to that one.
If we can come back to it, please, Councillor, I'll be much appreciated.
No problem at all. Just say so, sir. I know it's when you're put on the spot, it's very hard, especially on this. Councillor Donna Jones, please.
Chairman,
sorry.
Chairman, sorry, it's Alan. Can I help at all?
Well, if you can, sorry, if you'd like to just make sure you put it in chat as well and let me know, Alan, that's fine. Alan, would you like to say something before I turn over to Councillor Donna Jones?
Yeah, the answer to Councillor Smythe is that it was mid 2018 that the Milton Neighbourhood Planning Forum or one of their representatives contacted Historic England, and they made a decision that the villas would not be worthy of listing in their own right. So mid 2018.
Thank you.
Thank you, Alan. Councillor Donna Jones, please. Some questions to the officers, please.
Thank you, Chair. The question that I've got 2 points really, and I'm sorry, the first one is a question. The second one is a principal question that's going to actually probably end up being more of a comment, which I'm sorry about that, but it's going to be very difficult to separate it out. But it will require a response from an officer. Yeah. The first point, following on from Councillor Judith Smythe. So, can I just ask a case officer if the age of the villas would make a material difference to anything that we're considering today? So, for example, because we've heard a lot in the deputations around the fact that the reports and professional assessments have been based on, they believe, the age of the villas being built in the 30s and 40s, when in fact they were probably built around the turn of the century. So can we just get clarification, or even earlier actually, maybe in the late 19th century, can we just get clarification around that?
Who would
like
it
be material or not? That 40 or 50 or 60 year age difference.
Could you just remember, just to remind members and officers, please only use the meeting chat if we really need to have it, if we really need to use it. So, Councillor Donna Jones put a question there. So, do you want to answer that?
Or the case officer, maybe, if Alan's the case officer.
Alan?
So, Councillor Jones, you're asking the significance of the age of the villas. I mean, at the end of the day, you've got evidence submitted by the applicant in the heritage impact assessment, and you've got the evidence presented by the forum. At the end of the day, you'll have to decide whose you favour. At the heart of the argument is if these are actually older than some have suggested, that they may have greater national significance. But of course, the counter argument that to one earlier is there a great sort of difference between them? Well, obviously that would have been something that Historic England would have considered, and in deciding that they're not worthy of listing in their own rights, obviously the components they've looked at is both the architecture and the historical significance as well. So it's.
We're not.
I
sorry,
can't definitively tell you the date.
We're not considering the listed building today, are we? We're considering the curtailage of the building and whether or not it has a material impact on the main hospital. So with the decision that's before us today, would the age of those properties have a material impact on the officer's report today or not? I mean, English Heritage already said they don't want to list them, so we know that. But, you know, from your perspective, if these properties were built in 1879 or 1936, would that make a material difference? Or do you think it would make a material difference to the barrister's advice to come forward today as well?
Ultimately, the decision for you today is whether you favour the evidence of the forum or the evidence by the applicant. How important the age is then linked to how significant or unique, rare these villas are within the timeline of when we've gone. I'm not a history graduate. Councillor Dowan probably do this a whole lot easier than me. It's how rare these villas are in that national context rather than how important they are in a local context.
That's not what we're being asked to decide today, is it? We're not being asked to decide how rare they are. This is about the curtailage and their impact on the main hospital. That's what we're being asked to decide in this decision today. And that's what I'm asking. Maybe it's one for Kieran then. Can some officer please let me know if the age of these buildings, there's a variant being produced today that spans a 30, 40, 50, 60 year even gap, is that material to our decision or not? It's not about listing. We're not being asked to list the building today or not, or decide if it's listed. That's already been agreed. That's out of our scope. British Heritage have already looked at it, viewed it, visited them, considered all of the evidence and decided they don't want to list them. So we know that. But is the age of these properties a key and relevant decision for us today or not?
Kieran, do you want to have a stab at this
thank
one?
you. So it goes back to the point that you will feed that question of age and that dispute of evidence between the parties into the three Stevenson factors. I'm quite happy that you could apply age into the three Stevenson factors in order to weigh your decision legitimately. There's a conflict of evidence. You can decide between that.
Okay.
Jones?
Thank you very much. Right. I'm going to move on now to they are going to be comments, but they will need a response if that's okay. I do apologise about this, Chair, but I do think that this is the relevant point to bring them up. Having been on this committee for 13 years, with the exception of a break of a couple of years when I was leader of the council, this is an extremely unusual decision that the planning committee are being asked to make today. And I have to say, and I'm still open to persuasion that I'm wrong on this. So that's why I'd be very interested, particularly to get Kieran's take on this, and Alan and anyone else who is really who is here to give us professional advice today. But from my perspective as a lay person, the relevant policies that need to be taken into consideration for an application. So if we can just step back from where we are today with what's before us, and we're looking at the overall application that came to this committee came to the council in 2018, came to committee in 2019, and then the legal dispute that's gone on since. The material planning considerations are not judged by us, the planning committee. They are judged by planning officers who have a degree in town and country planning, and in consultation where required with somebody like Kieran, who was a legal planning expert. And I think that's the point that obviously Councillor Stubbs was making when he first spoke as well. So the fact that this came to committee, it was rejected because of a insinuated legal challenge from the Milton Neighbourhood Forum, which I fully understand, very much within their rights to do that. And then the council has gone off and sought extensive legal advice that's taken, nearly 2 years to get. The council's then received that legal advice and the case officers and the council's lawyer, Kieran, I'm assuming, have reviewed all of the evidence, all of the QC's reports, and have put in black and white in their report today that they believe that the curtailage argument is not valid. It doesn't have a material impact on the building, and that's their professional judgment. Now, we also heard in one of the deputations that it was the QC made it very clear that it's a planning judgment, and it's for it passes to the council's case officer to make a planning judgment. I wrote that down. So in all applications that come before this committee, it's the officers, the professionals, the people with the degree in town and country planning to make a decision about the relevant policies that they base their professional recommendation to us on, be it permission for refusal or for rejection, recommendation for refusal or conditional permission. And yet here today, it appears to me from the officers' report that the officers have taken on board the QC's advice from both Homes England. They've weighed up the Milton Neighbourhood Forum position, and they've also taken on board the council's QC position, not once but twice. And the case officer has put in writing that they don't think that the curtailage issue is a material point, and that therefore we should be going on to decide the application fully for 107 homes. So why then is this coming to us? This is highly irregular, and as I said, in 13 years on planning, with the exception of a couple of years break around 2014 to 2016-17, I've been on planning for pretty much all of that time. This is making me quite uncomfortable. As Luke Stubbs said, we are not lawyers. We are not planning, we don't have degrees in town and country planning. We go by the advice given to us of our officers, and we either agree with that or not. Our officers have written in the report they don't think it's an issue, and therefore they should therefore be bringing this application back to us, having made their decision on what the material planning considerations are, and not asking us to judge if we think it's a material planning consideration or not. So I am very concerned about this. I think it's irregular that this is coming to us in this format, and I feel, particularly legally, and bearing in mind that these things can go on to judicial reviews or on to appeal to a lesser extent to the planning inspectorate, but certainly to judicial review, I just don't think that we are the right forum to be making this kind of decision as 8 or 9 lay councillors who do this as a part-time type job that we dip in and out of. I just think that we are completely ill-qualified, and I'd like a response on that point.
Kieran, I mean, obviously there are quite a lot of concerns that Councillor Jones says there. She's got me slightly wobbly as well. Can you reassure her and reassure members, please?
Okay, so the key point, as was stated right at the beginning of the meeting, is that you are here today considering one item, not the full application. There are no planning policies in play. You're concerned with the Listed Building Act, Section 1.5. So you're being asked to determine one very narrow, indeed binary, legal question, whether or not these buildings are or are not curtilage listed. Now, I hear what you're saying about this. This is a complicated matter, and it's unusual that you would take one matter of an application and bring it forward like this. The point is that if you just went straight into the determination of the full application, this is one of many factors that you would have to decide. This is material to whether or not a listed building consent is required. So it's seen as prudent by officers to flush out the answer to that question before going forward, because it will then would make for a very complicated decision on the entire application in one sitting if you were to decide that they were curtilage listed and there was not a supporting listed building consent application, because that would be quite a considerable change to the understanding of the heritage impact of the development. So does that make sense? I understand entirely where you're coming from.
Can I come back, please? Because
Yes,
fundamentally, that gets right to the nub of the point I've just made. It would not be for us to decide if the curtailage was a relevant policy or not when it came to committee, which is what Kieran's just said. He said it would be one of many things that we'd have to consider. No, the point is that if the planning officer, the professional person with a degree in town and country planning, has made a decision that it is a relevant policy, we can then agree with their assessment or not on what the outcome should be. But we are not the people who are best placed to decide on behalf of this authority and the people of Portsmouth whether it's a relevant policy or not. Now, from the officer's report that's before us today, it's clear to me that the officer thinks that there is a clear way forward here and that it is not within the curtailage, and it doesn't, under the Stevenson test, it doesn't have an effect on the listed St James's Hospital. So why is it the officers are not having confidence in their own professional assessment, taking on board a barrister's opinion? Because it won't be for us to make the decision at the next committee meeting if that is relevant or not. It would be for us, like all things. If you have a two-storey extension to a house, we had one off Castle Road about 3 months ago, and one of the relevant policies was the scale, bulk and mass of the building. Was it going to have an impact on the two terrace houses either side? Now, it wasn't for us to say to, let's say, Rebecca Altman, Rebecca, you've got that wrong. That's not one of the relevant policies. You shouldn't have that on there. It was for us to decide if we agree with Rebecca's assessment of the scale, bulk and massing impact on the neighbouring properties. It wasn't for us to say that is a relevant policy or not, because that's their professional judgment as planning officers. So I come back to my original point. I think that both the PCC legal team and the planning department are putting us in a very difficult position because they don't want to make a difficult decision. Well, I'm sorry, that's what they're paid for, and that's also why they went to university for 3 years and have done umpteen years experience in practice, in either local government or private practice, to be able to sit here before us today being paid a lot of taxpayers' money to give us this professional judgment. So I'm sorry, I reiterate my point. Nothing that's been said to me by either case officers or the council's lawyer today have convinced me that this is the right and appropriate position for this to be. And if this does get rejected today, I wouldn't blame Homes England for taking this further on the fact that we are not the appropriate body for this decision to be made. It's for the officers to decide their position on the appropriate policies, the relevant policies, to judge their opinion on and bring it forward to us. Yes, it might be a complicated application when it comes forward with 107 homes, of which this would be or could be one of the relevant policies. But this is entirely the wrong, part of the council to be making this as lay members of a planning committee on a legal point about whether this is a relevant policy or not. That should be for the officers to decide, not us.
Sharon, what do you think of what Councillor Jones says?
As I've said already, it's not a question of policy. You're not concerned with issues of policy today. There is a legal test set down in statute that must be met by any decision maker. That could be an officer under delegated authority. In this instance, it happens to be in the context of the loan issue presented to the planning committee. If the application were taken forward as a whole, the planning officer would give their recommendation, as they have today, and it would be open to planning committee to say, thank you, planning officer, we see your judgment on the curtilage listing issue, but we disagree with it. That is your gift. In the same way that when you gave the example of scale, bulk and massing, the policy for a full application may be relevant, and you don't dispute that, but you take it in a different direction. That's exactly what you could do here. We're saying that the test is before you. What do you make of it? We can only take you so far, in as much as I've stated what the law is. You've got reams of evidence before you. What do you make of it?
It's exactly the same as right of light, Chair. I'm not going to reiterate my points.
No.
I think I've made my point to the committee now. I'll leave it at that. Thank you.
Thank you very much, Councillor Donna Jones. Thank you for that. Thank you, Kieran. Councillor Terry Norton, you were next, please. Questions to the officers, please. Councillor
Yes,
Terry.
thank you, Chair. And I am equally as confused about this, really, and will try my very best to put this into as material grounds as possible. I agree with the comments that have already been made. This is one of two things. I think this is either officers not wanting to make a difficult decision or an attempt to push an application into the long grass for whatever reason. But I will try and tie this to material grounds if possible. It does have an impact on an application that, yes, we're not deciding to set today for 130 plus homes, but it is linked to it. Of course it is. So I guess my question is about the cost of keeping those buildings in operation, and maybe the site on whole, actually. What is it costing to have that site left unused, and who is paying for that? And then the second question is on timeframes. Whatever decision is made today, what is the worst case scenario for that pushing back the real application or the full application in the future? Do we have an indication of how long that it will take of that site further being left unused while we make decisions on contentious issues like this today?
Good point. Ezzy, did you want to answer Councillor Terry Norton there?
If it's okay, I just wanted to have a discussion with my colleagues behind the scenes and come back to you on that, Councillor. Okay.
So are you asking for a comfort break? Is that what you're asking for?
Yes, Councillor.
Okay, then members, the officers are asking us for a comfort break. So I make it, so when did you want to come back? What, 10 to 4? Is that long enough for you?
10 to 4 will be fine. Thank you.
10 to 4. Okay, so we're going to have a short break, members, and we'll see you back at 10 to 4. If you could put the screen up, please.
Yeah, I'll share the screen, and also if you'd all keep your microphones off, please, because it is still recording.
Yes, please. And we'll see you back at 10 to 4, members. Thank you.
Councillor.
Yes.
Ian will be joining us.
Okay, thank you very much. Anna, it's 10:02.
Right, do you want to, shall I take the slide off?
Yes, please, and ask members to come back. If members can hear me, if they would like to put their videos back on. Thank you very much. Are we all here? Are we all here, Anna? Just to make sure, please.
Right. I think, well, I had 24 people before, and there's 24 showing as the list of people. So we've got.
Okay. I think we should have one extra. We've got Ian, who's going to join us at this point.
Right, so I'll just do. I've got Councillor Atkins, Atwell, Councillor Fuller, Councillor Hunt, Jones, Norton, Smythe, Stagg, Stubbs, Udy.
That's everybody, I think. Okay. Members, welcome back to the general public. Thank you for bearing with us as well. We had a little short break there for the officers to have a little chat. And Ezzy, would you like to tell us what's happening now, please? Thank you.
Thank you, Councillor Fuller. Thank you, Chair. The Chief Planner, Ian McGrath, has joined us, and he would provide a response to the questions from Councillor Terry Norton.
Thank you. So, Councillor Terry Norton, do you have those questions with us, please?
Do you want me to repeat them, Chair?
I think so, just so that we can know where we were. If you
what did I say? So I was worried about the reason for this coming to the committee, wasn't I? Is whether it was to, kick this into the long grass, or whether it was a decision avoidance of making a decision from officers. But the main thing here was the cost, wasn't it? The cost of running the site at the moment, because it is linked to a bigger application, and time frame. So what is the current cost, and who is paying for the site? And then secondly, if whatever decision is made today on curtilage, etc., what is the anticipated time frame that will push back a further application? What implications does that have? Are we looking at another year, 2 years, 6 months of nothing being decided?
Thank you very much. So Ian, would you like to introduce yourself, please, to members of the public if they don't know you, and then obviously answer those concerns from Terry Norton, Councillor Norton. Thank you.
Certainly, Chairman. Thank you. I'm Ian Maguire. I'm the Assistant Director for Planning and Economic Growth. To look at those questions, as the Planning Authority, obviously, we don't have any information regarding the landowners' costs for the site, so unfortunately there is no assistance we can provide for them. Obviously, it is a vacant site at the moment, and there will be, I'm sure, security, etc. costs associated with it while the consenting is carried out. In terms of the process that the members are being asked to look to in respect of the curtilage listing, the process, in this case, officers have made our clear recommendation, but as the report lays out, it is a matter of judgment of whether or not curtilage listing status applies to these buildings, and members, you are the ultimate judges within the council. It is your role to settle those matters of judgment where there is significant matters to resolve. There is clearly a difference of opinion between an important stakeholder, the Modern Neighbourhood Forum, and the officer's recommendation and the applicant's position as well here, and therefore it is appropriate for members to exercise your judgment. It's the role of the Planning Committee to exercise planning judgment on behalf of the local planning authority in this case. What would that do to the overall timetable of determination? Well, it really depends on the outcome. If the conclusion is that these buildings are not covered by the additional protection of curtilage listing, then that is a certain set of material considerations that officers will factor into in finalising the recommendation regarding the live planning application on this site. That'll be factored in, and the report will be brought back within, I'd imagine, the next couple of cycles of committee. There's no particular need for delay associated with that. Obviously, we would want to go back and speak to the stakeholders, in particular the Neighbourhood Forum and the applicants to discuss whether they feel there is any further action. Normal practice for highly contentious schemes, I'm not suggesting that is what we have here, but clearly there's a degree of contention, would be to take a precautionary 6-week period, which is obviously the period wherein interested parties can judicially review a decision by a local planning authority. So whether there's a pause for 6 weeks before we then progress with confidence of the decision of the committee and resolve the broader planning application will be something we'll be discussing, obviously, with our legal advisors and amongst ourselves. But either way, within a couple of cycles, we'll be bringing back the discussion on the basis that they're not carefully listed, should you so conclude today. If, as the alternative, you conclude that they are carefully listed, obviously that does require further consideration and may require a listed building consent. If the applicant does not wish to amend their scheme, that will be for the applicant to make that determination. That the options are clearly to apply for listed building consent to secure the demolition of these buildings protected under Section 1.5, or to amend the scheme and retain the buildings in some format. We'll be discussing that with the applicant, which direction they wish to take, and then obviously any delay associated with that they will be able to factor in. They've obviously done extensive heritage work to underpin their submissions to date, so the listed building consent for the demolition of the building, should they take that route, I would not anticipate would take them very long to pull together, so that would be not something that would need to do specifically delay a decision as I say, wouldn't be the next schedule of meetings, but we'll be looking at a meeting sort of May, June, for something like that, to give them a chance to have a listed building consent heard at the same time, should they wish to demolish the buildings, notwithstanding a conclusion, should a conclusion be reached, that they are covered by the protection of listing. Clearly, if they want to amend the scheme and do something totally different, that will take longer as that alternative design will be put together. That is obviously for a decision for the applicant to make, depending on the decision you make here today.
Ian, thank you. Councillor Norton? No? Okay, you may want to come back later. Thank you very much, Ian, for that. Councillor Matt Atkins, please. Councillor Atkins, please.
Thank you, Chair. I've quite a long list of questions, so you might need me to ask some of them and then come back later. But we'll.
If you can ask them sort of one at a time, and then we don't get too much, they can quickly answer them, if that's okay. I think that's a better way.
I'll see how we go. I mean, obviously, I do have a bit of legal experience, an academic lawyer rather than a professional, and I do think I have a reasonable understanding of the test, but obviously not my specialist area. And I do feel that actually the history of the building becomes extremely important. The history of these villas becomes extremely important to our decision today. And unfortunately, from the paperwork I've seen before me, all I hear is there is a dispute in evidence about the history. What I feel that I don't have enough of to make a decision here really is some sort of authoritative opinion on the history, or I even perhaps feel like there has been an insufficient investigation into it, not to criticise officers in any way, but I would like to know what investigations have been done into the history of the buildings to determine the date that they were built. Have we had an independent historian of our own examine the information provided by the Neighbourhood Planning Forum to assess the documentary evidence they suggest these buildings were built in 1905?
Okay, Ian, are you still with us? Would you like to answer?
Could you take me through what historical investigations have been done by the council as opposed to by the applicant or by the Neighbourhood Forum?
Yes. Thank you, Chairman. Yes, so that no further independent assessment has been done of historical evidence. We have examined and compared both the applicant and the Neighbourhood Forum's assessment and brought them in summary to you, as would be the normal practice. We haven't commissioned our own evidence. The role of the planning authority is to assess the evidence before us. Both the applicant and the forum have done extensive and very informed assessments. They have come to different conclusions, always a challenge, and we've therefore presented both their background information for you to make a judgment on and our own conclusions. I don't think there will be a resolution of what the truth of the matter is. There are clearly conflicting opinions about the available evidence, as always, at some point you have to draw that line and say, right, that's the evidence that we have. We now need to come to a judgment. We've made our recommendation. It is for you to have that judgment. In the ideal world, we would have more common ground between the parties. Unfortunately, as is so often the case, the ideal world is not available to us.
Councillor Atkins?
So if I were to summarise the evidence as I see it, as I do not believe there is a clear answer to the date at which the building was built, but I consider that that is an important question in assessing, under the Stevenson factors, use and function, and perhaps even partially physical layout, and also in relation to structure, the extent to which the buildings are ancillary. If I conclude I do not have sufficient evidence to make the determination as to when the building was built, but I think it is important, do I fall on the side of curtilage listing or against curtilage listing? Which is the default position?
Difficult one, that, I should think. Who's going to answer that one?
Again, Chairman, to assist, there isn't a black and white answer, to say, unfortunately. You will need to balance that. That's obviously, that factor doesn't give you an answer of whether it is curtilage listed or not. It's one of the factors in the round, and considering the other tests and the other relevant matters. Are you more convinced in your judgment that it's curtilage listed or not? That is an individual judgment for you to make. Certainly that lack of certainty is unhelpful. This is, again, unfortunately, the real world versus what we would like to have available to us. It is our job to look at the evidence that's available and say, okay, we know it's somewhere between those dates, is the information that we have. We now need to make a conclusion on the balance of probabilities on which one of those cases, or neither of those cases, you find more convincing, to see whether this should be extended to it. So it is purely a matter of judgment. There isn't a legal test we can say if it's built in date X, then it is curtilage listed. If it's built in day Y, it is not. That is not the relevant test. That is not where your judgment need be exercised. That is one of the factors. And if you feel that I don't wish to personalise it, but the Neighbourhood Forum's case for when it's built is more accurate and is more persuasive to suggest that they are curtilage listed, because accuracy and the relevance to the overall balance, of course, not the same question. Or if you feel the applicant's case is more accurate and or is more persuasive as to the relevance to be taken into account for the curtilage listing, that is part of the judgment that you have to pull together in your mind.
Councillor Atkins again.
I can explain what I mean by that question in a bit more detail, but it would possibly involve me straying slightly to comment. But I would like to hear the officer's response to this. So, if I were to take structure, for example, removal would have an adverse impact and it being ancillary to the main building. I don't consider them, and you can perhaps correct me on this, but I don't consider them to be, from what I read of the law, completely independent tests. They are somewhat interrelated. So if they're different judges expressing, if you like, an interpretation of the same piece of law. So if the villas are ancillary, then their removal is likely to have an adverse impact. And similarly, if removal is likely to have an adverse impact, the villas are probably to some degree ancillary. Whereas if it's not likely to have an adverse impact, they're less likely to be ancillary, and so on and so forth. So there's an interrelationship. And so, you know, from one perspective, I could say, well, if I look at them as an architectural or planning point of view, does removing these buildings have any obvious immediate impact on St James's Hospital? Well, probably not from an aesthetic point of view, but the argument that the planning forum is making, it has an impact from a historical point of view. And so the sense in which they're ancillary is dependent in part on when they were built and what they were used, and whether or not they were historically interrelated with the core use of the hospital at the time it was built, or if they were a later addition when the use of the hospital changed, after which point we don't consider it to have quite the same level of historical conservation value, which is what I took Historic England to say. So, for example, in that test, applying it without the relevant, without being able to reach a determination, in my opinion, in order to determine that test, I would need to determine, as a judge would in a court case, whether or not I consider the buildings to have been built in 1905 or 1926, and whether or not I consider them to have been used as part of the original function of the hospital or part of the later function. And so I would consider myself to need to reach a factual determination on that point. before I can then reach the in-law theoretical determination of how the test, of which way to fall on the test, because I do think the historical point then decides, if you like, whether or not they are ancillary. And I could go on and I could go through the same process with the curtilage test, but effectively what I'm saying is I feel like I'm being asked here to reach factual determinations about the history of this building, of which I don't feel I have enough personal knowledge, and I don't feel I am presented with enough evidence. Because, in a court case, a judge will always, and I know we're only quasi-judicial, but a judge will base their reasoning on facts. And I would expect, as a member of a planning committee, to be presented with, if you like, a determined set of facts from which I can then apply the principle. I don't expect to be a finder of fact in the way that I'm feeling like I'm asked to be today. So I do consider this to be different from when we're applying our own policies that we wrote, which, or the council in theory had, in theory wrote. Previous councils may have actually written them, but they are things that we created as expressions of our view and our desire for the future of the city. I instead feel like I'm being asked here to decide the factual history of St James's Hospital, so that I can then determine the legal question of whether or not the buildings are ancillary, and indeed whether or not they have a shared use and function which might make them curtilage. And I just don't think I have the facts here, and I don't think I should be a finder of fact in that way. Is that not a correct interpretation of the law as it's sort of been put before us?
Is that one for Ian? Yeah.
Yeah, if I may assist, then I may well pass you over to Kieran.
Yes, that's the next one I was going to go for.
First of all, to be blunt, one of your roles as a planning committee is you do have to find, because you are an emanation of the local planning authority, the ultimate emanation of local planning authority, you are required to be a finder of fact. Every application for a certificate of lawfulness, for example, is exactly that. What are the facts of the case based on the available information? This is the available information. You could forever do further research. We have conflicting opinions from very detailed research that has enabled us to draw a conclusion. I would suggest, however, from overall the nature of this test, though Kieran will expand on this, there's a risk of chasing yourselves down a rabbit hole slightly. Obviously, when the buildings were built, there have been a significant evolution of the buildings from the 30s, when it's all accepted that the buildings were there, through to today. And obviously it's about evolution as well, which is a key influencing factor. So whether they were built in 1900s or built in the 1920s or built somewhere in between, obviously we do know how the buildings are perceived now from an ancillary and structural point of view, and how that use has changed since that period. If you feel that there is insufficient evidence about whether the buildings were there between 1900 and 1930 to balance those issues, then obviously you're unable to exercise your full judgment. I would suggest, and it is my professional advice, that factor and that factor alone is insufficient to outweigh the broader other tests that come into play here to enable a judgment to be made. We are required to make this judgment. It is a finding of fact from the information available to us, and then more importantly, a conclusion of your judgment based on the facts that are available to you. Do we have the information in the way we'd like to have it? No, I would happily agree. We do not. Does not change our obligation to conclude this matter.
Thank you, Ian. I think that was well said. Well put forward anyway. Ian, not Ian, Kieran, did you want to say something about this at all for Councillor Atkins?
Yes, there is one thing. Councillor Atkins is particularly interested in the ancillary question to the first limb of the test. The important thing to understand about that ancillary test is, as I said earlier, it's intended to limit the scope of what can be brought within the protection of the listed building. So first you address the question of whether there would be an adverse heritage impact if the two structures were removed. And that forms whether they are in fact structures in the first place. But that ancillary test is designed to ensure that a neighbouring building that would be regarded essentially as its own sort of building in its own right, and the lead case on this is Debenhams, which I think concerned was a listed shop, but I think it was essentially, as is often the case in London, a sort of terrace. It was, although the other building was attached to it, the neighbouring shop is clearly not ancillary to the listed building, so should not be dragged into the listing by virtue of the fact that it's attached. So yeah, it's very much about cutting down and limiting sensibly what gets caught in a listed building. That's what the ancillary test is about. Does that assist?
Does that assist you at all, Councillor Atkins?
Yes, that is somewhat helpful in how to apply that particular test. I do still have a difficulty with, the extent to which in a standard planning application. Could you give me an example of in a standard planning application, where there might be a dispute of fact that we would resolve? Because what we have tended to do, is if we are asked to decide questions, is it within the does it fit within the conservation area? Is it too large? Is it too over intensive? Does it interfere with neighbouring amenity? None of these questions of fact. Like, we're told how many houses, how many parking spaces, what kind of things do we decide as questions of fact on a regular basis, in the same way that we are deciding now about things like coming to a determination about the interrelationship over time, which is a historical factual question, between villas and a central hospital building.
Who wants to answer that? Ian, you look as though you're ready for that one.
Yeah. So I think, as I mentioned earlier, the most common scenario where the local planning authority has to come to a question of fact are matters of lawfulness, so certificates of lawfulness, and matters of enforcement as well, dates of implementation, so on and so forth. It's a regular requirement of the local planning authority. It is rare for those matters to come to the committee, because the structure of your constitution and the nature of those matters often don't require this part of the local planning authority to do it. They're delegated to officers. But yes, matters of fact, so it doesn't actually matter whether the committee does it or officer does it. It's the local planning authority coming to a determination, and it's a very common outcome that we are required to determine it. And certificates of lawfulness with neighbours presenting alternative information, and certainly pretty much every enforcement case I've had to take formal action on, you will have disputes over fact when something occurred. For example, whether it's now immune to enforcement action, it is unfortunately a common requirement to judge those and then look which is the more persuasive evidence on the balance of probability to come to that, to then inform the second judgment for an enforcement case, for example, which is, now we've established whether it's lawful or not, is it acceptable or not in planning terms. Similar circumstance here, we have to establish the degree of fact as far as it is relevant, that we've talked through here, and then you have to make a judgment as to the implications associated with the tests as laid out in the report, to then apply that, the facts as you've established it, to then apply that judgment going forward to whether or not these buildings are covered by the appropriate listing status. So yeah, not something commonly planning committees need to do, but obviously it is open for all decisions of the planning authority, and in fact without an appropriate scheme of delegation, all decisions of the planning authority would be coming through the committee. So it's a very common circumstance, just not one perhaps this committee's had much experience of for those reasons.
Yeah, thank you. I mean, the end result for me is the likelihood of falling back on professional advice, just because I feel like there's a high likelihood whichever decision we reach, that one of the other parties may well take it either to appeal or to judicial review, or it may end up judicially reviewed regardless, because it is a question of law to be decided. That even the planning inspector, I don't know if they would easily decide this themselves. In that circumstance, it just feels like in the end, the reason we normally delegate is because that provides us with a certain level of legal protection, because officers could ensure they make that decision on the basis of their expertise and following legal procedures and legal requirements. I do still feel that this is a slightly risky for a decision for us to reach if we do anything other than follow professional legal advice, and the weight of the professional legal advice we have received appears to be in favour of not saying this is not curtilage listed. Is that a correct analysis?
Chairman, if I can assist, I think it is very important to clear. So we've got a lot of advice, opinion from QCs, and Kieran, of course, has been assisting you today. This is not a legal judgment. There are matters of fact to settle, and obviously the law helps us establish what are the relevant facts, but matters of fact. But then it's a matter of planning judgment. The law is quite clear that it's not a matter of law, it is a matter of fact and to be in planning judgment in these cases. So it is quite right and proper for you are entirely qualified as being competent and capable people to make those judgments based on the evidence before you. Ideal evidence, no, but obviously anyone sitting in a position of judgment has to use the evidence that is available to them. I would stress the scheme of delegation is not to insulate the planning authority against challenge. It makes no difference whether the decision is made by you or by me on your behalf. It is still the application of judgment based on professional recommendation. My officers make recommendations, and then either the management team in the planning department sign them off on my behalf, on your behalf, or you sign them off on your own behalf in planning committee, or you disagree with them as a matter of judgment. So there is no difference in the actual process or the legality of a decision made by officers or a decision made by members. There is no difference with me disagreeing with one of my officers' professional judgment on a matter of planning judgment, or you disagreeing with your officer's recommendation on a matter of planning judgment. The legal liability, the legal risk is exactly the same as long as in both those scenarios the decision maker, in this case you, properly applies all the considerations as available to you and comes to a rational judgment. And that rational judgment there is perfectly capable of coming to a rational judgment that disagrees with the recommendation. I wouldn't recommend it. The recommendation we've given you, but it is not irrational to weigh these matters differently, to prefer some of the facts as preferred and make a judgment that differs from the conclusion officers have drawn. That is rational. It's just not one that we're recommending to you. We don't think the evidence and information points in that direction, but it is for you to apply your own judgment to that rationale.
Councillor Atkins?
Yeah, that concludes one category of questions. The second category will be more relating to factual questions around the evidence and things said in the QC's opinion. If you want others to go first, you can, but I do have a considerable number more questions.
I know I've got Councillor Judith Smythe. Is your RTS working, Councillor? All right. Did you want to pick up a point? Because if not, I was going to go to Councillor Lynn Stagg. A point. Is that what you wanted, Councillor Smythe? A quick point.
It's about the question, and it follows directly on from Councillor Matt Atkins. So I thought it'd be useful to do it now.
All right. Okay. I'll allow that, and then come back to Councillor Atkins. Councillor Judith Smythe, then, please.
My question is this, and I did have a go at asking a similar question earlier, and I didn't quite get the answer that would help me very much. If we accepted the evidence that has been provided by Milton Forum that the building was built in 1910 or 1907, would that have changed the officer's recommendation? And I think that's an absolutely key question. When we had the answer, I think, Ian Maguire, you implied that, whether it was built in 1907 or in 1930, it wouldn't make any difference to whether or not there was a case to be made about being ancillary. And indeed, it could be argued that meals could be made in the main hospital, whether it was built in 1907 or 1930. The key date, I believe, was the 1948 that you said was a cut-off date. So my question is this: if we went along with the evidence provided by the Milton Forum that it was built earlier than your report implies, would that make any difference to your recommendation? Because for me, I'm going to find it very difficult to make a decision on this if that remains in doubt, because the first challenge to us will be that we didn't take notice of the historical facts in a correct way. So that's the question, please.
It's a long one. Ian?
No.
You know the short answer. Ian? Or Ezzy?
Yeah, Councillor. Councillor, you're referring to the evidence put forward by the different parties in terms of when it was actually built. And my opinion is that when it was built does matter, because it does point to the ancillary aspect of it and the use of that. And the use also, rightly so, we need to look at the use not just as the use then, but at the use in present time. So how that use have evolved over the period. So how the period was built, I think, links up that relationship to the main building, the St. James's Hospital itself.
Okay.
Surely, can I just ask a supplementary to that?
Yeah, you can.
I mean, if it makes a difference, then I feel we can't make a decision until we've looked more closely at those photographs and those other things, and there is quite a lot of evidence, historic evidence around, and absolutely can be sure. I myself would be satisfied that it didn't make a difference, because it'll be ancillary whether it was built in 1907, 10, 20, 25, 30. But if you're saying that's not, you can't say that, then I think we have to defer to get a proper historical bit of research done, actually.
Chairman, if I can assist.
Please, Kieran.
So it's Ian Maguire. I think just to be clear, so it is not usually appropriate for the planning authority to go and create further evidence. As a general rule, I would say we have, say, details here. There is a point of dispute. The question really does lie: is it necessary to resolve that dispute? As I said, it has a degree of relevance. My personal professional opinion, and it is not no more than that. That's all I can give you. Is that it isn't determinative. Now, clearly, the longer the buildings were there and the more closely they were used for the hospital over a longer period of time, lends more weight to that ancillary activity. However, it is agreed pretty much from the 1926 point onwards, when the buildings were, they've moved on since then. So almost, I would say, irrelevant, because it's not, but in either scenario, I would be satisfied these buildings are not Kirklees listed because of the overall rest of the tests and the overall current situation on site, whether or not they were built and used in a certain way in the 1900s, 1910s and 1920s. The recommendation that these are not covered by Kirklees listing remains the same, in my professional opinion, when I apply my judgment, which obviously has informed the recommendation for you. But it does undeniably, if you think those, had they been there longer, they've been more, in past history, more closely used and associated with the hospital, that does weigh in favour of the idea that they are part and parcel of the heritage and the listing of the building. Whether that's sufficient weight to tip the balance that they are Kirklees listed, that's the judgment you apply. So we can forever research that matter. I would suggest it isn't a determinative one, in my view, and almost irrespective of the outcome, the conclusion is the same, in my personal professional opinion.
Okay, thank you. That's really helpful. Could we be assured that that'll be minuted, please?
Yeah. Okay. Somebody wanted a point of order. I can't remember who it was. It came up. Was it Councillor Atkins? Did you want point of order? But somebody said something on the chat at all.
I wondered if I could follow up directly on that question that Councillor Smythe just asked. Slightly outside, it wasn't a point of order.
Oh, sorry. It was somebody said
it's
something.
a direct follow up on this question.
Yes,
because it is something that's weighing quite heavily on my mind. Is that
yes?
What if what Ian just said was true, I would feel more comfortable determining this. But unfortunately, I feel it contradicts what we've been advised by the QC in the paperwork, and I'll explain why. In the QC's first advice, and perhaps the officers could respond to this. In QC's first advice, he relies largely on the reports that the applicant submitted and comes to a clear conclusion: these buildings are not curtilage listed. He's then asked to later advise, does the Milton Planning Forum's evidence make a difference? And he concludes extremely clearly, yes, it does, and withdraws his effectively previous opinion that they're not curtilage listed, and says now it's a matter for you to decide because there's a dispute of factual evidence. And if I quote directly from the relevant paragraphs on page 176 of his 27th of May 2020 opinions, page 176 in the reports back, paragraph 23, as I said in my previous opinion, whether or not the building is curtilage listed is not a matter of law, rather it's a matter of fact and degree, and ultimately a matter of planning judgment. Okay, that's what the officers have been saying to us very strongly, except that I'm not in a position to resolve the disputed facts. Rather, the council's case officer needs to review the evidence, the competing assertions, and form a view as to which to accept. So the barrister advises the case officer determines the factual sequence of events. He then says that...
Which is exactly the point that I made in my deputation as well. Sorry, Councillor Atkins.
Yeah, he then says, after he's determined that, in my view, if the council were to accept the forum's version of events, that would lead strongly towards the conclusion these villas are curtilage listed. So basically, the barrister to me is saying, if we accept the applicant's set of facts, as he did in his original opinion, they are not curtilage listed. If we accept the neighbourhood forum's version of facts, they are curtilage listed, and the officers should reach a determination as to which set of facts is correct. And unfortunately, I feel today we do not have that. And like Councillor Smythe, I would like this deferred until the officers, according to the barrister's advice, provide us with a determination as to which facts we should accept, more than just a recommendation, an actual determination. And if they feel they need to commission historical advice on that is independent, that is of the council's own commissioning, they should do so. So if the officers feel they can determine the facts of the history of these buildings off the current merits of the evidence they have, that's in accordance with the barrister's advice. They do so. I will reach a decision. If they feel they need more evidence, commission it, fine. Once they've done that and we have a definitive account of the history that we should accept, I'll reach a decision. What I'm not really comfortable doing is reaching a decision when I think the barrister has said you need to pick between the two sets of facts, and actually the case officer should do that. In my opinion, that's the barrister's advice. And I think we should follow that. And so I think we need the case officer to determine the facts, the history, and we will reach a conclusion on that basis.
Kieran, thank you. Kieran, Councillor Atkins is on about deferring it. But is that something that this committee can do, or what's your view on that?
It's certainly within the committee's gift to put forward a motion to defer the item. The context I think the committee needs to understand the report before its day in is that the report has been written subsequent to the two opinions which Councillor Atkins has just referred, and that report has been reviewed by Queen's Counsel to ask, would this report be sufficient to give a robust judgment on this matter by the planning committee? And the answer to that is yes. I appreciate you're really struggling with the fact that there is potentially the discretion of the planning committee here to prefer either evidence. The point is that provided that the committee resolves that point of discretion reasonably, then its decision will stand. It should not be susceptible to judicial review. The report before you is good enough evidence for you to make a decision today, and it sounds as if perhaps if you feel that there is something missing, well, frankly, I'm afraid officers disagree is the response. And as I say, that's been assessed independently by the Queen's Counsel to get you to a decision today.
Councillor Atkins, you know you've got your hand up there. You wanted to write a reply or something there.
So I want to come directly back on the point.
Stagg has been waiting. Councillor Lynn Stagg's been waiting a long time as well. So I do want to go through the questions and the comments and get to that eventually. And then if we need to defer it, someone will put that forward. Sorry, Councillor Atkins.
This is a direct question back to Kieran then. Yes. Should we accept the officer's report of the facts as authoritative as to the history of the building, therefore, and not consider the two competing sets of facts? Because it does seem to me, do you not accept that the barrister's opinion seems to say that if we accept one set of facts, we should reach one conclusion, if we accept the other set of facts, we should accept the other, and the case officer should determine. Therefore, should we not accept the case officer's assessment of the facts? If you're telling me that the case officer's report has been to the barrister signed off on it, and that's an assessment of the set of facts, do we accept as authoritative the facts in the officer's report today?
Yes, Councillor. The wording you're concerned with is Rob Walton QC being concerned that he might be accused of interloping into the decision of elected members. It is not for us as lawyers to tell you what the answer is. It's for us to set the parameters and for you to come to an appropriate decision. I think Ian Maguire would like to speak on this point as well.
Ian.
Sure, I think Kieran has largely dealt with what I was just about to say. I think, yes, it is. We as officers have looked at this, and to be blunt, we prefer the fact.
Sorry, Ian, can I just stop you there? Councillor Donna Jones, you wanted to do a point of order or something, or wanted to say something quickly?
Just following on from something Kieran said, but I'm happy to go after Ian if he wants to finish his point. It's not urgent.
Sorry, I do apologise, Ian. I shouldn't have stopped you. Carry on, sir. Sorry.
So, of course, to be clear, we preferred that option. We feel the evidence suggests they were built at the latter date, and consequently, the barrister's advice, having considered that, he's to say that's an iterative process. That advice is an informed recommendation, and that recommendation has been assessed by the barrister. He is not looking to proffer his opinion. That's not the role. It's a matter of judgment. we've provided our judgment, you are to do the same. The only thing I would want to add to that is, of course, that is advice from the barrister to officers. So he's quite right. It is for, and he's used the word case officer in that case. I would suggest he's slightly misspoken there, because of course it is never for the case officer, it is for the decision maker. All the case officer can do is make a decision on their recommendation. You now need to make a decision on the decision. It's the same, it is for the planning judgment, those that are authorised for planning judgment to do it. Case officers are authorised to provide a recommendation and no more for matters that are not delegated. So the advice applied to that case officer is equally applies to you as a planning committee, and indeed to you individually in casting your vote as members of that planning committee. It is advice to the planning decision maker. In this case, because it is advice to the planning authority, the case officers, he's used the word case officer, but it is equally applicable for you to select those preferred paths. We've done so, hence we brought the recommendation to you, but for you to select your preferred paths, and you can come to a different conclusion, applying your judgment in the same way that Queen's Counsel has suggested the case officer should apply their judgment in finalising their recommendation.
Thank you, Ian. I'm going to come to somebody different now, and obviously if other
Can
councillors...
I do my point of order now, if that's okay?
Yes,
please?
sorry. Yes.
Sorry, Chair, to interrupt you. I apologise. Yeah, I think we've just got down to the nub of the second point now, haven't we? Which is it case officers, or is it us as planning committee, the local planning authority, to make the decision? The barrister's advice, I made this point in my first comment. Councillor Matt Atkins has repeated it, I think, twice now. I'll say it again. The case officer, the barrister did say the case officer. Well, to me, in planning speak, a case officer is very different from the local planning authority, as in the development control committee. And Ian's just said that it can be either or. It could be the case officer or it could be us. That begs the question then, why is it here? Because it appears to me that the case officer has made their recommendation in the report. I've got two computers going on here, which I'm reading. They're telling us that they don't believe it's within the curtailage. So if they've come to that opinion and they've been considering this for 2 years, bearing in mind we've only become aware of this issue again on Friday of last week when we had our pre-committee discussion in private. So, you know, we all then became aware of it. We started scratching our heads. So as lay people, we've considered this for half an hour, 20 minutes on Friday afternoon, now over an hour today. This is a key legal decision. These professional people, by the way, that work for the council, they've been considering this for a really long time. They're the ones that have been asking the barrister the questions. They're the ones that have been asking supplementary questions to clarify. They're the ones that have been reading the case law. They are the best people, therefore, to make this decision and not us. I reiterate that point. And as we've just heard from Ian Maguire, our Assistant Director of Development Control and Regeneration for the City, it can be made by either or, by the case officer or by us. And what the barrister meant was it could be either or. Well, he did say case officer, but all right, okay, for latitude, it could be us as well. I accept that point, and I don't dispute Ian at all there that we could make this decision legally, but I don't think we're best placed to do that, and I think the members need to give that a lot of consideration today.
Ian?
Yeah, Chairman, I think I do need to provide a clear clarification. As I say, the barrister, when he said case officer, he is talking to that person exercising planning judgment. There is no other interpretation for that. Yes, case officers are not the planning committee, of course they are not, but advice to someone exercising planning judgment is the same, whomsoever exercises that planning judgment. The point that's just been made, Councillor Jones feels that officers are the best people to make that judgment. Clearly, it's a complicated matter. We have therefore provided you what we believe is a robust and clear recommendation. It's a complicated matter, undeniably a complicated recommendation, but it is a matter of judgment. Therefore, you are entirely qualified to apply judgment. That is your role as members. That's what you're placed on a planning committee to do. And consequently, we have been asked to bring this matter to the planning committee, and I'm quite...
Who's asked you to do that, Ian? Could you tell us that, please? Because that's a really key point. Because as a committee member, I've never been referred to as a case officer in law, in layman's terms, in this council ever. So could you tell us who's asked you to bring this to committee?
I've asked the team to bring this to. So I'm sorry using the third person there. Apologies, because under the scheme of delegation, where matters are highly contentious, the assistant director has the authority to say, I think this is a matter of contention that would benefit from an open decision by the planning committee, not one by individual officers. So I have utilised my authority under the scheme of delegation to bring it here, because it clearly is a matter of clear contention and involves our only neighbourhood forum, a key stakeholder in the city. So that's why it's before you. You are therefore obliged to come to a conclusion on the matter, on the information available to you. That's the role of the planning authority. And to be absolutely clear, I don't want you to get hung up on the issue of being called a case officer. I am interpreting the barrister's advice. That's our role as your officers, and advising you advice to when a barrister gives advice to a case officer, what he is doing as a matter of fact is giving advice to someone exercising planning judgment. You are people exercising planning judgment, and consequently that advice is equally applicable to you. So you say everything in that extract of the barrister's advice where you're saying you need to come to a conclusion to help, and that's a matter that is important to that determination. As I said earlier, it is absolutely relevant to the consideration. How determinant it is a matter of judgment, the weight you give to the evidence and information available to you. In my professional opinion, when I'm exercising my planning judgment, whether it's built on one date or the other doesn't actually change my judgment, though I'm of the opinion that the applicant's evidence is the more compelling. You can clearly come to a different opinion, that the neighbourhood forum's evidence is more compelling. You can come to that opinion and still conclude that they're not carefully listed when you look at the rest of the tests in the round. It is that series of interrelated judgments you need to make, and then you need to balance those judgments together to come to a conclusion as a planning authority.
Chair, on that basis then, because to me the barrister does say, and then it's for the case officer to make the decision. So on that basis, and on the basis of previous years on this committee, I'd like to make a proposal that the committee does not make it, the committee abstains on this point today, and that the decision is passed back to the professional officers who have the legal training and have been dealing with this for many, many, many months, in fact almost 2 years, to make the decision for this committee.
Thank you very much for that. I know Councillor Lee Hunt's chat isn't working, and I know I've got Councillor Lynn Stagg, so I'm trying to obviously get as many people as possible in. And I know Councillor Stagg has waited a very, very long time. So if you don't mind, I'm going to go to Councillor Lynn Stagg, who's been waiting a long time, and then I'll go back to Councillor Lee Hunt, and then obviously we can still carry on for as long as it takes, members. So I'm going to call now Councillor Lynn Stagg, please.
Thank you, Chair. I have been very patient. Before I ask a question, I just make 2 points. One is, if the villas are accurately described as Edwardian, they would have had to have been built between January 1901 and May 1910, because January 1901 is when Victoria died and Edward VII came to the throne, and he died in May 1910. So he would have had to have been between that time. And if you look up the history of his St James's Hospital, County Asylum's website, which is very, very accurate, records that on October the 31st, 1908, 4 detached villas were opened, and those were the ones that are now, or 2 of them anyway. Right, my question is, and I don't understand, why was West Lodge considered to be within the curtilage in 2017, but the Fair Oaks and Beeches are not today?
Ezzy.
Thanks, Chair. If I can call upon Alan Banton, who probably has more knowledge of the history of this site than anyone here today.
Alan?
Thank you, Chair. Forgive me, I haven't had any previous dealings with West Lodge or what evidence was presented around the issue of curtilage listing. So forgive me, I can't assist with this, I'm afraid.
Can anybody assist with Councillor Lynn Stagg's question there, please? Any officers?
Unfortunately, Chair, that was something we probably need to dig up. That history of that application or that building in question. So,
Ian, did you want to? Yeah. Sorry, can I go to you, Ian?
Yeah, the only thing I would add is that it's the standard advice we can always give you, that every application has to be assessed on its own merits. I can't recall top of my head when the West Lodge decision was made, nor indeed what process that decision went through, and whether therefore there was any specific issue. Obviously, everything will have to be judged on its own merits. The status can change as circumstance changes, as you know, we've talked about what would happen between 1905 and 1926, and obviously what happens between date X and date Y does change the matters. It is therefore for members to determine these lodges on their own merits. Now, I entirely understand the point you're making, Councillor Stagg, and apologies we don't have more information on that judgment when that one was made, but we are satisfied on all the evidence that's available and the extensive opinion and background that has been provided with this report, that there is enough information to make a judgment here today, but as always, for individual members to come to their own judgment on that matter.
But that doesn't satisfy me, because that's giving me two contradictory conclusions made by officers, as far as I see it, without the evidence. I'm not saying that they are contradictory, but what it appears to me, because I haven't got the evidence, and then makes me a bit concerned about, do we accept officers' advice on this?
So to assist us as far as we can do, so as you say, they're not contradictory. The council is required to act reasonably and consistently. I don't have the information, but I have absolutely no reason to presume the council made an incorrect decision before. So on the individual facts and merit of West Lodge, it was deemed to be one status, and in the individual facts and merits of these lodges, officers' recommendation is that they don't benefit from that status. Everything will have individual facts and merits, and obviously comparing those will help you judge whether you prefer the opinion of the officers there where there is similarity, but it will be no more than that similarity. So consequently, we are satisfied that there is sufficient information to make that judgment now, and the only presumption one can make is that the council acted appropriately on that judgment and on its own merits then came to that conclusion. You're obviously required to look at the own merits of these schemes in front of you today.
Okay, Councillor Stagg, did you want to come back before I go to Councillor Lee Hunt and then Councillor Luke Stubbs?
Just to say I'm not happy. I would like to have the evidence, and I appreciate that it's not available at the moment. But I mean, if there's a genuine reason for the differences, that's fine. But without that evidence,
we're not on comments yet. It's just questions at the moment. But I understand how frustrating you are, Councillor Stagg. Councillor Lee Hunt, and then I'm going to move over to Councillor Luke Stubbs. Councillor Hunt, for questions, please.
Yeah, I understand his questions and so on. I've been listening interestingly all the way through. And I suppose on the previous 2016 report we heard about earlier on, I don't know if the planning officer would agree, but I don't think it would materially impact upon my thinking today. I mean, I'm sure he'll agree with me that we have all the proper information today to make a informed decision. We have several Queen's Council. If it's gone on to the date, I mean, I've heard about the date of the building, but we've had documentary proof, which is in the chat bar at the moment, documentary proof that these villas were built in the time that the Milton Neighbourhood Planning Forum tell us that they were built. And we can shake your head, Councillor.
Point of order, Chair.
I mean, no, come on.
1 second.
Councillor
Hunt, Councillor Hunt, 1 second, please. We've got a point of order. Councillor Terry Norton, please.
Sorry, Councillor Hunt. I forgive me for interrupting, but I do think we're in a strange situation here where we could be going against standing orders. The stuff, my understanding is the information in the group chat isn't public. It is a public meeting, and therefore it should be accessible to the public if we're making decisions based on information that's been put into a private chat. And I don't think Councillor Dowling has any intention other than trying to be helpful. But if comments are being made by deputies that are not in public view, I think we're in a very tricky, precarious position there. Also, my experience of planning is that deputies don't have the opportunity to come back and comment further. I don't want any previous deputies to feel like we've another office.
Very happy to accept that point. The same photograph was produced by Councillor Jeanette Smith in her presentation, and she showed it to us. So whether it's in the group chat or whether she showed it to us, the documentary evidence has been produced. I can see absolutely no reason whatsoever at all why there should be a reason to defer this today. All the evidence is there. We're not going to get any more evidence. And quite frankly, this is all rather bizarre to me because we're perfectly competent at making decisions. We do it all the time. And we should just carry on and get to the end of this today.
Thank you. I've got lots of people wanting to join us. Councillor Judith Smythe, did you want to come in? And Councillor Donna Jones again. Did you want to come in at all? If not, I'm going to come to Councillor Donna Jones. No.
No, not me, Chair. That must be from before. Sorry.
There's lots going on in the chat here, and I'm trying to keep an eye on it. And yeah, I know, Councillor Atkins, you've still got some questions. I haven't moved on to comments yet, as you know. I'll give everybody a proper chance to talk. Councillor Judith Smythe, please.
I mean, this is a question pursuant upon Ian Maguire's statement that the word professional planning officer is applied to any decision maker. In which case, as decision makers, we should decide that we take the council's advice and investigate properly the history of the site. I mean, I think I am fairly clear on what my view of this is, and I do think I've probably got enough information to make a decision, but I don't think that I can possibly feel that we should make it on the basis of a report that has some of its facts that might or might not be wrong, where we've been told that might influence what's in the balance either way. So I don't think we've got any alternative but to ask for a deferral while that matter of the history is, which some people think is significant, not sure I do, but some people do, is resolved. Am I right in that judgment or not?
Kieran?
Thank you for the question. I reiterate, the officer position is that you have a report with you today that is robust in terms of if the committee were minded to go with it and accept its recommendation. That is on the advice of Queen's Counsel. However, as I've also been labouring throughout this committee, it is within the committee's capabilities in its entitlement, if it has cogent reasoning, to disagree with the officer recommendation. If part of that is that you don't feel there is enough evidence and you wish to defer, you can, of course, do that, but you have to consider how long a deferral and for what ends. What is it that you want? Are you able to guide officers any more on that? Because officers are quite clear that you have the material before you today to come to a decision.
It would simply be whether the building was built in Edwardian times in 1910 or at a later time. I don't think, and that would clearly satisfy quite a lot of people sitting around the place. It might not, it would weigh in the balance. We were told it should weigh in the balance, and but the balance for some of us might not change, and for others might.
Okay, I hear that. I think, as Ian's already said, the only thing is that you can get an opinion, but will that necessarily lay the matter to bed for everybody permanently? Will there become what may an amount of disagreement? It's entirely within your capacity again to probe that, but you do need to think about, is it going to be a first, second, third opinion, so on and so forth. The advice today is that you have enough information.
Okay, it's what Councillor Matt Atkins said, which this is a matter of fact. It's not a matter of opinion. And if we haven't got the right, and I would go for deferral while we get that matter of fact sorted out. Because the other thing is that we don't want a reputation for having ignored facts that we seem to have got proof of. We can't have a reputation of a planning committee that overrides facts, even though they might not weigh very heavily in the balance for some of us or any of us.
Okay. I understand where you're coming from. I'm going to go to Councillor Luke Stubbs and then Councillor Atkins again to ask some more questions. Councillor Luke Stubbs, thank you for being so patient, Councillor.
No problem. I've got a few questions, but the first one I would like to ask is, when Historic England assessed these two buildings individually for listing, what was their range of options and what things did they look at when coming to that decision? Was one of the decisions they could have reached to have found in favour of curtilage listing at that point, or is it a wholly separate matter that they were powerless to consider?
Who would like to answer that one? Alan, you've come up.
The judgment that Historic England were making was whether the villas were of sufficient merit for listing in their own right. So do they have special architecture or historic interest sufficient to warrant listing in their own right? That was the only judgment call for them.
So just for clarity, the range of options they had available did not include a finding in favour of curtilage listing.
That wasn't what they were asked to consider. I mean, I have gone back to Historic England and asked whether they would ever consider weighing in on the argument, especially when it is sort of finely balanced. And I got the answer from them that no, that ordinarily they wouldn't. So it isn't what they're asked to do to consider listening in their own right is a quite separate issue from whether or not fact and degree they're curtilage listed. Completely separate.
Councillor Stubbs, happy with that?
Let me just check my other questions I've got because some of them they've come up.
Yeah.
Let's see now. In the event that we extend the listing in this way and Homes England or the applicant is unhappy, they don't have a right of appeal, right? Their only appeal is in effect for a judicial review. Is that correct?
Who would like Ian?
So the two outcomes are obviously it's a resolution of this committee, and as such, they could consider judicial review. Whether the courts would even entertain judicial review is a matter of question, I would say, because obviously it's a resolution to inform a further judgment. It's that further judgment is where that appeal element comes in. If obviously the officers, the local authority will act on the resolution of the committee. So if we effectively require them to submit a list of building consent or refuse the application for a harm to designated heritage assets, then they have a standard route of appeal against that refusal through the planning inspectorate in the normal way. So that will be available to them, but it would form that tertiary step. This is to inform the judgment of are they designated heritage assets or not, and then obviously that would then inform the judgment, and if then refusal or conditions associated with that matter are imposed, they have a right of appeal to the Secretary of State in the normal way. They currently, of course, have a right of appeal to the Secretary of State available to them because the application hasn't been determined within the statutory time period, so they could appeal for non-determination at any time, so they have that right, but obviously they're keen and happy to work with the authority to settle this question and have been, as you've seen, participating in providing opinions and advice and evidence to enable you to make a judgment in this case.
Okay, my only other outstanding question, so if West Lodge has been interpreted as being curtilage listed, we also had a recent application for a care home on Forest Lodge, which didn't have any listed building status or any consideration, I don't think, in that planning application. So why? I mean, if West Lodge is curtilage listed, and we're saying that it is, then why is it that Forest Lodge, this question didn't arise at the time the planning application to develop Forest Lodge came forward?
Who's going to answer that one? Ian, again, thank you.
Members, I'd have to quickly go back and check through the report, but Forest Lodge, from recollection, didn't involve any demolition of buildings, did it?
There was a building on. There is a small care home building on that site.
Again, it's the overall conclusion, therefore, without going back and reading through the full report, was clearly that it wasn't a matter that was considered relevant. There was no suggestion that that building was covered by Kershaw's listing. Obviously, the traditional parkland of St James's has got all sorts of things in it, and clearly there will be areas within that where no one is of the opinion that structures that may exist in there would benefit from Kershaw's listing. Without double checking the full write-up of that recommendation, I would anticipate that was the outcome. In that case, it simply was not a matter considered relevant to the determination because that building wasn't in any way suggested by any party to benefit from listed protection, and certainly considering from my own recollection of the site, we obviously are a substantive distance away and a different relationship to even the structures we're talking about here today.
Councillor Stubbs, you happy with that? Okay, then so Councillor Atkins then, please. You wanted some more questions to the officers, please.
Yes, thank you. Basically, you know, carrying on so assuming I was going to decide the question of fact of when these buildings were built and what exactly they were used for over that period of 20 years. Reference is made to 7 villas on the site. Can you confirm how many are still standing, and do we have pictures of all of them?
Was that Ezzy or Ian? Ezzy?
Thanks, Chair. I haven't got photos of the ones that were demolished. I believe a couple were demolished, some villas were demolished previously. If I might call upon a colleague, Alan, who's been here longer than I have, who might know a bit more about the sites and what demolition has taken place previously. Just one moment. Alan, please, can you...
It's more a case of I'd like to see the pictures of the ones that are still there, as in how many are still there and what do they look like?
The ones that are still there, I believe there's photographs on the appendix of the reports showing the ones that are still there, and in the I believe I shared a photograph on my presentation slide, if that would help.
It would be helpful if you could just show me quickly, because there were so many documents and so many different buildings pictures in the report, and also there's the 2 different names used for them. So my understanding is that historically we're talking about Dickens and Brunel. Is that correct?
I've not heard of those before. The ones I have in front in the presentation is the Beaches and the Fails.
Yes, my understanding is that's the same building.
Okay.
But the contention of the neighbourhood forum is I think they were built at the same time in 1905 as 2 others called Pink and King. And my opinion of the photograph showing the soldiers, from what I've seen, is it would have to be in front of either Pink or King, because the 3-stage window in the middle of Dickens and Brunel is a different shape. The central window has 3 portions to it, not others. Whereas I think the window design behind the soldiers in the World War picture, and perhaps you could confirm this for me, only corresponds with King and Pink.
Just have a look at that photograph, and I would put up the photograph that I have on the presentation for members, and hopefully that might provide some clarity. Just one moment, I'll just get that up. Share my screen. Okay.
Yeah, so in the centre of that, which I think is either Dickens or Brunel, there's a clearly different 3-point window, isn't there? And it's a wider frontage than the picture of the soldiers, where we can see virtually both edges. Whereas if we look at a picture of, I don't know if you have a picture of either Pink or King.
Unfortunately, Councillor, I can't see what you're seeing looking at these photographs. I've had my presentation up. Unless I was to stop presenting, then I would be able to go back again to that.
Yeah, but perhaps others in the committee can see what I'm saying. The centre of the building is clearly different, but the centre of the building does correspond to pictures I found online, I mean not in the reports back, of Pink and King. So my follow-up question was then going to be, what evidence is there that all four might have been built at the same time when they're actually of slightly different design? Because I think the contention of the Neighbourhood Forum is all four were built at the same time pre-war.
Indeed, that's what you said, yes. I'll just come off from this presentation. Just a moment.
And I wasn't even sure if people would stand or not. It's something I don't know about the site, and unfortunately I wasn't able to attend the site visit yesterday, organised at rather short notice.
Yeah, I think when one is looking at age and character and design, I think there's a couple bit fine details one looks at. That would be the bonding of the bricks that are used, the separation in terms of windows, and again it will be the height of the windows with the patterns at the corner posts and the cornices, and the type of roofing in terms of the pitch and the height. I think there's some features that are consistent that will carry across, giving an indication of when they were built, if they were built in the same period. Because it's unlikely that the bonding for the bricks would be different for if they were built at the same time.
So I didn't see any comment in any of the reports referring to an assessment of the four buildings and whether or not they were built definitively at the same time. Certainly the Neighbourhood Forum have asserted that there's a document ordering them pre-war, but is there any actual definitive evidence about when they were actually constructed? Because it strikes me that the two pairs of names, Dickens and Brunel, go clearly together, as do clearly King and Pink. But I don't know that all four necessarily clearly correspond. Two are his sort of famous figures from the Victorian era, two are local figures. This is kind of what I mean by, as soon as I start examining the factual evidence, I feel like I'm short on a lot of information. Because to me, the Neighbourhood Forum is asserting, with some valid documentary evidence, ordering pre-war, and four villas built at the same time to expand the capacity of the hospital, thus giving a very close link in function between the hospital and the four villas, not just in terms of them being on the same site. Whereas the applicant asserts the idea that you have the hospital and then later the separate purpose of housing private patients, which arguably is makes them more independent structures, makes them independent in use and function, less likely to be curtilage.
I'm getting feedback. Sorry, I'm struggling to hear you guys.
Sorry, I think it's possible. Maybe if you mute your microphone, you wouldn't. Yeah. So what I was saying is that I've started. Are you still struggling? Still struggling? Are other people struggling to hear me? No. Seems to be an issue, perhaps with Ezzy. But I mean, perhaps one of the other officers can address it. But is there any definitive evidence? So let me break them back down into my individual questions.
Prevarication.
Councillor Hunt, I think you've got your microphone.
Yes, it doesn't change. We've had 3 hours of prevarication so far.
Yeah, I know, Councillor Hunt, but everybody has to be heard, I'm afraid, including yourself.
The contention is we can reach a finding of fact on these decisions. I'm going to then interrogate the facts. And I'm sorry, Councillor Hunt, if you just want to make a decision, pulling it out of your backside, but that's not what I think we have a responsibility to do. There is conflicting evidence. There is some evidence presented by the Neighbourhood Forum which is compelling, which I think is perhaps not as compelling as the way in which they've presented it, because they have a clear piece of evidence that the construction was ordered at a certain date, and a clear piece of evidence that there were some villas on the site during the war. But to my mind, they don't actually have clear evidence of the two in question, which do have a different design, do have a somewhat different name. And then in competition, we have our planning authority presenting us with evidence which is based on mapping that the two in question that we're asked to decide about today were not there pre-war, and in fact potentially not there until the 1920s. And the Neighbourhood Forum calls that legitimately into question. But I don't think either side of actually presenting, and this is kind of what I'm putting to the office, neither side is actually presenting anything like what I would consider definitive evidence one way or the other. Would you agree that isn't? that is an accurate description of the two sides' evidence. Both of them have significant flaws and significant holes in them.
I wouldn't say there's significant flaws, Councillor. What I would say is that both sides have presented evidence which the local planning authority has to make a judgment call which evidence to accept. And this would be the normal situation in any dispute. Evidence is presented and the judgment call has to be made. And it's again, it's an opinion that the LP has arrived at by looking at the evidence in front of it.
Thank you. Any more questions from members?
Yeah, I mean, so another question I had. I think I'm going to leave factual questions there for the reason I actually don't think we have a historical expert here who is actually able to answer. Because one of the other things I was going to then interrogate is, the Neighbourhood Planning Forum have submitted as a document that is full of references to historical evidence. Have our planning officers actually reviewed the primary evidence, or have they only read the Neighbourhood Planning Forum's summary of the evidence?
I think we should
have officers reviewed the primary evidence in the submission of the Neighbourhood Planning Forum, or have they just seen the Neighbourhood Planning Forum submission?
Yeah, who would like to answer that? Ezzy?
Yes, Chair. Thank you, Chair. The evidence of both parties were reviewed.
So the Neighbourhood Planning Forum submitted all their primary sources and documentation, and you went through all of it?
We went through the summary of what they provided.
But not through the primary. So did they provide you, for example, with they refer to at least 2 books. They refer to historical documents of which they have pictures. Did they provide you with photocopies of the historical documents? Did you go and review in libraries where they said you would find these documents, or are you relying on their evidences?
Councillor, what we did was look at the evidence, and the evidence that we reviewed is included as the appendix 1 of that report, and that's what we looked at. We didn't go.
So everything you've reviewed, you've provided to the committee.
Yes.
Yeah.
Correct.
And I think that's perfectly fair enough. But if a court was reviewing this, they will want to see the primary source material to decide the facts. And so either they would want an expert to review it and testify independently, or they would see the primary source material. So I do think, we are falling short of the level of evidence a court would review if making this decision, and I do think we are at risk afterwards of this resulting in a court case, in my opinion, on factual evidence we've been provided.
Yeah, I think, Councillor, if I might add there, I wouldn't say the court would require an expert to give that advice. I think it would be the parties that present that, and we will put up their own experts forward. And in something if we were to an inquiry, it would be them putting forward, not the inspector asking them to get a specialist or an expert in that field. We've looked on the documents been provided by both parties, and we made a judgment call or an opinion, offered our opinion based on what's been put in front of us.
Thank you.
Yeah, and I'm not meaning to criticise officers anyway. I think you're in a very difficult position, like we are. I just think that with the legal risks that lie here, I think it probably would have been a better officer made decision. My last question then just relates to one final thing that the QC said in his opinion. It talks about the report that the applicant had commissioned. This is on page 170 of the QC's opinion of the 21st of June 2019, so his first opinion. And at bullet point 2 in paragraph 17, it says, the report says that despite their proximity and historical associations with the hospital, the 2 buildings ceased to be a single unit with it. And it says it's not quite clear what this means, when this is considered to happen, or why the conclusion is reached or needs to be revisited. And another thing I felt in terms of the evidence is, like that the QC says, we've heard remarkably little about what happens throughout the continuing life of the hospital, either from the Neighbourhood Planning Forum or from the reports. Was that question ever addressed that the QC directly asked, this needs to be revisited? Could I find the revisiting somewhere of them ceasing to be a single unit at some point?
Is he? Or was Ian still with us?
Yeah, sorry, Councillor. I'm trying to go back to the the QC's opinion and go through that as well as we are talking. If you give me a few minutes, I can
sure.
through that,
Page 170 of the public reports pack. It's the bullet point 2 on the page that you see.
So you said this is the second opinion, the first opinion of
This is the first opinion. So the report may well have been revised to cover this point, but I just wonder if you could draw my attention to exactly where it was revised to cover the point raised by the QC in point 2.
So, sorry, I just need to take you back just a step bit. The first opinion, what paragraph of the first opinion? Sorry.
17.
17.
On page 170, because it carries on over the page.
Yeah.
Kieran, you're lit up there. Did you want to say something?
Yes, I can assist with that. This is the report that's being referred to will be the report that went to the committee in February 2018. So that report has been rewritten because officers were concerned at the time that the curtilage issue wasn't dealt with adequately. That's part and parcel, forgive the pun, of why we're here today, to iron that out. So in reviewing the report for today's meeting, it can be taken that the QC is happy that that point has been resolved.
So was it withdrawn by the officer, or was it clarified and strengthened? Is kind of what I'm getting at. So is it still the officer's opinion that they ceased to be a single unit, or is it now the opinion of the officer that they did not cease to be a single unit, or never were a single unit? It just was an odd question.
So the position, this is kind of goes into the difference between what the High Court and the Court of Appeal found in the Blackbush case, is that you are now addressing the part and parcel test, and that's why the SMAT report referred to the change to that first sentence. You're concerned with part and parcel, not the integral unit.
Okay. Sorry, what's the difference? Sorry.
The difference is the High Court, throughout the case law, there's a little bit of ambiguity between competing phrases. The High Court felt that perhaps this language of a single sort of integral unit was appropriate. The Court of Appeal said, no, we actually think that just stick to the part and parcel. That's all we need to focus ourselves on. It's unhelpful to have this sort of second phraseology bubbling under the surface. So that's where we are with that. So yes, I'm not surprised that reference to cease to be a single unit with it would not appear in a subsequent report, because as I've said earlier, we've updated the line that would address that in relation to the SMAT because of the Court of Appeal case.
Okay, thank you. I think I'm finished, Chair. Thank you. Thank you very much. Sorry.
Members, I think we have to start sort of coming to comments in a minute. So any more questions before we move to comments, please? It's been 3.5 hours on this one. Okay, I'm going to move to comments now. Councillor Atwell, I know his chat isn't working. So Councillor Atwell, comments please about the presentation. Councillor Atwell, first of all, please. No? Councillor Atwell? Hello? Hello? Anybody there?
Apologies, Chair. I'm having to deal with a family issue at the same time.
Yes, you had.
Yeah, do you mind if I take that call?
I'll come back to you then, Councillor. Okay, sorry. Any councillors for comments, please? Okay, Councillor Judith Smythe, please. We're on to comments.
I'd like to propose that we do defer this. I hate deferring things, but I do think in this case, with a dispute about things that we can prove the history, that's the only alternative we've got. And I'd like to formally propose a deferral on just so that we can find out the history.
Thank you very much
Is
for
there a
that.
seconder? Is there a seconder for
Yeah,
that?
I'll get to that in a second, Councillor. I just need to go through for comments first of all. I've got that written down. Councillor Terry Norton was next. Comment, please.
Yes, thank you, Chair. My comment is simply that I don't, when we're talking about situations like this and we hear things like, the evidence isn't ideal, it doesn't fill me with confidence at all. I'm not convinced either way with this, and I just don't think that we are best qualified or will ever really be best qualified to make this decision, and therefore I'm inclined to second Councillor Jones's proposal that she made earlier on in the meeting.
Yeah. I'm aware she did actually propose it first of all, actually. So I know Councillor Jones did say right at the very beginning she proposed that it would be deferred. So if I could take that as if that's still the case, Councillor Donna Jones, is that still correct? As for deferral?
Well, no, actually, I was
changed.
proposing to delegate to officers, but actually, having listened to the conversations around evidence base, I'm minded on the deferral. So I think Councillor Judah Smythe's got a point there, I have to say.
Okay.
So I'm sorry, Councillor Norton, I'm going with, I think I'll be supporting a deferral as opposed to a delegation.
Okay, thank you. Kieran came in, wanted something as well. Kieran?
I'm grateful to acknowledge that Councillor Jones has withdrawn her motion. As just a comment, the oddity of the motion that Councillor Jones was proposing was to delegate it to officers when officers have already made a decision. So in effect, that would be taking the officer's recommendation, logically, in my mind.
Yeah, but making the point that we're not the correct body to make it, in my opinion, so which I was entitled to do, Kieran, and I have withdrawn that, but that was the basis for it for the public.
So in essence, you would just be wanting the committee to hear all of the different facets in the round rather than as a preliminary issue in that way.
Councillor Jones? Councillor Jones, is that correct?
Yeah, I mean, look, I can't say whether I think this is the right, whether I think that we should be, whether there is a curtailage issue here or not, whether the Milton Forum have got a really valid point, or the barristers and the council officers. I can't reiterate it enough. I don't think that we're the correct body to do this. However, I do think that rather than me saying today we should be, because what I don't want to do is just get delegated to officers and then they just say there's not an issue, because actually a lot of valid points have been raised, a lot of questions have been raised today. I think the Milton Forum have raised some really good points, and it has really made us all think about this, but we've only been thinking about this for 2 hours, and this is a really big decision that's going to affect a whole neighbourhood, that's going to affect roads and schools, and we're not talking about 3 or 4 houses here, we're talking about 107 houses. So from my perspective, I am prepared to withdraw my delegated to officers, because I think that if we do have more evidence to come back, and one of my colleagues, Councillor Smythe, has proposed that, which I think is a sensible recommendation, and therefore I'm saying I'm going to withdraw my proposal, because I think it might be that in 2 or 3 months' time, or whenever this comes back, members have got sufficient clarification to be able to make a decision.
Okay, thank you. Noted. We'll sum up later on when we're back to the voting. Who have I got next? So I've got Councillor Terry Norton for a comment. Sorry, Councillor.
No, I've made comments. Sorry.
Oh, sorry. Councillor Lee Hunt, then, followed by Councillor Atkins. Councillor Lee Hunt.
Right. As we've been told by the legal officer, we are the proper decision makers in this matter. That is beyond doubt now after all this discussion. So on those grounds, we should be carrying on today. We can't abrogate our responsibility. Officers, when we're elected to put into our roles to make this decision today. Just carrying on from what Councillor Jones said just now, we are not looking at 170 homes or anything to do with that. That's conflating the issue. That's been going on all day, along with the prevarication and obfuscation. And we are looking at whether or not these 2 villas should be curtilage listed. There is plenty of evidence that we're being given, not least from several QCs, which we should all have read. I'm beginning to wonder if anybody's actually looked at it. I'm sure most of us have. And we've got an officer's report. Now, some of us agree with the officer's report, and some of us do not agree with the officer's report, and some of us agree with it for different reasons, and some of us disagree with it for different reasons. But that's the nature of the business at hand. And to simply want to put it off, for whatever reason, to a later date, to me seems quite wrong. We've had further legal advice, so all the evidence we need to make up our mind is here today, so therefore I won't be supporting the deferral, and I would ask the other members to carry on with the discussion today.
Thank you, Councillor Hunt. Councillor Matt Atkins.
I would like to second Councillor Smythe's motion for deferral. I read all of the QC's opinions very carefully, and that is in effect why I'm asking for deferral, because I think we have had it clarified that we do need to determine issues of fact in order to apply the test. To my mind, the way the test works, it is actually a very important question when they were built and how much they were integrally involved with the business of the hospital as it was originally set up, and how much they were set up almost as a separate business of taking fee-paying people who needed treatment later under different regimes. And there are other questions which I've not got. I've not even discussed my view on the landscaping and planning part of the test. Fortunately, the part of the test of ownership is determined already. So there's a lot still that I could be saying and could be going into in great detail. But I think the factual element around the historical harm is important, and I think that relates to when the buildings were built, and I think the factual element around use and function makes the question when they were built and how they were used. Were they indeed supplied from the same kitchen? All quite important. And the barrister, as far as on my reading, says very definitely that if we were to accept the neighbourhood forum's version of facts, we decide one way, and his first opinion strongly suggests if we accept the applicant's version of facts, we decide the other. And so I think we do need a clear sort of at least evidence based on which to decide that. My preference would be that the officers, and I don't know how Councillor Smythe wants to exactly word the motion, my preference would be that the officers decide the history, but in the alternative, provide us with a substantial body of historical evidence, perhaps on the basis of an independently commissioned report, on which we can determine the issues in dispute between the neighbourhood forum and the applicant's historical evidence. And so that Kieran asked that we say that what we want, that's what I want. Either a determination from the officers of the historical divisions, or that we use as the basis for our decision, or a more substantial evidence base, possibly on the basis of an independent historical report, into whether or not we should accept the applicant's evidence or the neighbourhood forum's evidence where they conflict. So for that reason, I support Councillor Smythe's deferral recommendation.
Thank you very much. I think Councillor Donna Jones got in there. I think who's seconding that. If I'm quite rightly, I'm sure Kieran at the end may tell me. No, you're not. Sorry, Councillor Jones. No. So at the moment for deferral, I've got Councillor Judith Smythe and I've got yourself, Councillor Matt Atkins. Is that correct? Yes. Right. Okay. Thank you very much. As long as I know what's on the table in front of me, that's important. So any more comments then, members, please, before we go to yeah. Okay. What have we got here?
Yeah, sorry, Chairman.
Yeah.
I've put in for
it's
a comment.
Getting a long day for me, sorry. Yeah.
It's only a brief one. I mean, so it's taken over 2 years to get from the original deferral when this actually came in front of the planning committee. It's taken 2 years to get a QC's report put together. I don't know how, quite honestly, it's taken that long, but it has. And so, you know, I think a deferral, so we can make sure that any decision that is made is sound, is absolutely essential. I think it is highly likely, whichever way, if the committee were to make a decision today, whichever decision that will be, is highly likely that there will be an attempt by the aggrieved party to litigate. Now, of course, it may get filtered out through the court, so you can tell. But, you know, if this is something that's going to be challenged, we or whoever will be representing the council in that case would need to be able to demonstrate that the council has done everything it can to establish the facts in order to demonstrate that whatever decision was made was a sound one. So I don't think we've got any choice. I think to make a decision on this now, we'll be putting the council in a dangerous position in court, and we have to avoid that.
Okay, I know Councillor Atwell had a phone call earlier on, and I know he wanted to do some comments, wanted to do it. So is Councillor Atwell back with us at all, please? And could he just confirm that he's been listening to everything that's going on?
No, I have been listening. Thank you for bearing with me. Thank you for bearing with me, Chair.
That's fine. So you've been hearing what's been going on?
I've heard everything. I think it's really clear that I think the burden of proof placed upon us this afternoon was the balance of probabilities rather than beyond reasonable doubt. So if that's what we've been asked to make a judgment on, then surely we should just do that. So that's my position. Carry on.
I'm looking somebody to second Councillor, because you proposed, Councillor Hunt, haven't you? It's come back to you. You've proposed.
Sorry, Chair. Would we both I understand we're both on a deferral.
Yes.
And I don't agree with that.
Right, okay. So you're not proposing anything else at the moment?
No, we haven't even had the debate, Chair.
Okay, all right.
I just want to say, Chair, that I would like the objective would be that the Milton Forum and the council officers agree on the most likely, on the truth, really, because these are facts we can find out. I'm looking for an agreement on when the building was built.
Okay.
Based on historic evidence.
Ian, did you want to come in?
Yes, if I may, just to manage expectations. Obviously, what we can do, I'll have to speak to the administration around budget, is commission, as has been suggested, an independent historian to come in and create evidence if you feel that is necessary and reasonable. To be absolutely clear, officers have taken advice, and we don't feel that is necessary. With the QC's advisors, you have right information, but it is your decision to make. We can create that independent evidence to say, right, there you go, and we can, as officers, validate that to our professional satisfaction. We can make no guarantees third parties will agree it, and I would not be seeking to create something that is, in fact, everyone, experts on both sides, historical experts for the applicant, have concluded that there is uncertainty here, and it's not clear and not capable of being clear when these are built. We can go and redo that work with an independent person. I wouldn't suggest the applicant's expert have done anything improper, of course, but with an independent person. But I can't guarantee that any third party would agree it before we can bring it back to the committee.
Of course, you can't guarantee it, but a shared process would be much more helpful, where all the available information is looked at, including what they've looked at. I don't even know to make a difference to my decision, actually, but I do think we can't go in, as Luke Stubbs said, with a risk that will be seen as not having taken things into account properly.
That would also mean we would have direct comment on the neighbourhood forum's evidence, which we currently don't have from history.
Okay, Councillor Lee. Sorry, Councillor Lee Hunt was just before you, Councillor Atkins. So we're trying to do it in the chat order. Sorry, I know it's important. Councillor Lee Hunt, please.
Well, I'm sure Kieran will give us the proper route through this. I understand there's a deferral on the table, but if we get through to further debate, of course, I will expand on my proposition that the villas are and should be curtilage listed. That would be my proposition. If I have to make it now, I will, but I would like to come back and talk about it too, and my reasoning. So there you are. If we get through this, that would be my position, and I'll reason it out.
Thank you. Councillor Atkins, sorry to disturb you beforehand. Did you want to carry on with what you were saying?
No, I think I'd made my point.
Thank you very much, Councillor Atkins. Thank you for
sides evidence. I'm happy, by the way, to vote on deferral first, if that's the position of the committee, and then continue debate afterwards if needs.
Thank you very much. Okay, Councillor Lynn Stagg, did you want to say anything? Sorry, I haven't seen. No.
Yes. I wanted to propose that we refuse the recommendation. We oppose the recommendation.
Right. Okay. All right. Okay. Thank you. Anybody else?
Seconding my
Yes, seconding. Councillor Hunt. So you're proposing to it should be listed, basically, is what you're saying. And Councillor Lynn Stagg is seconding Councillor Hunt. Is that correct so far?
Yes.
Yes. Okay. I just want to make sure I get it right, Councillor Stagg, because I get told off if I don't do it correctly, and legal tell me off, and no doubt they're writing it as well. Kieran, can you help us? Yes.
Yeah. Thank you for making that clear, because I was a little bit unclear myself as to where Councillor Hunt stood on that. So, Councillor Hunt, it's your motion to propose. So I would want to work through the different statutory tests with you to understand what the basis of that motion is. However, the motion to defer was placed on the table first and would normally overtake any other motions anyway. So that I'm not going to sit here and make us do that if it ends up becoming quite a literal moot point. If you're going to defer the motion. So subject to any further comments, and then the vote on deferral. If we're still then concerned with this item, I will take you through that.
Okay, anybody else want any more comments then before we take a vote, which is Councillor Atkins? Yes, please.
I'd like to vote on deferral because I agree that it would waste a lot of time if we go into an extended debate and then we defer. So can we vote on deferral? But I would want to then come back and potentially propose something else if we don't succeed in deferring. So I don't want to lose the opportunity to make a different proposal. So I'd like to vote on deferral first, but.
So I understand, Kieran, now, just correct me if I'm wrong, I'm sure members would tell me, that's the first vote that we'll be taking on. The vote is for deferral, and that was proposed by Councillor Judith Smythe and seconded by Councillor Atkins. Is that correct, Kieran?
Yes, deferral was proposed by Smythe and seconded by Atkins. That's what I've got.
Okay, so we vote on that first of all, yes?
Yes.
Okay, members. So that's what's on the table at the moment. Everybody understand? Okay then. So they have to vote for or against that. Is that correct, Kieran? Yes? For or against?
Yes, and as discussed, you're voting on deferral on the basis that you want further information in relation to the dates that the two villas in issue were constructed.
So it's very simple, members, for or against. Okay then, so I'll call upon Councillor Judith Smythe, please. You for or against?
I'm for deferral, Chair.
Thank you very much. Councillor Matthew Atkins, for or against?
For deferral.
Thank you. Councillor Atwell, for or against?
I'm against deferral.
Okay. Councillor Lee Hunt, for or against?
Against deferral.
Councillor Donna Jones, for or against?
For the deferral.
Councillor Terry Norton, for or against?
For the deferral, Chair.
Councillor Lynn Stagg, for or against?
Against.
Thank you. Councillor Luke Stubbs, for or against?
For.
Councillor Claire Oudie, for or against?
Against.
Thank you. So I'll cast my vote and against the deferral. I think we should make the decision today, personally. Okay, so could someone count that up?
I've got 5 for and 5 against.
I agree. So, Chair, you would have a casting vote on that.
Well, I think we should make the decision today, quite honestly. So I'm not for deferral.
Against deferral.
Yes.
Okay.
Yeah, yes. Same as Councillor Lee Hunt. Yes.
So the motion fails.
I think we should make the decision
been
today.
defeated.
Yeah, I should think we should make the decision today. Personally, I know members may not agree with me, but there we are. Okay. So where are we now, Kieran?
I will now, as we have the motion to forgive me, Councillor Hunt. What is the thrust of your motion again?
Well, the thrust of it, but I've got to reason it out, Kieran, haven't I?
Yes, but sorry, forgive me, I'm being dense. Are you for listing or not?
My proposition at the end will be for listing, and I need to reason that out.
For listing, yes, that's fine. I need to take you through the tests either way. Well, in the case of the officer report, it's readily reasoned, but yes, I thought it would be in favour of in listing, and therefore we need to go through the tests because it's contrary to the officer recommendation.
Okay. So I'm going to reason it. So I'm going to go first then, by the sound of it, Kieran.
So the first test you've got to address your mind to is the structure test and whether there would be adverse heritage impact on the listed building if it were removed.
So on the, I see the two is, am I allowed to go without interruption, Kieran, or we have to take this one stage at a time by everybody?
I'm going to try and take notes on what you say. So
okay,
if I have to ask a follow-up question.
Yeah, thank you. Thank you. Here we go. So I'm going to do a presentation. So the two villas the question we've had to look at today is, are the two villas curtilage listed under Section 1, brackets 5 of the Town Country Planning Act 1990 listed buildings and conservation areas? So we all know what we're talking about. So we've been asked to examine, Kieran, these two key questions. Are the villas structures, and do the villas stand within the curtilage of a listed building? We are findings of fact, we have now agreed today, and as members of the local planning authority and the city's licensing committee, we're quite competent to make those decisions. So I've read the officers' report and the representations from Milton Planning Forum, the public, and local councillors, and I've also read the Home England QC report. I've paid close attention to the advice of the Queen's Counsel to decide if, in my opinion, the land is so intimately associated with the listed building as to lead to the conclusion the land forms part and parcel of the building listed, of the listed building. And I've looked at all the relevant matters to decide whether or not the villas do form a part and parcel of the listed hospital building, including the physical layout of the listed buildings and villas, their ownership, past and present, and their function, past and present. Today, we are considering if we believe these villas can be curtilage listed. And this is different to some of the conflation that we had earlier on, the historic England's listed status. After considering these matters, I must come to the conclusion as to whether or not the villas are structures, i.e. ancillary to the hospital building, and so clearly related to it, that if they're removed, they would adversely affect the interest of the listed building, and then whether or not the villas stand within the curtilage of the listed building. In other words, whether they form part and parcel of the listed building itself. It seemed to me that this case, the two questions go hand in glove. All the evidence presented today shows the use and function of St James's Hospital, including the two villas, were part of the same common purpose, almost right from the start through to modern day, remaining under the same ownership and management, the treatment of and the mental well-being of Portsmouth people. We have been shown evidence that the villas were conceived and completed between 1905 and 1908, not 1926, the officers' report. So Mr. Bailey and Mr. O'Hara produced their evidence, and they refer us to tender documents obtained in Norwich Library and Historic England's archive. I find the evidence from their evidence compelling and confirmed even more in Home England's QC report. They talk about the earlier date, and that reinforces the close relationship with the main listed building. All of this evidence we've heard today from the people that we've listened to shows the intimate and close relationship between the villas and the listed buildings, always serving the same common purpose, inextricably linked in the story of the care of mental well-being here in Portsmouth. On the geography, Kieran, whilst the villas are stepped apart on the main building, their function and purpose and relationship to the listed hospital building remains one and the same. They are interlinked by functioning in the same common purpose. They are interwoven in the history and the story of the treatment of the mental well-being of Portsmouth people. They are more, Kieran, than ancillary to the main listed hospital building. They are an important part of the same common purpose, situated in close proximity to save that interwoven common purpose. Removal would, therefore, adversely affect the interest of the listed building. On function, layout and ownership, I have tried to separate the two tests on structure and curtilage as advised, but the more I have heard and the more I examine the evidence, the more I find the villas are so closely related to the listed hospital building and intertwined with this common purpose and a common function. I have to say that I've considered the geography and layout, and this is not like the case in the Manor Horn, where Deirdre is down at the gate looking through her binoculars up at the Manor House. Here, the villas are in close proximity to the listed building, not separated by fences or by any other barriers. As we heard earlier on, as close to the main building or even closer than the chapel. Rather, they are joined by the quiet and solitude of the green space, and joined by the peaceful woodland paths for over a century, serving the people of Portsmouth in a common purpose to improve mental well-being of human beings. So in conclusion, I'm sorry for going on, but it needs to be set out. So having regard to all of the evidence we have heard today available, including representations by Milton Neighbourhood Planning Forum, ward councillors, city planning officers, and taking into account Queen's Council advice on both sides, it is clear that the past and present join these buildings in one common purpose over a century, that the three Stevenson's tests, ownership, function and layout, are met, so that the two villas are part and parcel of the listed building itself, which will be harmed by their removal. The beaches and ferrets do comprise structures under section 1.5(b) and are within the curtilage of the main hospital listed building and are therefore to be regarded as curtilage listed. Okay, that's the end of it.
Okay, Councillor, thank you. Feedback.
Kieran, I don't know if to read that back.
Oh, I won't be writing it back, that's for sure. I may just summarise it though. Okay. So there was one pedantic point before I go any further. You said at one point that they're more than ancillary. The test is that they are ancillary.
Yes, they are ancillary.
They are ancillary. Yeah. Okay. That was clear from the general thrust you put around it. But yeah, thank you for that.
Okay, so we've got the next thing on the table then, Kieran, that we have to vote for, which is the proposed by Councillor Lee Hunt and seconded by Councillor Lynn Stagg, and that basically it should be listed as cartridge. Did you just want to read out what Councillor Hunt has, or sum up what he said, so members know exactly what they're voting on?
I think, given that we've been going for some time now, Councillor, and I think it would actually be helpful for me to speak to the planning officers just to get a common form of words agreed between us on an officer level. If we could reconvene at, say, 5:05?
I think it's a bit later than that. It's called near 20 to 6. Yeah. It's 20 to 6. So are members happy, what, 5 to 6? Would that be long enough?
Earlier than that, actually. Maybe 6 o'clock.
6 o'clock. Give people time to go and get a cup of tea. 6 o'clock, then, members, please.
Yeah, I've got a meeting at 6 o'clock, so I'm going to leave now. Then that's it. I've got no longer now. Sorry about that.
I'm so sorry, Councillor Jones. Sorry. I'll try to get everybody in. Okay.
Absolutely. No, I understand.
Obviously, can I just remind members, obviously, not to talk about it outside until 6 o'clock, until we're all back again. Councillor Jones, thank you again for your support. And members, we'll see you all at 6 o'clock. We'll take a short break. Thank you very much.
Okay, I'll put the slide up, and can you keep your microphones muted, please, because the recording's still running.
Yes, thank you very much.
Oh, they ran you over.
Councillor Hunt, your microphone is on.
Oh, sorry, I nearly ran the dog over with the chair. I'm so sorry.
Hello, Anna.
Hi, would you like to resume?
Chair, if I may, could we take a further 5 minutes just to bottom this out, please?
Thank you, Anna.
Loitering. Is that okay? Yeah.
Don't think anyone can hear us at the moment.
Yeah, that's fine by me. Councillor Hunt, I can hear you all.
Hello?
Yeah, I'll leave
Okay.
the slide. I've got the slides still up.
Okay, so I'll come back to you by 7 minutes past now. Apologies for the delay.
Hello?
I'm here, David.
Hello there. Sorry, councillors. A little bit technical fault. I've come up in the private office now. A bit cooler.
And the officers have gone away for another 5 minutes just to bottom it out.
Oh, the officers are still wanting 5 more minutes, are they?
Yeah, that's what they requested, and they've gone off for another 5 minutes.
Okay, then. So we'll switch our microphones and cameras off, councillor, just in.
See you shortly.
Chair, thank you. It's now 7 minutes past 6, so I have had the time I require.
Thank you very much, Kieran. I'm just sending a quick email. I'll be with you in 30 seconds. Thank you. Right. Okay. So,
Chair, can I make a quick point before we get going again? Just a point of order.
I think if you want to make that when we make sure everybody's here,
Sure.
Councillor
Yeah,
Atkins,
sure.
first of all, just so that everybody's heard it, that's all, sir. So if Democratic could let me know if everybody's here apart from Councillor Donna Jones, I think, has had another meeting at 6.
I see 5 of you, 6 of you now. Got Councillor Udy there.
Hello.
Well, that's 7.
Thank you, Councillor.
Councillor Norton. Yeah, I've got Councillor 1.
Sorry, Anna. Yeah, present. Sorry,
I've got 8.
Pressed the wrong one. I pressed camera rather than microphone, but yeah, I'm present.
So it's Councillor Stagg is the 9th one. Councillor Stagg, are you there?
I'm here.
Right, that's all 9 of you, so I'll take the screen away.
So you can take the screen off and I'll officially welcome everybody back. Good afternoon or good evening, members. Welcome back. Thank you for your patience again. I was going to have a word with the officers just to make sure the wording is correct before there's a vote taken on a proposal that Lee Hunt and second by Councillor Stagg, but we'll go into that in a second. So can you just read out what you're going to say, Kieran, please?
Chair, thank you. We've taken the time to distill the motion as Councillor Hunt has proposed it. I don't know about other people, but I'm getting intermittent connection with Councillor Fuller.
Yes, I am as well. Mine keeps dropping. Is everybody else, is okay? No, mine keeps dropping. Bad quality.
Yeah, it's just Councillor Fuller that I'm seeing difficulties with.
We can hear you, though. We can hear you.
Can you? Is that okay? If it should, can you hear me? Obviously, is that okay, Kieran? It might settle down. I'm about to move upstairs.
I just want to double check that you've heard the motion as I read it out, Councillor Fuller.
Can I make a point before we read them? I mean, maybe it doesn't matter which way around, but I would like to make a point of order.
Okay, if you to do. Is he if we let him do that first, Kieran, and then if there is problems here, I might have to go back downstairs again. Councillor Atkins, point of order, please, sir.
I had RTS'd in the chat after we voted on the deferral because I had said before we voted on the deferral that I would like to come back to the debate and speak again prior to us, resolving any other motion. Now, I suppose we could vote on this, but I have comments that I would have made on Councillor Hunt's motion if I'd been allowed to return to the debate. My understanding is we were returning to the debate after we voted on the deferral, and I would like to do that.
I'm going to have to break off and take this downstairs because I can't. I'm just going to have to call back in 2 minutes. I'm sorry. Let me just take it downstairs. I'm going to mute myself and take my camera off. Just give me 2 minutes again. Hello, members. Hello. Can you hear me? I can't hear anybody else, but
yes.
Yes, we can hear you.
I'm back. Sorry about that. Sorry, I'm back again where I was before. I do apologise. Sorry, Kieran. Councillor Atkins, you wanted to make a point of order. I didn't hear what you were on about. Please, could you repeat that before I go over to Kieran?
My understanding when we went to the vote on the deferral was that after the vote on the deferral, we would be able to return to debate. And we've instead gone straight to voting on Councillor Hunt's proposal. I would have liked to have spoken before that in order to explain my reasoning and comment on Councillor Hunt's proposal as part of the debate. And I would like that opportunity to speak. I did put RTS in the chat before we moved to the vote on
Councillor Atkins, sorry to interrupt there. Yeah, my apologies for that. Obviously, it's been a very fraught few hours, so that is down to me. So I do apologise. You did say that correctly. Kieran, if you've got any problems with that, if I let Councillor Atkins say a few words, is that okay?
Yeah, I'm grateful to Councillor Atkins for raising that. I wonder if it might assist Councillor Atkins if I were to read out the motion for Councillor Hunt to then assist with his comments, in effect.
Sure, either way. Either way.
Are you happy for that, Councillor Atkins? Thank you very much. Kieran, over to you, please.
Okay, so yeah, there will follow a bit of debate and not straight into a vote, but particularly looking to Councillor Hunt as it's his motion that I'm looking to distill in the first instance. Right. So the motion drafted is that as follows. In respect of whether the villas are to be considered structures within the curtilage of the listed building of St James's Hospital, as referenced in Section 1, subsection 5 of the 1990 Act, the local planning authority considers that these buildings are so closely related to that hospital building in terms of the historic context of medical practice at the hospital that their removal would adversely affect its special interest, and they are ancillary to the main hospital building. As such, they are considered structures for the purposes of the Act. The physical layout of the villas in association with the listed hospital is such that they are in such close proximity and without fences or barriers separating them to form part of the curtilage of that building. Since their construction in 1908 until their recent disposal, the villas have been in the same ownership and fulfilling the same function, that being the ownership of the wider NHS and for the shared purpose of delivering medical services that, in combination with the physical layout in such close proximity and without fences or barriers separating them both historically and evident currently on site, that they are considered to be part and parcel of the St James's Hospital building and within its curtilage.
Yeah. That assumes everything that I said, so I'm grateful for that.
Okay, Councillor Hunt, does that roughly sums up what you've...
Yes, I just agree. Thank you, Chair. And it summed it up nicely. Thank you very much indeed.
Thank you. So before we go to that, Councillor Atkins, thank you. Thank you for being patient.
Thank you, Chair. And I think well done to Kieran and his team for obviously expressing. They'd obviously prepared and had a good understanding of how we might word this motion, I think, either way. However, I just want to reiterate to members of this committee, and I think it needs to be emphasised, the level of risk that I think you are placing this committee, this council, and ultimately the money of the people of Portsmouth if you are voting in favour of this motion. We had one piece of QC's advice of our own QC, which said these are not in curtilage. We had the QC's advice of the applicant based on a professional historical report, which says these are not curtilage. And we have our own office recommendation that they are not curtilage. Now, contrary to that, we have the non-professional, but obviously very expert and very enthusiastic Milton Neighbourhood Planning Forum submitting to us effectively unanswered historical documents that appear to contradict that evidence, and we then had a QC advising us that actually if that is correct information, we can make a decision that they are potentially within curtilage. But, we are deciding on the basis of historical information that, our officers are advising us not to accept, and we have not had any verification of that historical information. It's still in Kieran's wording, which puts a very professional spin on what I think was a garbled explanation from Councillor Hunt, frankly. It puts a very professional spin on it, but it still refers to the 1908 It still refers to historical facts that were in dispute about the way the buildings were used. And if the applicant chooses to take this judicial review, they will be able to ask a very legitimate question, which is, on what historical basis did the council reach this decision? Information provided to us that I pointed out is by no means determinative, has no means got a solid basis, that we've not checked the references or the primary sources of ourselves, by an organisation which, let's face it, is set up primarily to discuss planning issues in Milton, and we know has taken publicly an opposition stance to this development in the whole. So, the applicant is going to have a strong argument that we are deciding this on the basis of evidence that we are, giving, I would say, undue weight to. And so I think this is extraordinarily risky. You decided you wanted to determine today, but it's extraordinarily risky to decide the determination you therefore want to reach is to reject all the professional advice we've received and reach our own conclusion. I also frankly have to say that members of the public, who are not in Milton, across the wider city, might question whether or not that is a sensible use of their taxpayers' money, as well as the taxpayers' money of the residents of Milton, when we had, 3 Liberal Democrat councillors making deputations today, and this vote so far against waiting for further historical information to give proper respect to the Milton Forum and the research they've done is proceeding entirely, frankly, on party lines. And frankly, as a final point, it appeared that when Councillor Hunt was giving his reasons, he was reading from a pre-prepared written statement. And I would frankly like to know when he wrote that statement. I mean, I suppose I wasn't watching his camera carefully, and if he says he wrote it in the meeting, he says he wrote it in the meeting. But it does raise the question, frankly, of predetermination, because it was a long and extensive statement which was pre-written. Yeah. And okay, if you wrote it in the meeting, that is entirely legitimate. Yeah. But it was.
Councillor Atkins, I think I'm going to interrupt there because no, hold on, it's my meeting. Councillor Atkins, I find that, and I know that this is non-political, but I can assure you, when you've been talking, and you've said a lot today, and I appreciate that. I've been watching Councillor Hunt and everybody, because I can see everybody, and all he's had is his head stuck in a book, writing stuff down. Now, Councillor Hunt usually is very vocal, and I'm sure if he had been very vocal in this meeting, he wouldn't have had time to have written down the stuff that he's written down. So I do personally take a bit of offence of that. Yeah, well, I'm sure Councillor Hunt will say that, but that's up to him.
Your observation.
Well, I can assure you on that, and I wouldn't have anyone predetermine anything. So that's my view on that, and unless you can prove anything else. And of course, the other thing, Councillor Atkins, I will say it, is that all I've heard from officers today is it could go either way, one way or another.
I was going to proceed finally to that point in my concluding remarks, which is only one member of the committee has actually given reasons, Councillor Hunt himself, which I applaud him for the bravery to do so, has actually given reasons for why he would vote to reject the officer recommendation. We've not heard from the seconder, we've not heard from any other member of the committee on the extensive evidence presented to us. I think Councillor Smythe and I and Councillor Norton, Councillor Jones, when she was here, were all clear on why we felt there is insufficient evidence. But those of you that have said that there is sufficient evidence none of you have commented, which is, of course, you're right. But we are here putting I just want to emphasise, we are putting taxpayers' money at risk, going against professional advice from multiple professionals, and I would say on the basis of an inadequate factual basis. And so I do think that it needs to be said that I think the decision being reached by the committee today is an extraordinarily risky one, and I find it quite astonishing that it is the decision that appears to be the direction in which we're heading.
Well, the vote. Look, thank you very much, Councillor Atkins. The vote hasn't been taken yet, in fairness, and from all sides, all political sides, everybody, in planning, they say 1 minute they've got to support the officers, and if we don't go against them, it's going to cost the taxpayers money. So your argument, I've heard hundreds of times, Councillor, personally. It comes from whatever political party you belong to. I've heard it hundreds of times since being on this committee. But anyway, Councillor Hunt, did you want to come back with anything before I move on?
That's very good of you, Chair. I mean, when you have debates like this, you know, one's own character, one's own preference, and one's colleagues will reflect the same sort of things. I mean, all of the Conservatives today have said more or less the same sort of thing. I haven't popped up and said we're going to all stuck their heads together and done this, that, and the other. It's just a load of baloney.
Members, I will intervene here.
You're
you must
right,
be
sorry.
mindful that we're in the purdah period, and you must not politicise the decision.
Sorry, Kieran.
Yes, Kieran, you're absolutely correct. I do apologise for that, Kieran. Okay, so Councillor Hunt, I think we'll move over to Kieran now, if every member's okay. I think
hold on, I'm down to comment this, Chair.
Sorry, Councillor Terry Norton, comment, please.
Yeah, thank you, Chair. No, I mean, I do raise similar concerns around the standing orders and the issue that we've got these meetings online. At the beginning of this meeting, we were asked to keep our cameras on at all time. Many didn't have their cameras on at all time, myself included. At part of that, in part of that, we've had a meeting chat there which isn't public. So there are, I think it leaves us in a very difficult position if anyone were to question the information that we were receiving in meeting chats. There's a claim of predetermination, and I worry about legal challenge. I really do on this committee when we're not adhering to the standing orders really with the way it's being conducted potentially, and that's for the benefit of the committee as a whole. On the application, I don't know who wins here. I really don't. I don't know who wins. I feel for the Milton Neighbourhood Forum. They genuinely really do care. Of course, they care about their the site there. They care about the historical nature and the buildings that are there. You know, but we've had deputations that were political. We've had deputations that spoke about from councillors that spoke about the application that wasn't in front of us, it linked towards the major application. And actually, I think if I'm a member of the resident Milton Neighbourhood Forum, I'd be thinking, well, actually, there was an opportunity for the City Council to take control of the strategic development of that site, and it was fluffed, wasn't it? An application was put in years ago that no one will tell us anything about. The Liberal Democrat administration won't tell us about the application. They won't tell us the details of it. So if there's a push to have a look at the strategic element on that site there, then do something about it. You know, I just feel for the residents who are being spun a little bit here on this. We had a deputation that also attacked the developers, so they don't win either. It spoke about greedy developers, using this as a cash cow. Well, if the administration aren't building homes, who are going to build homes? You know, and that's linked to that, isn't it? And Councillor Smith also spoke about not politicising this, and it did become political at times. I just don't think anybody wins here. I really struggle with it, and I stand by my comments that we are not the best people to make this decision. So I'm going to have to abstain. I just don't feel that we're in a position to make that decision, and I feel for the residents who are invested in this, who are being dragged into this very difficult political battle here. It doesn't serve anyone, I don't think.
Thank you, Terry. Councillor Norton. And again, as I say, it is recorded, so I know that you've expressed your wishes, and I know as Councillor Matthew Atkins has as well. But I think we need to move on really now. We are where we are. Kieran, any quick comment on anything that's been said, or do we just get on with the vote? And are you happy to carry on?
Yes, members. I'm assuming none of you have any further comments. I would be happy to go to the vote after. Would you like me to restate the motion again, just for clarity, one more time before the vote?
Just me. I think members, of all happy now. I think do all members happy for what we're voting on now? Does any member wishes for it to be read out again? Councillor Judith Smythe.
I had an RTS up, and I'm extremely worried about this. In many different arenas of life, a board that ignores professional advice can actually be sacked, and they're not covered by the insurance that they have. I presume our insurance, being a planning committee, and where there is a reasonable chance that there will be genuine evidence-based disagreement, is not in that category. Certainly, if you're on an NHS board and you ignore medical advice and somebody dies, you can actually be then publicly censured and sacked. I mean, I just raised the question. I am very, very worried about this one, about the likelihood of legal challenge, and I haven't quite decided how I'm going to vote on this, but certainly not for the motion. And I've asked whether you could put me at the end of the voting this time, because I prefer to.
Well, thank you for that, but I will be going as the list, Councillor Judith Smythe. I will be going as per list. I think that's what I've been told, so I have to go as the list as it's written out in front of me. Sorry, Councillor Luke Stubbs.
Well, if it's any help to Councillor Smythe, I certainly intend to abstain. And the reason for it is quite clear. It's because the facts of the case aren't established. And so I can't really take a position and make a judgment about then to interpret those facts when the facts are still uncertain. And as it's been mentioned a few times, could I also ask that the chat is all saved and made available, just so that we've got it all, just in case of any appeals or challenges further down, just so we've got that information and then it's clear about what information members in its entirety have had.
Thank you, Councillor Stubbs. Well said. Thank you very much, and thank you for pointing that out. Kieran, so I'm going over to you now. So are you happy for me now to? Would you like to read it out? Say I'm just about to take the vote now. So obviously I've got to ask for each member in turn if they are voting for or against the motion. Is that correct, or do they wish to abstain? And this is a proposal was Councillor Lee Hunt and seconded by Councillor Lynn Stagg, and that the cartridge should be listed. Is that correct?
Yes. So the consequence of voting in favour of the motion would be that you support the listing of the structures within the curtilage. Yeah.
Yeah. So members, so that's what we've got in front of us. So it's for or against, or do you wish to abstain? So I call upon Councillor Judith Smythe. Please indicate if you're for or against the motion, or do you wish to abstain?
I wish to abstain, Chair.
Thank you very much. Councillor Matthew Atkins, please indicate if you're for or against the motion, or do you wish to abstain?
I wish to abstain, Chair.
Thank you. Councillor Atwell, please indicate if you're for or against the motion, or do you wish to abstain?
I'm for the motion, Chair.
Thank you. Councillor Lee Hunt, please indicate if you're for or against the motion, or do you wish to abstain?
I'm for the motion, thank you.
Thank you. Councillor Terry Norton, please indicate if you're for or against the motion, or do you wish to abstain?
I wish to abstain.
Thank you very much. Councillor Lynn Stagg, please indicate if you're for or against the motion, or do you wish to abstain?
I'm for the motion, Chair.
Thank you very much. Councillor Luke Stubbs, please indicate if you're for or against the motion, or do you wish to abstain?
Abstain.
Thank you very much. Call upon Councillor Claire Oudie. Please indicate if you're for or against the motion, or do you wish to abstain?
I'm for the motion.
Thank you very much. And I'll cast my vote, and I'm for the motion in front of us. So could just add up.
Right, I've got 5 for and 4 for abstain.
So that's been carried then. Thank you very much, members. Thank you. Sorry it was a long one. Okay, so we now move on to the next item, which is Rebecca is going to introduce this one, and this is Queen Alexandra Hospital, Southwick Road, Cosham. Over to you, Rebecca. Thank you.
Hello, thank you, Chairman. If you just bear with me while I get the presentation and share my screen. Excuse me, sorry about the background noise. Sorry, I'm just having some problems getting the presentation to share with you. Just bear with me.
Oh dear.
Sorry, I think I'm there now. Apologies.
It's one of those days.
Okay, now I've opened the wrong.
Thank you. Over to you then, Rebecca. Thank you.
Right, can everybody see the presentation?
Yes.
Okay.
Yes, thank you.
This application relates to the Queen Alexandra Hospital, and it's the northern part of the North Car Park that this one relates to. Most of the members, I believe, will recall that in December, an application was granted for planning permission for a ward block on the southern part of the North Car Park at QA. So this application relates to the northern section here, which currently has 195 parking spaces on it. The application proposal is for the construction of a 4-level multi-storey car park that would provide a total of 541 spaces. And I will explain the parking strategy a little bit more as I go through this presentation. Just to explain as well, what I'm going to do is when I get to the end of this presentation, I will do a summary of the supplementary matters because there was a fair few updates before the committee. And I will also read out a deputation that has been received from a neighbouring resident and a deputation from the applicant. So just first of all, just to go through some photographs of the site. This is the entrance to the current surface car park, North Car Park from Harvey Road. And you can see there's a boundary of trees there, which is on the western boundary with houses in Boston Road and Peterborough Road beyond them. Then this top right photograph is a photograph from within the car park looking towards the rehabilitation centre to the east, and you can see it's mostly hard surface, but there are some strips of greenery and trees in the middle. And then these bottom two photographs are taken from the northern bank and looking east and southeast back towards the main hospital buildings over here. You can see the car park itself is on a level, the land then raises up behind, and I will have some section drawings showing you how the car park will sit. I've also included these additional photographs looking back towards the boundary with the neighbouring properties, because that's another matter that I will raise a bit later. You can see, so there is a screen of trees, but you'll see it is a broken screen of trees. It's not. There are gaps in it, so there are views through, and they're not evergreen trees. And if you looking back down there to the south, that's the main hospital, and this is the western boundary. So the application is for the construction of a 4-level car park. It's as a standalone application. This would result in a net increase in 346 parking spaces on the northern side of the North Car Park. However, the application is being considered in conjunction with the ward block application that was previously permitted, and also a future proposal to expand the emergency department at the hospital, for which an application is forthcoming in the next couple of months. And I'll go through the parking strategy, which sort of takes account of all of those projects. Before I get there, just to show, this is more or less a repeated layout of each floor of the car park. This is the 4th floor, or level 3. You can see it's been designed so that the cars would park facing north and south and not to the west or east. In terms of the elevation design, it's a fairly simple design, but with some added visual interest. And also, so you'll see that the south and the western elevations of the car park will have the most articulation with some wood effect cladding. And it's this image up here. It's a metal cladding, but it's got a wood effect. And this is to provide some, to relate in some way to the existing multi-storey car park at the southwest side of the hospital, which has wooden cladding on it. The stair and lift cores would then be constructed with a terracotta cladding, which would complement the terracotta cladding on the main hospital building. And then the north elevation and the east elevations would be predominantly open with metal mesh cladding for ventilation purposes. And these would be the least visually prominent from sort of public vantage points. So as I said, this is the east elevation, fairly open, and the west elevation to incorporate the wood effect cladding. And this is an image of how, a sort of visual of how it would look on the site. And this is an indication of the ward block. So another element to this scheme is a link bridge from the first floor level of the car park through to the ward block to provide a level access. So I'm just going to talk through the parking strategy a bit now. As I explained, the North car park at the moment, the northern side, has 195 spaces. The multi-storey car park would have 541 spaces, which would result in a net increase of 346 spaces. But this has been, but the way that the parking strategy has been put together is to consider a longer-term strategy, which is a part of a wider redevelopment, well, improvements and enhancements to facilities at the hospital. So you'll see that when the planning permission was granted for the previous sort of main big development at the hospital in 2003, there were conditions that required a maximum of 1,572 staff spaces and a minimum of 664 public spaces. And currently, the parking numbers fall within those parameters, with 1,411 staff spaces and 801 public spaces. Upon completion of this car park, along with the ward block and the future proposed emergency department expansion, there would actually be a net reduction in parking on the QA site overall by 98 spaces. The main difference is that they would be increasing the proportion of public spaces in relation to staff spaces. And the proposal would then be to move more staff parking up to the Fort Southwark Park and Ride, which is currently known to have up to 450 spaces available daily. So it has the capacity to take more staff parking. So that's the main basis of the parking strategy, but I can certainly answer any more questions that anyone has around that. In terms of the relationship with existing buildings and neighbours, these are some section drawings. I don't know how well these outlines are coming up to see, but you can see the other hospital buildings around the site. So that the car park is a large structure. It is, undeniably, it is a large, bulky structure, but it's no taller than the buildings. Some of the, many of the buildings existing on the site. So in scale, in terms of its scale, it is considered to be acceptable. Here it shows the scale and height in relation to the nearest neighbouring properties on Boston Road. And I've got some more measurements here. So it's approximately 30 metres to the nearest property and at a height of 13 metres. So that's the sort of main relationship there. We've got the tree screening. And I will say at this point that there is no condition at the moment, but the applicants have expressed that they would be accepting of a condition to enhance the boundary screening on this western boundary. And I do have some draft condition wording if that's required. Sorry.
That's all right. Carry on. Yeah.
Yeah. So I've also just a couple more. So I just go back to saying that the cars, because there's one of the objection that has been received or some concerns received by a neighbouring resident relates to loss of privacy, light pollution and air quality. In terms of privacy, there would be 4 metres of cladding above the level of the parked cars. So there wouldn't be an open, unobstructed view to the west. And in terms of light pollution, the cars would all be facing. I mean, yes, they would be driving to the west, but they would be parked north or south facing. And the lighting strategy has been prepared, which shows that, which has been designed to ensure that the light would not spill beyond the immediate surrounds of the car park structure itself. And that has been reviewed by the council's environmental health team, who consider that to be acceptable. I would also say that an air quality assessment has accompanied the application, which has also been reviewed by our air quality specialist, and it concurs that it wouldn't result in air quality levels above what would be above sort of national standards. So I'll just leave it there with an image. The application is recommended for conditional permission, and I'm just going to do a quick summary of the supplementary matters, just because there's a fair few of them. So first of all, we received one public representation, and the comments can be summarised in relation to concerns about loss of privacy, so concern about overlooking of the property, particularly from the 4th floor level of the car park due to its height and the position of the building. Light pollution, concern about increased light pollution, particularly to a bedroom window on the east-facing bedroom window, which would result in an impact on health. And thirdly, concerns about air quality due to increased visitor and patient parking leading to increased vehicles. As explained, these matters have all been assessed as part of this application process, and it's considered that the impacts wouldn't be harmful to the amenity of the neighbouring residents. We've also had a number of further consultee comments. In terms of the highways officers' comments, you will see seen that they were summarised within the committee report. The highway engineer has recommended refusal of the application on the basis that it doesn't provide sufficient information to assess the impact of increased vehicle movements on the local highway network if the application is considered in its standalone, so just if we're just considering the car park. What we've done is considered it as a wider scheme, as I explained with the other developments and the proposed developments coming forward, and we have made an amendment to condition 5, which would ensure that before they start using the car park, they would have a parking mitigation strategy agreed, so that if there were any changes to the kind of timeline of works and completion of developments that were coming forward, they would have to show how they mitigated any potential increase in parking at that site and increased vehicle movements before they started using it. A construction management plan has also been submitted and agreed for controlling noise and dust and pollution during works. Other comments that have been received include the public health officer sort of made some general comments around air quality and a travel plan, and you'll note that there is a condition for a travel plan, and I've already explained in relation to air quality. I've summarised the environmental health officer's comments in relation to air quality, lighting and noise, of which they have accepted the conclusions of the submitted reports. We have slightly amended condition 13, which would ensure that the details of noise panels at each level of the car park are submitted and approved before they're installed, which would just allow us to make sure that they will mitigate noise. I'd also say that the surfaces of the car park, each level, would be concrete and there wouldn't be exposed metal, so the cars wouldn't be running over metal. We've also got some contaminated land officer comments, which has updated the 2 contaminated land conditions just to make them more specific to what's outstanding and what's now required, and this has all been accepted by the applicants. And the final amendment to conditions is to condition 10, which is again more specific because it takes account of some specific recommendations from the county ecologist in terms of biodiversity enhancement. And you'll also note that a tree protection plan has been added into condition 2. So that was just missed in error. So to conclude, with subject to the amendments to conditions outlined, the recommendation is for conditional permission. If you could let me know if you want me to go straight on to reading out the deputations.
Yes, please.
Yeah. So I will start with the deputation from, this is from Mr. Sawkins.
Sorry, Rebecca, could I just ask you to stop there? I've just got Councillor Luke Stubbs.
Yeah, I do apologise, Chairman. I mean, thinking about it, I know someone fairly well who lives in one of the even-numbered properties in Boston Road. And while I don't think this, it's not right at the end of his garden, but I think potentially it might affect the light slightly. I think just being cautious, I would like to declare that as a prejudicial interest, and so I won't take part on the remainder of this item.
Okay, so you'll switch the camera. So will someone be able to contact you when we've done this application? One of your
I mean, it is a public meeting, so if I just carry on listening to it, then I'll know.
Okay, thank you very much. If you switch your camera off then, Councillor. Thank you very much. Sorry, Rebecca, please carry on with the deputations. Thank you.
Thank you. The first deputation is from the resident of 56 Peterborough Road to the west of the site. I'm going to read out exactly as it's been submitted. Dear Committee, I would like to thank the Chair and members of the Committee for this opportunity to comment before you on this application. My name is Ben Sawkins and I have lived adjacent to the proposed development for 15 years, while my partner has lived there for over 30 years. I object to the application on the following grounds: loss of privacy, light pollution and air pollution. The height and proximity of the multi-storey car park will mean that it directly overlooks our property, resulting in a loss of privacy. Vehicles on the top floors of the multi-storey car park will have an unobstructed view to our east-facing first floor window and garden, which removes the current obstructed view from the existing car park due to garden fencing and hedgerows. The planning application suggests that there is a border of mature trees between the multi-storey car park and residential properties on Boston Road and Peterborough Road, which will provide some visual screening from these properties. The key word there is some, as there are gaps between the trees, and the limited obstruction will be provided for a part of the year when the trees have leaves on them. The height and proximity of the multi-storey car park will mean there will be unobstructed light pollution into our east-facing first floor window. Even though there will be motion sensors, meaning there will be periods with minimal light pollution, this will result in lights going off and on intermittently throughout the night. This is in addition to lights that will remain on at all times. As the east-facing first floor window is a bedroom, it will have a major negative impact on sleep and therefore health. The increase in visitor and patient parking provision as a result of the proposed development will increase the air pollution at the hospital site and surrounding residential area. At peak periods, the traffic at the hospital site exceeds capacity, resulting in idling cars and buses. Adding to the volume of vehicles coming and going, especially at peak times, will make the situation worse and have a negative impact on the health of adjacent residents. I understand living next to a large hospital will have an impact on privacy, light pollution and air pollution. The current impact is at an acceptable level. However, the proposed development will take it beyond an acceptable level. If the benefits of the proposed development were to outweigh the negative impacts on myself, the surrounding area and Portsmouth as a whole, I would be more reluctant to object. Having read all the details of the application, I do not see the benefits. I have highlighted the negative impact to myself as a neighbour, but after reading through the various documents related to this application, there are further objections that go beyond just the impact to the adjacent residents. Thank you for taking the time to listen to my comments.
Thank you. Any more deputations?
I do, yeah.
Yeah.
I have a deputation to read from the agent.
Okay.
Just bear with me. Just bear with me while I find I've closed it down by accident. Excuse me, sorry, it's just my computer's just being a little bit slow, but it's just opening up.
Chair, may I interrupt?
Yes, Councillor Atkins. Yes.
With regret, I need to leave the meeting.
Yes.
I'm sorry. Apologies to everyone.
Thank you so much, Councillor Atworth, for your contribution this afternoon, this evening. Thank you so much.
Thank you, Chair. Thank you.
Thank you. Bye-bye. Sorry, Rebecca. We'll be back.
No, it's no problem. I'm still sorry. My computer's decided to buffer somewhat. I may have to defer to one of my colleagues to read this one out if I can't get it to open. Oh no, I've done it. Okay, thank you.
Well done.
Right.
Over to you,
Okay.
Rebecca.
Thank you. So this is a deputation made by the planning agent on behalf of the applicants. Statement to present to councillors. Firstly, we would like to thank the Planning Department at Portsmouth City Council for working with the hospital during pre-application and application stages to see our application be presented with a recommendation for approval. Despite lockdown-related work pressures, they have been incredibly supportive and responsive at every stage of the process, and this should be commended. With regard to the single letter of objection received, we are happy to respond to these concerns. They essentially cover loss of privacy, light pollution and air pollution. Loss of privacy. The houses nearest the multi-storey car park are located to the west on the opposite side of Harvey Road. These houses face Peterborough and Boston Road. The western side of Harvey Road contains a line of mature trees on the hospital site which screen the multi-storey car park from views from these residential properties. The distance between the multi-storey car park and the rear elevation of houses is an average 30 metres between buildings, which far exceeds standard privacy distances of 20 metres between residential properties. What is more, overlooking concerns from non-residential proposals to residential properties is not normally applicable, as the nature of the uses would not result in an impact on privacy. The resident is concerned that vehicles at the top floor of the multi-storey car park would have views looking west through the trees into their property. This is not the case. The cladding proposed would prevent views between these properties. This is made clear from the proposed section drawing, and officers have conditioned samples and details of this cladding to be provided prior to installation, which we are happy to accept. We are also accepting a landscaping condition which will involve us planting more trees on the western boundary of the multi-storey car park, which will further screen the car park from residential properties to the west. The western elevation does not have parking facing the west, which will ensure that parking lights will not be projected westwards. Parking is north and south oriented to prevent any impact to residents. Finally, even when some members of the public are to park at the upper levels, which would be the least occupied level, they would not stand at the western edge and look westwards towards the housing to get a screened view through aluminium cladding and a tree-lined property west into a property over 30 metres away. It will not be a common position for a person to stand at. We feel that the concerns over privacy are not valid, and the design of the multi-storey car park has taken into account of the need to protect existing residential amenity. Light pollution. Light pollution was a factor which was raised at pre-application and something we specifically wanted to address in a planning application to avoid a planning risk being sustained. A detailed lighting strategy accompanies the application, which shows light spillage from the building with the proposed lighting design. As one can see from the CGI renders within this report showing lux levels of the lighting, light spillage will not extend outside of the site boundary. Motion sensor lighting will be proposed for parking spaces, but with parking kept in a north-south orientation and with the presence of cladding to all boundaries. Light spillage or nuisance would not be noticeable from residential properties in the houses to the west. Air pollution. Air pollution was a concern which we have tested and addressed during the application. A detailed air quality assessment has been provided as part of this application. This has tested the existing level and proposed air quality levels. The report confirms that the nearest residential receptors will not be subject to poor air quality as a result of this development when assessed against Portsmouth's own guidance on air quality. Dust and fumes during construction will be tightly controlled as demonstrated in the submitted management plans. The multi-storey car park will reduce congestion and parking build-up of people looking for places to park with their engines running. Outside of this application, this proposes only one element of the hospital's plans. Once all are completed, there will be a reduction in parking at the hospital site, meaning that air quality will be enhanced compared to the existing situation. This has been portrayed in some detail within the transport strategy and assessment which accompanies this application. Whilst this development will temporarily increase parking at the site, we have ensured that it has not come at the expense of residential amenity, which has been carefully considered when designing this scheme. Conclusion. We welcome the officer recommendation that planning permission should be granted, and we are keen to commence works on this scheme, which will further aid Queen Alexandra Hospital in enhancing the quality of service at the hospital. Thank you.
Thank you very much, Rebecca. Any more? Is that it?
That's the end of deputations. Would you like me to keep my screen shared with the presentation?
Yeah, fine. I've got Peter who just wanted to come in. Peter Haywood, do you want to come in, sir?
Hello, Chair. Rebecca explained that the Highway Authority had recommended refusal of this application. I wondered if it would be helpful just to explain our thinking to make sure you're properly informed on the decision.
That would be good. Yes, please, if you wouldn't mind, Rebecca, just touching on that for us.
Right. The key issue really is in the period between the construction of the multi-storey car park and any future redevelopment of the emergency department, there will be a significant increase in parking provision on the site, which is compounded by a greater proportion of that parking provision being made available for patients and visitors compared to staff. There is a much higher turnover rate of patient and visitor parking spaces than of staff spaces, so you get an increased number of movements. We determined that to be an extra 1,187 traffic movements each day, about 10% of which would occur in the peak. So it's about 120 extra traffic movements in the peak. Ordinarily, we would require a traffic assessment of the impact on junctions off the site if we saw more than about 30 extra movements an hour. So this is about 4 times the amount that we'd normally ask for an off-site assessment. And no such assessment has been submitted in support of this application in an area where we know we have some concerns for capacity, particularly in peak periods. One of the options that we thought could help resolve that would be to cap the number of spaces that could be operated on the site at any one time to the same level as would be available upon completion of the emergency department redevelopment, should that happen. That would have 2 effects. One, to stop us facing this increase in traffic in the short term, and also to avoid people getting used to there being quite a significant availability of parking on the site, which we then removed when the emergency department happened. I note that that's not explicitly included in the suggested conditions, although there may be scope to achieve that through the parking strategy.
Thank you, Peter.
If anybody has any particular questions for me as we go through, just sing out.
Thank you very much. Rebecca, have you finished with your presentation? Yeah? Ready for...
I have, yes.
Right, I think, thank you, Peter, for clarifying that as well. Councillor Lynn Stagg, I take it as no, we move on to questions. Is that correct? Councillor Lynn Stagg, please.
Yes, thank you. Can I ask, is there any provision for greening up the building? I mean, for example, green walls and trees, because the trees themselves would absorb some of the particulates from the vehicles, but also that would help with screening, particularly on the western side. But green walls as well would take in carbon dioxide and give out oxygen.
Rebecca?
Yes, thank you, Chairman. Yeah, I apologise. This plan doesn't really show it very well, but there are proposals to plant around the edges of the car park, and which is part of. So I would also explain that there is a wider screening strategy for the whole of the hospital, which is being developed and in conjunction with the council's landscape architects. So they have approved this landscape strategy for the car park as appropriate for this type of development. There was consideration given to green walls of the car park, but it wasn't considered feasible for maintenance and sort of liability reasons. So that was discounted. But there are certainly proposals to keep the site green and to enhance biodiversity. I think if you have a look at the amended biodiversity condition in the supplementary matters, you'll see that they are also committing to including bat and bird boxes as part of the design. Thank you.
Councillor Stagg, did you want to come back on a further question?
No, that's fine. I've got comments later on, but
yes,
no,
of course, Councillor. Councillor Matt Atkins, please. You were next. Councillor Atkins, please.
Yeah, thanks very much, Rebecca, and thanks to the applicants who appear to have taken a lot of the kind of key issues into consideration. One thing I was a bit concerned about in the deputation was the idea that lights going on and off in the middle of the night could be a bit of a problem. Could you confirm that the sort of the western screening, will that also deal with that issue? It'll be sort of, it'll enclose light, so the light should be predominantly escaping to the north and the south, should it as well, as a result of the western screening? Or could the lights going on and off at night be an issue for the neighbour's bedroom?
A good point, Councillor Atkins. Yes, Rebecca.
Thank you. As I said, the lighting strategy that they've put together has been reviewed by the council's environmental health officers, and they feel that the measures, that the proposals that are put in place, which includes motion sensors and timing sensors, so lighting would come on at a movement, and if there hadn't been a movement after sort of 5 minutes, it would then go off. It's that sort of lighting at night. And then if you look at the overall sort of Lux diagram here, you can see how the type of lights and the position of lights has been designed so as not to spill out far beyond the car park itself. So it wouldn't our environmental health officers are comfortable that it wouldn't cause significant light pollution to neighbours.
Okay, so but the western screening isn't all the way up then, is it? It's on the top floor.
Oh no, it's all the way up.
Okay.
There's cladding all the way up the side. Yeah.
Okay. Right. Yeah.
Thank you, Rebecca. Councillor Lee Hunt, please. Questions to the officer, please.
Yeah, I read the report thoroughly, particularly about the lighting, which did concern me. But Rebecca, I noticed in the report, was it how many? Some semi-mature trees are coming out, which is what I read. Was it 3 or 8?
It's 8.
It's 8. It's 8. I knew it was a round figure, something like that. It was 8. But the thing is, the trees that are going to go back in. I did read the conditions about lights and trees and the bird boxes, the swift boxes, and the bat boxes. So I'm very pleased about that. But the trees that are going to go back in, are they going to be mature trees, semi-mature trees, not just ordinary sort of whips or anything like that? You know, reasonably substantial trees to get along with.
I believe so. Yeah, it's all, as I said, it's been agreed in conjunction with our landscape architects, so they're satisfied with the details that we put forward. But yeah, I believe they would be more than just the sort of new.
So is that a condition, or is it just part of the subsequent agreement or whatever?
No, there is a condition. There's a condition that requires, in accordance with the landscape plan.
Yeah. Okay.
Yeah, and
I understand how you do that. I just want to make sure that the trees are something substantial, not just whippy little things.
Yeah.
Okay.
Okay, thank you very much, Councillor Hunt. Any more members for questions, please, to Rebecca before we move on to comments? Any more questions, members? No? Okay, so now we're going to move on to comments. I know Councillor Lindstad wanted to get in. I think she did say she wanted a question. Yes?
Sorry, can I?
Sorry, yes, Rebecca?
Sorry, can I jump back in?
Yes.
Just while we're talking about landscaping, as I mentioned in the verbal presentation, the applicants would agree to a condition to enhance the landscaping along the western boundary of Harvey Road. It's not currently in the report and it's not currently in the supplementary matters, but if it's something that members want to agree, then I do have some wording to read out. So I'll leave that as an option.
Thank you for that. We do love lots of options, Rebecca. Thank you. Councillor Matthew Atkins, now we're using the meeting chat, which is great. So Councillor Atkins, you were next. You got in quickly. So Councillor Atkins?
For comment, yeah.
Yes. I think we're on comments now.
Thank you, Chair. I think I mentioned when the previous application for the ward came that it was important to remember that there would be other follow-on applications, such as a need to re-provide car parking. And I do think it's very important that the Queen Alexandra Hospital does have adequate parking. It's not a site where everybody can travel by bike or walk all the time. People need to be there for late shifts. People have sick relatives, urgent things that need to be. And it's obviously a place where people who might be less mobile or feeling ill need to go. So I do think it's very important that the hospital has adequate parking as a way to support its sort of redevelopment strategy going forward. And I think its redevelopment strategy overall is a really good thing. It's fantastic that we're seeing these expansions and improvements at the hospital. And I do think this car park is an essential element of it. That area does see substantial spillover parking onto the roads, despite sort of some parking zones, despite enforcement, even as far potentially sort of Washbeck Road and beyond. And it is important to residents that the hospital has enough parking to support itself. I do hope that the hospital still, has some opportunity in the future to think about the cost of that and how that causes people to park on local roads as well. But I understand that may not be something that's possible at the moment. The design itself is obviously it's a car park, and there's not that much that can be said about it. It's not necessarily the sort of thing we want to see all over the city. But in terms of where it is, it's quite well hidden behind the other hospital buildings. There is a good line of mature trees down Southwick Hill Road, so you won't actually be able to see this from many aspects around the rest of the city, I don't think, especially once the new ward is in place. So I think overall it's needed, it's an important part of the hospital's development strategy, and on its own merits I do think it's an acceptable plan. I think the applicants have done a lot of the things that they can to make a car park more acceptable. I think that the one big concern and the one group of people which I almost feel we should apologise to, because they're slightly taking a hit for, I think, the good of the hospital and good of the Portsmouth, is those residents backing onto it on Boston Road, and I do somewhat feel for them. They're going to have a very large car park. Okay, it's more than a overlooking distance away, but it is going to be pretty visible out the back of their houses, and that's not necessarily going to be the nicest thing. But I think overall, taking into account the amenity issues and the steps taken to mitigate both the light and the overlooking, I think this is as good a design as it could be. I think that the panelling, the panelling all up the western side is very welcome. I would like to see the condition attached to increased tree planting and therefore screening down the western side of the site. So I would like to propose the officer's recommendation with the condition to plant further trees and increase screening on the western side of the site.
Thank you very much, Councillor Matt Atkins. Thank you for that. So you're proposing that, okay. Atkins, let me just do that so I know what I'm doing. Councillor Judith Smythe is next.
I'd like to put my hand in
I'd like to second the approval subject to the condition with the landscaping that Councillor Atkins has just put.
Okay, thank you very much. Councillor Lynn Stagg. Sorry, Councillor Stagg, I'm just going on the chat thing.
Okay, thank you. Yes.
So Councillor Judith Smythe, that's fine. Councillor Judith Smythe, so you're seconding Councillor Matt Atkins with that. Okay, thank you very much. Councillor Lynn Stagg, please.
Thank you, Chair. I'm very pleased to see that there's been an overall reduction in the amount of parking on the site. But like Peter, I'm a bit concerned about the increased number of movements in the day. However, I don't have a go at the staff losing parking spaces, because we're actually working with the two bus companies and QA to develop a demand responsive bus service. So that should hopefully help with a lot of the staff working at the hospital, because it'll work on the same sort of principle as some of the taxis using an app, and you can request a bus. And particularly for the out of hours, the out of normal hours, so people are starting an early shift or finishing on late shift. So that should help cut down the amount of traffic movements going there. So I'm pleased about that.
Good.
Thank you.
Thank you, Councillor Stagg, for that input. Thank you very much. Councillor Terry Norton, please. Comments, please.
Yes, thank you, Chair. No, I would support Councillor Atkins, seconded by Councillor Judith Smythe's comments there, really, and that condition I think is really important, that the tree lines are planted on that side there, so that we're alleviating some of the concerns of residents who are looking on to something that they may not be in favour of. One thing I would say is that I hope that will make their streets easier to park on. So yes, you are sacrificing elements of view, but therefore, where you live, hopefully there is less congestion and parking there. In my ward of Drayton and Farrington, there is a huge issue with workers from the hospital and visitors parking further afield. This idea that people aren't going to be taking their cars to work, I don't think it washes. And then you're left with, as a councillor, in a situation where you decide on, do we go to consultation for a residence parking zone? And I don't like forcing people into that situation where the whole of the city essentially becomes a residence parking zone. So this will help, I hope. I do hope that the hospital in future will look at their staff parking situation there, and cost and how that's managed in terms of the revenue that's drawn from that. But overall, very much in favour. Happy to support Councillors Smythe and Atkins.
Thank you very much, Councillor Norton, for that. Councillor Lee Hunt, please. You're the last one for comments so far.
Just writing my notes. Anyway, and Chair, thanks for this thing. And then, what I'm pleased about with this is noticing more and more is the attempt, the councils, the local planning authorities push to put in more bird boxes, more bat boxes. And it was very nice to see, very good rather, to read in the supplementary planning matters today, that condition. I'm not sure whether we put in the Harvey Road trees offer that was made. I'm just looking for Councillor Norton to nod his head or not, because wasn't paying close attention to that bit. But Rebecca, Miss Altman, she said that they were quite prepared to put in the Harvey Road a bit, and she's got a form of words to do that. So I hope that condition goes in, because we shouldn't miss planting any trees at all. I'm sorry it's not got a green wall on it. We're supposed to be progressive, and we should really be thinking about green walls. But we have to vote on what we've got in front of us, and it isn't there. And I think it's probably, if I said, "Oh, I want a green wall on it," the officers would say that it would be an unreasonable condition, and it wouldn't be done. So, but anyway, so yeah, overall, I'm pleased with it, particularly around the birds and the bats and the bees and so on, and the trees. So that's very good indeed.
Thank you very much, as always, Councillor Hunt. And members, yes, Councillor Terry Norton.
Yeah, just to say, Chair, sorry, so it was Councillor Atkins that has proposed, but I think the answer was yes, Councillor Hunt.
Yes, and seconded by Councillor Judith Smythe, but we'll make sure we vote on the right thing when I speak to Kieran in a minute, Councillor. I'll make sure I get it right. Any more comments, members, before we go to this vote, please? Okay then. So, Kieran,
I've just got a technical question for Rebecca before you move to the vote. Rebecca, sorry, can you clarify whether the new condition for planting on the western edge, do you have a form of wording for that that's summarised in the SMAT report, or is that something you need to go away and draft?
No, I haven't summarised it in the SMAT report, but I do have it in front of me to read out.
Okay,
So
yeah, if you want to read it out so the committee are clear on what they're going for.
Yes, we'd like to read it out in full, Rebecca, so we all know what we're voting for. Thank you.
Sure, yep. Okay, so the condition has been worded as follows. Part A, no construction works above the foundation and slab level shall take place until a scheme for enhanced boundary planting along the western boundary of Harvey Road, to include plant species, sizes and numbers, planting pit and preparation details and maintenance plans, has been submitted to and approved in writing by the local planning authority. Part B, the planting scheme shall be carried out in accordance with the approved details in the first planting season following first use of the car park or the completion of the development, whichever is sooner. And Part C, any trees or plant which within a period of 5 years from the date of practical completion of the landscaping scheme die, are removed or become seriously damaged or diseased shall be replaced in the next planting season with others of similar size and species. And that would be condition 14.
Another long one. Okay, Kieran. So I understand that the motion was proposed by Councillor Atkins and seconded by Judith Smythe that grant planning permission in accordance with the officer's recommendations, and I think we've just heard that. If everyone's happy, are you happy for me to carry on, Kieran? Yes.
Yes, Chair. The motion is to grant permission in accordance with the officer's recommendation and the addition of the condition 14 that was just read out by Rebecca Altman.
Okay, councillors, so there it is in very plain and simple to you. So I will call out your names as per sheet. So please, would you, Councillor Judith Smythe, please indicate if you're for or against the motion, or do you wish to abstain on that one?
For.
Thank you very much. I call upon Councillor Matthew Atkins. Please indicate if you're for or against the motion, or do you wish to abstain?
For.
Thank you. Councillor Lee Hunt, please indicate if you're for the motion, or do you wish to abstain?
I'm for.
Thank you. Councillor Terry Norton, please indicate if you're for or against the motion, or do you wish to abstain?
Yeah, I'm for, Chair. Thank you.
Thank you very much. Councillor Lynn Stagg, please indicate if you're for or against the motion, or do you wish to abstain?
For the motion, Chair.
Thank you. Councillor Luke Stubbs, please indicate if you're for or against the motion, or do you wish to abstain?
He left the meeting due to the interest.
Oh, sorry. Yes, he did. Sorry, my mistake there. So Councillor Claire Oudie, please indicate if you're for, against the motion, or do you wish to abstain?
For.
Thank you very much. And now I'll cast my vote, and I will say for. So I think that is
7 in favour. 4.
Yep, so that has been passed. Thank you very much, members, for that. Very nice, thank you. Moving along very swiftly now, with the next planning officer will now present the next application, and this is agenda item number 8, members. Fontenoy House, Grand Parade, Portsmouth, PO1 2NF. We know we've got Councillor Tom Wood, hopefully, who's with us. Councillor Wood, are you here with us?
Yes, I am, Chair. Thank you.
Thank you very much, and welcome. Thank you for staying with us. And I know that you want to do a deputation on this when we've had the application. So thank you for that. So now I move on to the planning officer to present this next application. Ike, please. Thank you, sir. Can't hear you, sir. You're muted at the moment, sir. Still can't hear you, sir.
So sorry about that.
That's all right.
Thank you, Chair. I'm just going to put my slides up and share my screen. Can everybody see my screen?
Yep, I can see it. I'm not sure if you can make it any bigger.
Yes,
but I will.
I will. Thank you. I'm the presenting officer as well as the case officer for this application. The application that I'm now presenting is planning application reference 20/00158/FUL, with the site being Fontenoy House, Grand Parade. The application seeks permission for the construction of a roof extension to form a 2-bedroom apartment under Class C3 with a roof terrace. It also proposes alterations to the existing building, including improvement works to the brickwork and render to the ground floor, as well as an extension of the staircase and balconies. The application property relates to a 3-story block dating back to the 1950s and situated on the western side of Grand Parade, immediately at the junction with the High Street. The site is located within Old Portsmouth Conservation Area and is adjacent to a number of designated heritage assets, the most significant being the Grade 2 listed building of 63 High Street to the west, 60 High Street to the north, and opposite side of Grand Parade, and the Grade 2 listed telephone box located adjacent to 60 High Street. The site, due to its siting, also forms part of the wider setting of the Square Tower, the Hot Walls, and the Cathedral Church of St. Thomas, all of which are Grade 2 listed structures, so Grade 1 listed structures. The block currently comprises of 8 flats. Planning permission was allowed on appeal in October 2013 to construct a single-storey extension to the roof to form 2 flats, including raising the existing parapet wall. The application seeks to construct a single-storey extension to house a single flat. The applicants propose that the roof of the building will be slightly raised by 600 millimeters beyond the highest part of the already approved building. The roof of the building would be used as a terrace with a frameless, clear glazed railing surrounding it. In addition to this, the plans also propose improvements to the facade of the building, and these will be render to the ground floor, as well as a new brick facade to match historic facing brickwork on local buildings. The plans propose lightweight materials such as zinc cladding and glazing to the extension. In reference to the appearance of the building within the locality, the appeal inspector commented that the additional height would be seen in the context of a variety of heights and styles and the surrounding buildings, and that it was not felt that it would appear over prominent, particularly as its overall height would be less than that of number 60. The inspector went on to conclude that the proposed roof extension would not be harmful to the old Portsmouth conservation area, which would be preserved. The current scheme proposes a reduction in the number of units from two two-bedrooms previously approved to one two-bedroom flat. I'll just run through the slides really quickly. So this is what has previously been approved, and this is the north elevation of what was approved by the planning inspector, and this is what's being proposed currently, the same northern elevation. Down here we've got the proposed east. Well, the proposed eastern elevation is right down here. But previously, the inspector had approved that right at the top there. In the history of this application, there's been an application proposing 2 additional floors, and that's the northern elevation as shown here. So I just put that as a distinction between what's already been approved, what was previously proposed in the middle, and down here what's currently proposed, so you can see the height differences. The design of the designer's proposed incorporates a setback of the additional floor from the existing elevation, and this would ensure that the building appears the extension appears subordinate and does not dominate the whole building. In conclusion, I would respectfully request that members be mindful that there is still a live planning application for the construction of a single-story roof extension, as well as it being 2 flats. It doesn't include improvements to the facade as being proposed by the current application. I think I'll probably stop there for now. And obviously, if you have any questions, then I've got additional slides.
I think we move on to deputations now. Is that correct?
That's correct.
That's correct. Okay.
There are some other issues which followed on from initial publication.
Okay.
So, following the publication of the committee report, the following issues have arisen. Additional comments regarding cycle parking and storage. The Highways Authority do not raise any concerns on highway capacity grounds or safety grounds, but they do have concerns on the lack of cycle parking. As such, if the committee is minded to grant permission, an appropriately worded condition is being recommended to be imposed on the planning permission. This seeks to ensure that the scheme has adequate provision for cycle storage, and this was submitted and approved in writing by the local, in writing to the local authority prior to occupation of the resulting flats. Following from that, 4 further representations have been received objecting to the proposal on the following grounds, and I've summarised them into 3 points. The proposal will detract from and dominate within the locality. The second one is the proposal fails to contribute to the housing stock in the same way the previous previously approved did. And the final one is the design and materials would appear detrimental to the street scene. These issues have all been addressed in the committee report. If I move on to I'll move on to reading out the deputations. Right, I'm just going to read it as it was sent to us. So this one's from Harbour View at 5 Battery Row, and it's from a Richard Bray, Mr. Dear committee members, the proposal of this application is considerably higher than that which was approved in 2013. Its significant height and bulk is both very unattractive, overpowering to the eye, along with far too contemporary. It totally fails to blend in with the heritage within the conservation area. It would be much appreciated by me if the applicants took into account the serious concerns expressed by not just the planning inspector, but also the surrounding neighbours. I see no useful purpose in the glass balustrade at 1.1 meters all along the top at back and front, with which we in Battery Row have to look at for years to come. In trying to assist the planning application by Mr. and Mrs. Phillips, I would agree in part to a 1 meter height increase in the roof space. This at the east end will allow a view. I thank you for listening to my deputation, Mr. Richard Bray. Go on to the next one. I'm a resident of Battery Row in Old Portsmouth and wish to comment on Fontenoy House's latest proposal to construct a mansard roof extension to form 2-bedroom apartment under Class C3. With roof terrace and alterations to existing building, including brickwork, render to the ground floor, and extension of external staircase and balconies. And it sort of lists the application number here, which is 20/00158/FUL. Fontenoy House has already been the subject of numerous planning applications to Portsmouth City Council and an appeal to the planning inspectorate by the applicant. Having regard all the circumstances, it is not equitable to grant the applicant a change of planning application. Thank you for your time and consideration in hearing my written deputation. Yours sincerely, Andrew Spraggs. Go on to the next one. My name is Jonathan Clapham, and I'm a resident of Grand Parade. I refer to the very recent planning inspector's report of November 2020, where the reasons for dismissal of the applicant's appeal against the council's refusal for the 2-story extension, where it stated, and I quote, that the significant heritage assets of the highest importance of the Square Tower, Point Battery, the Cathedral, and Long Curtain, that the 2-story extension would be harmful to both in terms of height and setting and be of very little value for future generations. The proposal is higher than the single story approved in 2013, together with the increase in the roof height and the glass balustrade on top being not visible on the skyline. The overall height is approaching that of the refused application. I am confident that with the planning inspectors many references to height, bulk and setting, that this too would be similarly dismissed on any appeal. I believe that the way forward for the applicant to acknowledge the very real concerns expressed by the planning inspector, his neighbours and the community at large, of whom he states he wants to be a part of and work with the height of. So I'll take that again. I believe that the way forward for the applicant to acknowledge is to acknowledge that the very real concerns expressed by the planning inspector, his neighbours and the community at large, of whom he states he wants to be a part of and work within the height of his already approved single-storey extension. I thank you for your time listening to my deputation. John Clapham. I'll move on to the next one. Dear councillors, thank you for your invitation to submit a written deputation with regards to the above planning application. I request that the following be read out at the planning meeting on the height and design. Living directly opposite to and close to Fontenoy House, there would be a serious loss of light to my home, especially in the autumn and winter months, caused by the excessive and overbearing height of the building, which, together with the balustrade, is approximately the same height as the applicant's two-storey application of 18/01634/FUL, refused by PCC and planning inspectorates on the height of the design. Its height and bulk is incongruous with other properties, listed buildings and the street scene, and is not in accordance with PCC's guidelines for conservation area. This would clearly be apparent when looking towards the Cathedral, Grand Parade and Square Tower. Quoting Old Portsmouth's Conservation Area number 4 guideline for conservation, page 23F, extensions will be discouraged where they would have an adverse effect on the existing building or townscape. Large roof extensions, and this is large, will be discouraged, particularly at the front, where they would lead to loss of original roofs or their features. Page 2, paragraph 26(5), new development and redevelopment. The City Council will oppose the redevelopment of existing older properties unless that development would positively enhance the character or appearance of the conservation area. This is effectively a redevelopment and should be rejected. Thank you for your attention and consideration. Yours sincerely, Ian Woodward. I've got another written deputation here. This one is from R. Blair. With regard to the above named planning application, please could you present/read out my deputation as given below to the planning committee members at the next meeting scheduled for 30 March 2021. Dear councillors, much has been said against the application with regards to its impact of its contemporary design, height and bulk against the surrounding buildings, many of which are Grade 2 listed, such as nearby Square Tower, whose aspect will be seriously impacted. However, what has not been mentioned is the room heights of this design are higher than the previously approved single-storey extension. This, together with the glass balustrade on the rooftop, now makes it much higher, visually getting on close to the recent two-storey application dismissed on appeal. For the reasons alone of the dismissed appeal, I would respectfully ask you to reject this controversial application. Why does the applicant not work within the height of his existing single-storey approved extension, which, with setback terrace at each end, will give perfectly acceptable will give perfectly acceptable harbour entrance and sea views, which is what he is obviously after. Finally, as I said on a previous application, I'm trying to be constructive and not obstructive to get a design sympathetic in this unique heritage part of our city. Got a further objection, and this one is a written deputation. It's actually from somebody called Russell Best, property owner at 76 High Street, Portsmouth, directly opposite the development at Fontenoy House. I object to the proposal at, he gives the reference number, which is 20/00158 FUL, on the grounds of the height, as per the drawings in this application, present us with an unacceptable denial of light to all our floors, to all floors of my property, particularly the lower floors from late autumn to early spring. The proposed single-story development is within 1 metre of the previous two-story proposal, which was rejected. And with the balustrade arrangement, light deprivation will be apparent to 72 to 77 High Street for over half of the year. The applicant's earlier appeal against the council's refusal of the two-story proposal was dismissed in the following terms: given the significant heritage asset of the highest importance of the square tower point battery, the cathedral and long curtain, that the two-story extension would be harmful to them both in terms of height and setting, and be of little value to the future generations. As there is little variance in the height in the current proposal, this design is equally incongruous with the setting amongst the listed buildings and heritage environment. The proposal contravenes PCC guidelines for a conservation area in OPCA number 4 guidelines for conservation. At page 23F, extensions will be discouraged where they will have any adverse effect on existing building or townscape. Large roof extensions will be discouraged, particularly at the front, where they will have an adverse visual effect on the existing building or townscape, or where they would lead to loss of original roofs or their features. B, and again at page 26.5, the new development and redevelopment. The City Council will impose the redevelopment of existing older properties. I'll take that again. The City Council will oppose the redevelopment of existing older properties unless the redevelopment would positively enhance the character of the appearance of the conservation area. The impactful nature of this proposal means it fails to meet these criteria and should be rejected. Russell Best, OBE. I think, and now I've got one from Friends of Portsmouth. This is the third development this applicant has applied for to maximize their volume of their development. The application will increase the height and the useful space of the structure by 2 stories. The deposited plans are misleading as they minimize the actual impact of the structure. The roof terrace, a minimum of 1.1 meters, will be clearly visible and add to the height and bulk of the building. A key reason the previous application was rejected by you and the Planning Inspectorate. The report ignores the key point. The height of the building, the height of the roof of the application, which was rejected by the planning inspectorate in 2020, has been requested but has not been provided by the planning department. However, comparing the elevations, this proposal with a roof terrace replicates the application refused in 2020. Therefore, paragraph 6.1 is incorrect. The statement in paragraph 6.5 of the report is also incorrect. This property has permission for 2 flats. The application is for 1. The proposal will add approximately 1.6 meters to the height of the building approved in 2017, and this is nearer the height of the application which was rejected by this committee and the planning inspectorate in 2020. Please reject this application and advise the applicant to submit proposals which are compatible for their use and with the current planning permission. I think I'll call on my colleague Rebecca to read. I think there's about 3 left. She can just read those. That'll really help.
Okay. Go and get yourself a drop of water.
I'll do that. Thank you.
Thank you, Chairman. Thank you, Ike.
You read the rest.
I'll just read the last 3. So this one is from Fontenoy House leaseholders. Can you hear me okay? Yep. My name is Anthony Knight and I am the chair of the Fontenoy House leaseholders group that includes 8 leaseholders. The leaseholders group has existed for over 15 years. We are a mixed social group with ages that range from mid-30s to mid-80s. 2 owners are pensioners and 2 have families with young children under 5 years. 5 are owner-occupiers and 3 rent. 6 have been owners for over 10 years. 2 flats are currently up for sale and 1 has been empty for 4 years because of development uncertainty. There have been many discussions between leaseholders and the planning applicant. We have always felt that the applicant has been open and cognizant of leaseholders' views throughout. This was not the case with the 2 previous landlords, Shiplands Estates Limited, Longbow Limited, who were regarded as uncooperative and profiteering. As a group, we can attest that the applicant has always been fully engaging and has disclosed their plans and intentions at every stage of the design and planning process. The proposed development affects each leaseholder differently. Sorry, I'm getting a bit of feedback. Is everybody else hearing that? I'll start that bit again. The proposed development affects each leaseholder differently. Some sense a loss of privacy. The majority feel that there are no significant losses and only gains. One objects to the addition of an internal lift and another is grateful as it helps with their disability. Some wait on a decision prior to extending their lease. Despite the various individual views, the consensus is that this proposed design is significantly better than the existing planning approval for a single extension to support 2 additional flats. The new planning application design is less imposing and the lighter colours blend well with the Grand Parade setting. The refurbishment provides a grandeur to Fontenoy House, which it never previously had. The newly proposed design also has a subtlety in keeping with other post-war rebuilding in Portsmouth and adds to the eclectic attraction that Grand Parade presents. There are 3 key points leaseholders considered in making our decision to support the planning application, which I would like to bring to the attention of councillors. They are: the applicant will be an owner-occupier and has strong vested interests. The application addresses the whole building, unlike the existing planning approval. The new building design significantly improves the appearance and quality of Fontenoy House. For the majority, this planning saga, now in its 8th year, has caused great inconvenience and frustrations. Those that wish to improve their properties have felt unable, while the planning intentions have been unresolved. Those that wish to sell feel that they are hindered, while there remains doubt about the planning outcome, while the owner of the empty flat also seeks some resolutions. Fontenoy House leaseholders recommend that the councillors approve this planning application. The new planning design fits well and meets the requirements of all, except for those that refuse to embrace change. That concludes that particular deputation. This is the second one in support. My name is John Pike. I am the applicant's agent and I have more than 40 years' experience dealing with planning and heritage-related matters, both as a local authority officer and consultant. Planning officer's support for this application is noted with thanks, but I would like to reinforce a few points that I believe are critical to the committee's consideration. Committee will be aware that there is a valid planning permission to construct 2 flats on the roof of Fontenoy House. This permission does not include any enhancements to Fontenoy House itself. The application proposal in front of you includes significant improvements to the external fabric that are integral to the scheme. If permission is granted today, they will be carried out in full, resulting in a significant uplift to the appearance of this part of the conservation area. The images shown to you by the planning officer confirm that there is no material difference in the height proposed compared to the highest part of the permitted scheme, excluding the roof terrace. The slightly increased footprint of the proposed apartment would have no real impact on its appearance from nearby streets compared to the permitted scheme, but would improve the relationship with the rear of houses in Battery Row by excluding the lower level roof terraces. It should be noted that published guidance for Old Portsmouth conservation area support 4-storey development. The roof terrace proposed would be set well back from the edge of the roof, and this, coupled with the use of frameless glazing, would ensure near invisibility of the roof terrace. Please refer to the images of similar roof terraces in this part of Old Portsmouth that are with the planning officer. To conclude, there is a simple choice for the committee. The current scheme, which would improve the entire Fontenoy House, compared to the permitted scheme, which would merely add 2 flats on the existing roof with no other enhancements to the building. John Pike. And I believe this is the final deputation to read. Dear Planning Committee members, about us. We have both lived in Portsmouth since attending the university in 1988. Our business is based in Portsmouth. Our 2 sons attended Priory School and Portsmouth College. Portsmouth is our family home. Fontenoy House will be our forever home. We met the planning committee members at our original planning committee meeting on the 11th of the 9th, 2019, when our plan for a 2-storey development was refused. There is currently approved planning permission for the building of 2 2-bedroom flats. The planning committee members' comments were: 1. Minutes. The dark colours and mass of design are unattractive. Now light colours are used. The scheme has 1 less storey and has been designed to further reduce mass. 2. Minutes. Fontenoy House is not a particularly attractive building and could be significantly enhanced. As mentioned below, our scheme looks at improving the building as a whole in every aspect. The current approved planning permission does not consider any of the building except the 2 new roof flats. 3. Minutes. A 1-storey extension might be acceptable, but that change is too big to be considered for deferral, so a new application would have to be submitted. This is our new application for a 1-storey extension, which is 2.7 metres lower than the 2-storey scheme. 4. Recollection. The windows and wall colours are too dark. Windows are now changed to white and the lightest colour zinc will be used. We have listened and implemented your suggested changes and feel that they have improved the look of the building and how it fits in with the surrounding building. Height of this proposal. 1. Our proposed scheme is the same height, actually 2 millimetres lower, as the current approved scheme, not including the frameless glass balustrade on top of the building, which is set back from the edge and nearly invisible as the planning department's photos will demonstrate. 2. It will be up to 6.3 metres lower than other buildings on the opposite side of Grand Parade and up to 2.1 metres lower than the other buildings in Grand Parade Battery Row quadrant. Please see attached photo and comparison table of all surrounding buildings. It is 2.7 metres lower than the 2-storey scheme. Benefits our scheme will bring over the current approved scheme. 1. The current approved scheme was prepared by a property development company. Its aim is to plonk 2 new 2-bedroom flats on the roof of Fontenoy House. It offers no improvements to the rest of Fontenoy House, a profit-driven scheme. 2. The current approved scheme has rearward-facing terraces and windows along the rear. These were objected against by Battery Row residents as they felt they would be overlooked. We have completely removed these rear terraces and have ensured any windows facing the rear use obscured glass. We have consulted with and listened to our neighbours in developing our proposed scheme. 3. Our proposal looks to improve all of Fontenoy House, at our cost, not to the residents. We are doing this because Fontenoy House will be our forever home. The residents of Fontenoy House will be our neighbours. The location of Fontenoy House and the historical importance of this location deserves for the whole building to be improved. 4. We will improve for all residents, full facade of the building, all the windows, doorways in the building, refurbish communal hallways, install a shared lift to the building, secure the tired roof, improve the communal yard area, improve energy efficiency of the building, improve security features and fire safety systems in the building, including extended and refurbishing the fire escape, and also look to add a historic plaque which shows an image of the York and Pier Hotel, Grand Parade Hotel, which stood on this site prior to it being destroyed in 1941. Around 1860, it was a resort for naval captains and known as the 4 o'clock Club. 5. 7 of the 8 Fontenoy residents support the scheme. All residents objected to the current approved scheme, and for this reason we would not consider building the current approved development. Grand Parade, as the name suggests, is the grandest parade in Portsmouth. The amazing balanced architectural entrance to Grand Parade was unfortunately destroyed during the Second World War. It was replaced in the 1950s during a time of austerity by the functional utilitarian building which currently stands on the site. Over time, this building has become worn, uncared for and tattered. We can't bring back those incredible buildings, but we can do our best to improve the appearance and condition of Fontenoy House and this part of the conservation area by slightly increasing the scale and grandeur of the building, more in line with the previous buildings on the site. We hope to make it worthy of its incredible location at the gateway of Grand Parade and hopefully call it home. We hope you are able to approve our planning request. Thank you. Jason and Kate Phillips. And that concludes the deputations. Thank you.
Thank you very much, Rebecca. We're now moving on to Councillor Tom Wood, who wants to do a deputation. Just to remind Councillor Wood that there is no time limit, so please go ahead and please, if you could do your deputations to the Planning Committee. Thank you very much.
I'll be as brief as I can, Chair. Thank you. Conservation in the area of outstanding seascapes and views is open to interpretation, but should be a level playing field for all residents surrounding to maintain and conserve some status quo and not instigate a race to the sky initiated for a single applicant. This area's built skyline is akin to a football terrace or an arena where everybody has a fair established view, but any people now standing up in front unfairly on raised boxes is bound to impact the status quo elsewhere and behind and lead to an outcry as unfair if they constrain themselves to the heights as the high street properties in the past. Otherwise it becomes a free-for-all on what people can get away with if a precedent is set. This will mostly impact many of the high street properties opposite, basically at the same height, and many of the upper and middle flats in Grand Parade opposite. So many will be impacted by the increased bulk at the expense of a single planning application gain. This planning application pushes the boundaries of what had been agreed fairly and clearly rejected. In May 2017, permission was given by the planning inspector as a single-storey 2-flat, and then in November 2020 for a double-storey height was rejected by the planning committee and rejected by the planning inspector on appeal. Clearly, the acceptance and rejections of the previous planning applications had a large part to do with the bulk of this building. So many residents would disagree with these recommendations that a half-metre allowance plus the additional glass balustrade will not have a material impact. The bulk has been the main concern of surrounding residents. 8 flats of 1 or more bedrooms plus and another couple of garage means on the existing 3 floors and an average of 3 possible flats a floor, surely much more than enough for somebody living in a footprint with a similar floor or for the penthouse flats without wanting to push even more height at the expense of those around. This design is incongruous with the setting among listed buildings in heritage environment and contravenes PCC's own guidance for a conservation area. We ask that you reject this push to the sky in favour of allowing the planning permission which has already been granted, which would be the fair thing for all local residents impacted. Thank you, Chair.
Thank you very much, Councillor Wood, for your deputations. Can I also thank everybody that's written in on behalf of the committee to thank you all for writing in today. So now, members, we're now going to move to questions to the officers, please. Right, here we go. Let me just have a little look. Councillor Luke Stubbs, you're in first. Councillor Stubbs, please. Questions to the officer.
Yeah, thank you, Chairman. I just want to get to the bottom of this question of height, because that appears to be the core of the issue, at least so far as people living in the immediate locality perceive it. So we heard on the one hand, so forgetting about the balustrading for the moment, we heard from the applicants that the building without the balustrading is basically the same height as the appeal scheme. And we've heard also concerns from residents that this building is significantly taller. So setting aside the balustrading issue, is this proposed extra flat, is it taller, significantly taller than the appeal scheme or not?
Mike?
Thank you, Chair. I think for this, I think I'll just put up my slides again so I can explain it better. I'm just going to share my screen with you.
Yes, please. That would be helpful.
Right, there we go. So what's actually happened is oh, hold on. I think if I get the pointer out, that might help.
Can you make it any bigger as well?
Yes, of course. I'll do that.
Yes, please.
Oops. Wrong one.
If you can make it bigger and then you right click and you'll see pointer options or something.
Thank you.
Thank you. You put it in presentation mode. Thank you. Pointer options. Lower down, 2 steps down from where you are now.
Great, thank you.
Thank you.
Right. So from this bit of the building, because this we're looking at now is what was previously approved. So from this, from the top of the building here, it's going up 0.6 of a meter higher than what was approved. So that's in terms of the height of this building, without including the balustrade. It's just this bit here is 0.6 higher than that bit there.
Councillor Stubbs?
Thank you. No, that's all I wanted to ask.
Thank you very much. Thank you, Councillor Stubbs. Councillor Matt Atkins, please. A question to the officer, please.
Thank you. Actually, Councillor Stubbs asked one of the same questions I was going to ask. I had a follow-up, though, which is, how much higher then was the two-storey? So we've got 0.6 extra for this. How much more would it have taken to get up to the two-storey? How tall was the two-storey extension that was, the planning inspector accepted should be rejected?
Unfortunately, I don't have that figure to hand, but I imagine. It would have been quite significantly taller, but I don't have the figure to hand.
Yeah. And as a second point, what is the justification for wanting the extra 0.6 of a meter? Is it just higher ceilings?
No. It's according to the applicants. It's actually for insulation purposes. The previous one, which was done, didn't have. So it would be that scheme didn't have enough room for insulation in the roof. And I think that's what these guys are trying to do. They're trying to make sure they keep as much of the warmth within the building.
Yeah. Is the new application slightly closer to the edge, or is it the same on most of the aspects? I know it says on one of the aspects it's slightly larger in the footprint, but is it close to the edge most of the way around, or just?
It is. It is similar to what was approved, or most of the way around. It's only sort of in that point there where it gets closer to that building at the back. See if I've got. So at this point here, it comes closer to this boundary than the previous one did.
Yeah. Yeah, okay, yeah, no, I see that. Yeah, that's helpful. And then finally, the balustrade proposal, is that to allow people to go up on top and make it a kind of roof terrace? That's the point of that, is it?
That's absolutely correct. But as far as I can see, it's only for the occupiers of this
Of the top
additional
of the
property.
penthouse.
Correct. And also in terms of in terms of what they're looking for, so that's actually going to be frameless, it's going to be rimless, and it's going to be clear glazed. This is all just to minimise impact.
My final question then, I was slightly disappointed to see it was a reduction from 2 flats to 1 in the sense that Portsmouth could do with more housing. You've basically said in your report that's not something that's really material. Is that correct? The reduction from 2 flats to 1, or is that something the planning inspector did take into account?
I think at this stage it probably would have been ideal if we had more housing. But however, I don't know that we can control them in that way to to mandate them to provide 2 when they've sort of put an application in for 1 at least more spacious flat.
So it's not a factor in the planning inspector's decision to allow them the planning permission before, on the basis that they're creating 2 houses. It's not a big enough difference that they're only creating 1 that it would justify refusal, basically.
That's what I as an officer that's the way I see it.
Thank you very much, Councillor Atkins. Councillor Luke Stubbs, you wanted to come back, please, with a question?
Yeah, just a different question, actually, you're sort of flowing out of that. So, as far as this roof space is concerned, my understanding is that you don't need planning permission to, walk around on a flat roof, and that therefore the usage of the roof as an accessible space is outside of planning. The only bit that is inside of planning is the appearance of the balustrading. Am I right in thinking that?
Ike?
I think I would probably refer to one of my colleagues to answer that question. But as far as I know, in cases like this, we would generally put, if we didn't want, if there was an application and we didn't want the use of the roof in that way, we would generally put a condition on there saying no use of the roof for that sort of purpose. But I think I don't know if any of my colleagues, probably Ed, would have something to say on that.
I think Ed may want to come in, but Ike Izzy sort of said that he might be interested in coming in. Izzy, will you be able to come in on this one?
That's fine. I think Ike just nailed that.
All right. Okay.
If members were minded to go in with an approval officer's recommendation, members could be minded to put in a condition restricting the use of the flat roof as an amenity space for reasons of amenity, reasons of design, and on those 2 grounds, I think we can't decline them using that as amenity space.
Well said, Izzy. Okay. Anybody else for any more questions before we move on to comments, members? No? Okay then. So we'll move swiftly on to comments, and we've got Councillor Lee Hunt who wants to add a comment. Councillor Hunt, please.
Yeah, I've listened carefully again, made some notes. I've been going along, and I'd just like to say that I've looked at this, and the whole thing, this new proposal, is overbearing and overly dominant feature atop the recipient building by way of its mass scale and its height, the materials and colours which are incongruous, adversely impacting the street scene and the built environment in this heritage area. So I want to overturn the officer's recommendation, or amend the officer's recommendation to refuse this application for the reasons I've just given.
So you're proposing for refusal, Councillor Hunt, yes? Okay, thank you very much. There's one on the table. Members, any more comments, please? Councillor Luke Stubbs.
I think I'm going to make the other possible recommendation here, that we grant consent that this application that has moved our way, since it is obviously there's been multiple applications at this site, but the views of the committee have been taken on board. I think that, look, obviously any extra height is regrettable, but we've been offered a justifiable reason for that with insulation, and I'm also cognizant of the benefits to people in the remainder of the building. So for all of those reasons, I would like to propose the report.
Okay, so you're proposing for permission, what the officers have said, Councillor Stubbs, that's fine. And we've got one for refusal, Councillor Lee Hunt. Now moving on to Councillor Matt Atkins, please. Councillor Matt Atkins.
I recognise the strength of feeling in the local area around the fact they don't want a development on the roof of Fontenoy House. And a lot of people in that area, clearly don't. And they're obviously somewhat irritated to find it coming back to committee again for an extra 60 centimetres. But the reality is the planning inspector has given permission to put a one-storey extension on the top of Fontenoy House. And we have to ask ourselves the question, could we, really face the taxpayers of Portsmouth and say, we could justify denying permission on the basis of 60 centimetres in a way that's not just going to immediately result in this going to the planning inspector going, what on earth are you doing at 60 centimetres, and sending it back with permission. So I do appreciate the strength of feeling in Old Portsmouth. I think it is unusual of the applicant to continue pushing for that extra bit of distance, but perhaps it genuinely is about sort of insulation. It could be roof strengthening, any kind of thing. I think we would still have plenty of grounds where they to attempt to ever come back with 2 stories to say no, because clearly, the difference, 60 centimetres is not going to have got them anywhere near to the second story. So I don't think there's any question they could creep the height up, if you see what I mean. So there must be a genuine reason for the 60 centimetres. The insulation reason makes sense. And then apart from that, it's just not really any bigger. I mean, perhaps this is why we shouldn't hold these planning committees in Perda, but I respect the residents' concerns around this. I respect that this has been a long and an annoying planning process. I would say for all concerned, the residents of Fontenoy House, the applicant, and also for local residents. But I think it's probably time we put an end to it and accept the planning inspector has said a one-storey extension on this building is acceptable. A small tweak to the design such as this is going to be considered acceptable as well. And so I think we are forced to accept, I feel forced to second Councillor Stubbs' recommendation for approval here, to proposal of the officer's report, because I think we are just wasting more time and wasting the council's money if we attempt to refuse this, because there's a lot of residents who oppose it. And I think that's the ultimate reason we would be refusing this, is because we know that a lot of residents don't want it. We've been told by the planning inspector it's acceptable. I think we just have to swallow that and vote it through. There is really no difference between this application. I think the officer is entirely right. There is really no difference between this application and the one that the planning inspector has deemed acceptable, other than it is 60 centimetres taller and it's 1 flat instead of 2. We might regret both those things, but it's not going to make enough of a difference to justify refusal. So I second Councillor Stubbs' recommendation. Proposal,
Okay.
sorry.
Yes, thank you. So we've got, for permission at the moment, we've got proposal is Luke Stubbs and seconder Councillor Atkins. For refusal at the moment, we've got Councillor Lee Hunt and possibly somebody else in a minute, if we can get anybody. Okay, anybody else? Any more comments? Yes, sorry.
I'm happy to second Lee Hunt's
Okay.
proposal.
Could you tell us on what grounds, Councillor Stagg, just so we've got the same as what Councillor Hunt
Yes, I think it's totally out of character.
Sorry?
Sorry. I think it's totally out of character with the area. And 600 is it 600 millimeters, whatever it is, it doesn't seem very high, but it is, I think, on top of, it's already quite a tall building. And this is just rehashing, it's just another variation of what they've asked for in the past and which has been refused. So.
Okay, so we've got 2 and 2 then. Okay, members, any more comments before we do our voting? Any more comments at all from anybody else? Okay then, Kieran. So we've got 2 on the table. I take it I go for, is it Councillor Hunt's one first, Councillor Lynn Stagg's one? Is that correct, Kieran?
The order in which they were seconded, the first to be seconded was the motion to go with the officer's recommendation from Councillor Stubbs. So if we could start with that one, please.
Yes. Okay then. So members, so we're looking for permission to grant permission proposed by Councillor Luke Stubbs and seconded by Councillor Atkins, and they're looking for permission. Is that correct, Kieran?
Yes, that's correct. It's in accordance with the officer's recommendation to grant planning permission.
Thank you very much. I just wanted to make sure I get that right, members, because it, must make sure I get it right. So, okay, so I call upon Councillor Judith Smythe. Please indicate if you're for or against the motion, or do you wish to abstain at all, Councillor?
I'm for, Chair.
Okay, thank you. Councillor Matthew Atkins, please indicate if you're for or against the motion, or do you wish to abstain?
For.
Councillor Lee Hunt, please indicate if you're for or against the motion, or do you wish to abstain?
Against.
Okay. Councillor Donna Jones and Councillor Terry Norton, please indicate if you're for or against the motion, or do you wish to abstain?
For.
Councillor Lynn Stagg, please indicate if you're for or against the motion, or do you wish to abstain?
Against.
Okay. Councillor Luke Stubbs, please indicate if you're for or against the motion, or do you wish to abstain?
For.
Councillor Claire Udy, please indicate if you're for or against the motion, or do you wish to abstain?
Against.
And me as chair, and I'm against that. I think it's too big. I'm against that. Okay.
Right, there are 4 who are for and 4 who are against.
Is it down to me again? So yes, I
yes,
don't. Yeah. Sorry, it's down to me, Kieran. Yes,
yeah,
well, I carry on with what I'm saying. I totally agree. I'm against it. So that one falls. And yes.
Yes, if it's 5 votes using your casting vote against,
yes.
4
okay.
in favour. Yes, the motion falls. Members, I realise an error on my part there. There was also mooted a condition restricting amenity. Sorry, the use of the roof for amenity purposes. That was entirely my fault, not yours. Now, obviously that motion has failed, and we're open to consider a subsequent motion. If the proposer, after we've considered this next motion, were to want to feel that we would go back and explicitly reference that condition, because we didn't, and that was my fault, then we can do so. But at the moment, the next motion for consideration is the refusal in accordance with Councillor Hunt's proposal.
Councillor Hunt, did you want to say something on that?
When can we put that condition? We can still apply a condition, Kieran?
Well, because you're proposing to refuse it outright, aren't you?
Yes, indeed. So nothing.
So there wouldn't be a condition attached to yours, no.
Yeah. So nothing needs to come afterwards.
No, not in the event that your motion was successful. That would be the end of the matter.
I beg your pardon. Yeah.
However, if that were to fail because other members wanted to be explicit, there was a condition to be added, then that condition could be salvaged if it wasn't clear it was attached the first time.
Okay. Okay, thank you, Kieran. I think you've explained it. So the next voting is for refusal, and this was proposed by Councillor Lee Hunt and seconded by Councillor Lynn Stagg. So obviously I'll read your names out if you can say if you're for or against that motion, or do you wish to abstain. Councillor Judith Smythe, please indicate if you're for or against the motion, or do you wish to abstain.
I'm against refusal.
Thank you. Councillor Matthew Atkins, please indicate if you're for or against the motion, or do you wish to abstain.
is a laughable waste of time and money, and so I'm against.
Okay. Just to remind you, Councillor, we're just voting. You've had your moment about
It's a
comments.
massive disgrace.
I know. Well, that's your opinion, Councillor. Thank you. Councillor Lee Hunt, please indicate if you're for or against the motion, or do you wish to abstain?
I'm for the motion.
Thank you. Councillor Terry Norton, if you're for or against the motion, or do you wish to abstain?
Against.
Okay. Councillor Lynn Stagg, for or against, or do you wish to abstain?
For the motion.
Councillor Luke Stubbs, please indicate if you're for or against the motion, or do you wish to abstain?
Against.
Councillor Claire Moody, please indicate if you're for or against the motion, or do you wish to abstain?
For.
And I'll cast my vote, and I'm for it. So could you add the numbers up, please?
So that will be 4 who are for and 4 who are against.
So I stick to what I've said before. Totally agree with Councillor Lee Hunt and Councillor Lynn Stagg for refusal. So, okay, thank you very much, members. Now move on to the next bit, if we can. So we're moving over to St Helens Pavilion, which is the last one, which is at Eastern Parade, Southsea. Sorry, I've got planning committee. Please leave you now. Highway issues final application. Thank you very much, sir. Yes, sorry, I'll go over now to Rebecca, who's going to tell us about St Helens Pavilion, Eastern Parade, Southsea, please. Thank you.
Thank you, Chairman. I am just sharing my screen, which again is oh, I think that's worked now. Does everyone see the presentation?
Yes.
Yep, thank you.
Yeah.
Okay, so this application relates to the cricket pavilion, which is on the northwest side of the cricket pitch on Southsea seafront, just south of Eastern Parade. I've got a few photographs there just showing the pavilion as viewed from the surrounding streets. It's a dark brown clad building at the moment, wood-clad building, which faces the main elevation faces into the cricket grounds itself. And sort of from the public footpath, you sort of see the rear of the building and some storage areas beyond the fencing. And then this picture is taken further down the footpath, looking back up towards Eastern Parade. And then some closer up photographs that are provided by the applicants. The application is for alterations to the building, mostly internal alterations, but it would involve a small infill extension in this area here, which I'll show on the plans in a minute as well, an expansion to this balcony at first floor level, and an expansion to this terrace area here at ground floor level. The building would then be completely reclad in a mixture of white render and white cladding. So this shows the site plan as it is proposed, which will have the extension in this area here. But it's probably better if I show you the floor plans. So this is the floor plan of the existing pavilion, and this is proposed. So this terrace here would be extended outwards slightly. There would be an infill extension in here, which measures 4.6 meters squared, and the majority of the rest of the alterations are internal, with the aim of creating better changing space, in particular to allow better women's facilities within the building. And at first floor level, the main change relates to the balcony here at first floor level, which will be extended outwards and sort of oversailing the ground floor level there. You'll note in the report, a consideration had to be given to the loss of public open space because technically the bit in front of the pavilion is classed as public open space, but the extended area is so small and infills an area of the existing building that as a council, local authority, we don't consider that to represent any sort of significant loss of public open space to any degree. In terms of the elevations, as I said, the main change is that it would be going from a brown sort of clad building to very much a white appearance with white cladding and white render. So that would be the front elevation facing to the southeast, and the other elevations which are sort of adjacent to the fencing. So the recommendation is for conditional permission. You will note a couple of corrections that are written into the supplementary matters and a slight amendment to condition 3, which just relates to the fact that it is a new materials being used rather than matching materials. And I do have a deputation from the applicants to read out.
Yes, please.
Which I will do now for you. I have no deputations against. So this is from the applicants. I would like to thank Councillor Fuller and other members of the Planning Committee for giving me an opportunity to provide a short deputation in support of our application. Portsmouth Cricket Club is a community-focused, volunteer-led cricket club that cares deeply about cricket in Portsmouth, increasing participation in the game and the health and mental benefits of sport more generally. As a club, we operate 4 men's teams that compete on Saturdays over the summer and a Sunday team. Our first team were the 2016 Southern Electric Premier League Division 2 winners and are now competing near the summit of Division 1. As a result, we are the highest performing Portsmouth-based cricket club in the Southern Premier League. Similarly, our second and third 11s have also achieved promotion in recent years, competing within the Hampshire Cricket League in Division 1 and Regional 1 respectively. As a club at the heart of Portsmouth community, we take a lot of pride in our Colts setup. The club has about 350 Colts plus parents and social members. In normal years, each Friday there is a fun training evening at which about 100 of these Colts and their families attend, and we run a barbecue with coaching often provided from senior players from our first and second team that have themselves progressed through our junior system. These Friday nights are often the first step of many children's cricket journey with Portsmouth, then progressing through their respective age group based teams, weekly training and summer academy. There are a total of 7 Portsmouth age group teams from under 9s to under 15s, with a further 2 competing in the under 17 and under 19 knockout T20 competitions. We also run an ECB accredited All-Stars programme aimed at 5 to 8 year olds attended by 50 children in 2019. Plus this year will be Dynamos aimed at 8 to 11 year olds. We are incredibly pleased that in recent years we have been attracting more and more girls to the game of cricket. We run a women's softball W10 team, are looking at setting up a women's hardball and have more than a dozen girls selected to represent our district and or Hampshire last year. This brings me to our application. Unfortunately, our clubhouse is now over 50 years old and was designed in an era when women's cricket was not a consideration, and the layout of the clubhouse reflects this. There are currently 2 major changing rooms, showers and an umpire's room. However, these are all accessed via the men's toilets. There is no dedicated disabled toilet, although we have tried to make some adaptations and a series of storerooms whose purpose has long since been forgotten. Our women's toilet has been refurbished and in recent years and enhanced. However, we want to do much better than this. Over the last 12 months, we have been working with local architect and club member to look at what can be delivered within the existing building and with the smallest possible expansion. At this point, I would like to thank officers within the council, property and leisure departments who I met with on site last year to discuss our ideas and who consented to the submission of this application. What we have come up with, I hope, balances the needs of our club, the community and the protection of open space in the city. By removing the storerooms and changing the position of the barn, we are able to create 3 good-sized multi-purpose changing rooms which all have their own access, meaning that on a regular training night we will be able to provide a changing room for the coaches, one for the male players and one for the female players. We are also planning to improve the toilet facilities by creating a bespoke disabled toilet adjacent to the main entrance. Importantly, we can create this thanks to clever design and an extension of just 4.6 square metres. Other improvements include slightly enlarging the scorer's balcony with access by stairs rather than a ladder, and new cladding and insulation to the building to improve the appearance of our clubhouse and energy efficiency. The total project cost is some £75,000, which represents a considerable investment in the future of cricket in our city. To pay for this, our members have been working extremely hard raising funds. Our crowdfunder page alone received 259 pledges, raising around £27,500, and with other donations, grants and so forth has meant that we are in a position to not only start the work but complete it in full. Members, I commend our application to you and urge you to support this much loved and well supported community facility by granting approval today. Kind regards, Rick Marston, the Chair of Portsmouth Cricket Club. Thank you. That ends the deputations for this item.
Thank you, Rebecca. That's very good. Thank you. I'm going to move to questions from members, and we've got Councillor Terry Norton who's come in there. Councillor Terry Norton, questions to Rebecca, please.
Forgive me, Chair, I got ahead of myself there. It must be late. It was just a comment, really.
Sorry. Okay, I'll come back to you in a minute then. If I don't, I shouldn't forget you anyway. Councillor Matt Atkins, then, can we have a question from you, please?
Do you have a picture of it in context, as in its surroundings, and basically why white instead of brown, and do you consider that an improvement? Because it could make it stand out rather. That's my only thought.
When you said I have a picture of it in its context, you mean like a CGI of its new design in its context?
Well, either of them, or not just a picture of the current cricket club.
Well, I have only the photographs.
The level of, yeah.
Photographs that I showed at the beginning there. So this is from the footpath along Eastern Parade. I mean, you view it through the fencing.
Yeah.
And then this is from the footpath that runs sort of from Eastern Parade down towards the beach. That one there, you can see the rear of it. And then this was me looking back, but photographing over the fence itself. So
yeah, so it's fairly visible from the seafront, isn't it? But not too visible from the houses behind. So would that be fair?
Well, it is. This is taken from the opposite side of Eastern Parade. There is a tree that screens some of it, and you can see it. Sorry, the sun was in the wrong place really, but you can see the building there and there from Eastern Parade. So yes, the white colour would certainly make it, I think, more visually prominent, but it's considered to be an acceptable design solution, and it's not getting bigger. It's very much designed more or less in the same sort of size and scale, so it is considered to be acceptable.
It's cricket white, I suppose.
Yeah.
Any more questions to the officer at all before we move on to comments, members? Okay, so we're going to move on to comments then, and Councillor Terry Norton, you were first, so I'm going to go with Councillor Terry Norton. Councillor Norton.
Yep, thank you, Chair. Not a contentious one at all. More than happy to propose recommendation of this. I think the applicant is right. Actually, I agree with their comments. Portsmouth Cricket Club is a fantastic local cricket club, and something that allows multi-sex changing and disabled facilities is as clear cut, I think, as it comes. Really, fantastic that they're working hard as well to get to promote women's sport and get girls involved in sport. So a really clear cut decision, I think, on this one. I know the tennis club next door have a balcony as well, and it's a lovely site there. So 100% yes from me. I think the plans look great.
Yeah, good. Councillor Atkins, you were next, followed by Councillor Lee Hunt.
Well, mine was actually still my question, but I'm happy to second Councillor Norton's recommendation.
Okay, thank you very much. Councillor Lee Hunt, please.
Yeah, so I was going to second it too. Clamouring to second, all got our fingers poised.
I don't want to be accused of anything. I'm trying my best.
That's all right. Everyone knows Terry Norton. He's learning. Anyway, I want to say this. So let's not forget that this club, Portsmouth Cricket Club, the grounds and the maintenance and everything and buildings all used to be done by the City Council. So when I was in the chair of Culture and Sports, we handed the grounds and maintenance and everything over to Portsmouth Cricket Club. Same with the tennis next door, which people have just referred to. Passed over to a philanthropist, and the result of that is getting the council out of it. You see these applications. We're here today. They're going to spend £75,000 on the club, a building. That's £75,000 that taxpayers would have to pay for, but their members have raised it this way. So this is part of the big society and so on. As the government reduces funding for things like this to local councils, people are getting on and doing it, and that's got to be a good thing. What I do want to praise the club for is how they have increased membership, women's membership and girls' membership. This year, for the first time ever, there will be more women going to the Olympics in the GB team for the first time. And when the Commonwealth Games come to Birmingham in 2022, cricket will be there. women's cricket as well. And again, there will be more women representing England probably than ever before, and probably more so. So women's cricket is really important. It's come on leaps and bounds. More women are getting involved in more sports and leading the way and setting a good example right across the sports, from cycling through to cricket, through to football, and women do extremely well. So it's extremely pleasing to see the Portsmouth Cricket Club and the tennis club and so on making more facilities for women, which should have been there in the first place, I guess, but things are rapidly evolving, which I'm very pleased about. As to the colour white, well, Lord is white as well, Councillor Atkins. That's the home of cricket in the world, I think. So it's white, so I'm happy for this to be white. It will be all white. I'm sure it will be fine. So, yeah, a lovely application to finish the day on, eh?
Thank you very much, Councillor Hunt. Councillor Luke Stubb, please. You were next.
Yeah, I'm only going to say a few words. I mean, it is, obviously, we've got improved facilities, we've got an improved design, no public objections. It is a no-brainer. I certainly will support it.
Thank you very much. Councillor Lynn Stagg.
Yes, I totally support. I think we need to support as many local clubs as possible, and particularly following COVID, because I think so many people have missed out on sport and exercise, and if we can encourage more people to take it up by encouraging the clubs or supporting the clubs, I think this is an excellent idea. Totally support.
Thank you very much. I think it's going to be a good one, this one, to finish up with. Just for myself, I mean, I remember when I went there as former Lord Mayor of Portsmouth 2016, and they looked after me. It's a fantastic place. I personally don't like cricket that much, but I mean, I thoroughly enjoyed myself, and I'd certainly go again. So, and they're very, very good people down there. So thank you for what they're doing for the community as well. And yeah, I think they do a great job. So you've got my support anyway. Anybody else want to have any comments before we go over to the voting on this one, which I think will be very easy? Okay then, so Kieran, so this is, we're voting for permission, is that correct? Proposal by Councillor Terry Norton and seconded by Councillor Matt Atkins.
Yes, Councillor, so that's a motion to grant planning permission in accordance with the officer's recommendation.
Thank you, that's what we're voting for then, members.
Can I just jump in, sorry?
Yes.
Just to say, with the amended condition 3 from the supplementary matters.
With the amended supplementary, yes.
Yeah.
Is that okay, Kieran?
Thank you very much for jumping in there, Rebecca. Yeah, so yeah, there is, you're asked to grant planning permission in accordance with the officer's report and the supplementary matters report that's been related to you today and the conditions therein.
Thank you very much, Kieran. So I'll call upon Councillor Judith Smythe. Please indicate if you're for or against that motion, or do you wish to abstain?
For, Chair. Thank you.
Thank you. Councillor Matthew Atkins, please indicate if you're for or against the motion, or do you wish to abstain?
For, Chair.
Thank you very much. Councillor Lee Hunt, please indicate if you're for or against the motion, or do you wish to abstain? Councillor Terry Norton, please indicate if you're for or against the motion, or do you wish to abstain?
I'm for.
Councillor Lynn Stagg, please indicate if you're for or against the motion, or do you wish to abstain?
For.
Councillor Luke Stubbs, please indicate if you're for or against the motion, or do you wish to abstain?
For.
Councillor Claire Udy, please indicate if you're for or against the motion, or do you wish to abstain?
I'm for the motion.
Thank you very much. And my vote is a unanimous for it. I think it's brilliant. It's for. So I think I'll take it that is a full set of fours.
Yes. Yeah, 8 to a 4. Yeah.
Yes, thank you very much. Well, members, officers, I think that concludes our meeting. It's been a long one. We do have another one, you'll all be pleased to know, members, so we can't get out of it yet for this year. So we look forward to seeing you in April. I'd like to thank Kieran and all the officers for looking after us today. Thank you to all the councillors here today. I'm sorry it's been a long one, but thank you very much. And please, now all go home and have a nice cup of tea or something. So thank you all, and thank you to the members of the public as well. So take care, everybody. God bless, and see you very soon. Bye-bye.
Thank you. Bye-bye.
I'll end the recording, but you're still all full for a couple of minutes.
Bye-bye.
Yes, thank you.